statements. This one, page number 1 to 4. Page 2. Number 5. Page 3. Number 6 and 7. Page 6. Number 8 and 8 to 10. Page 7.
We couldn't get it. Memo reporting death of respondent number 3A. Amendment? No, somebody is dead it since. Respondent number 3A. Who has reported? Who has filed this memo? 8.2. Okay. Do you want adjournment to this? We have engaged. This one. When do you want it? That time also you saw 2 weeks time. Now again you are seeking 2 weeks time. Adjourn at the request of appellant's counsel. Yes.
Page 7. Till number 11 to 14. The adjournments. Page spoken to number 1. B promote.
What is the error in that? Right? Right. No. If appeal is not allowed, the trial court decree will continue. What they represent here? See, you were for the respondent, they were for the appellant.
You read the next paragraph.
Suit is decreed in terms of the compromise petition and the suit was dismissed. See, suit was dismissed. Against that, they came in appeal. See, then the decree, whatever is passed by the trial court, remains. See, dismissal of the suit has to be set aside. Now, as per the compromise you have entered into, yeah, you are going to give some share to her. So we have said that. See, unless we allow the appeal, how the decree stands and see, we have not decreed the suit totally as spread before the trial court. Whatever compromise you have entered into, we have decreed the suit accordingly. Unless we set aside the trial court decree.
See, it was a suit was dismissed. Suit was dismissed. So that dismissal in entirety has to be set aside. Then after setting aside the dismissal, then we said that the compromise, in terms of the compromise, the suit is decreed. And then what kind of modification so far as dismissal is concerned? It is there.
Appeal is allowed. We are not finding any confusion in that. Appeal has to be allowed because the trial court decree has to be set aside. And the suit has to be decreed in terms of the compromise. Once the appeal is allowed, one second, once the appeal is allowed, we are relegated back to the position of the suit. No decree, nothing. Then we are decreeing the suit in terms of the compromise petition.
The suit is decreed in terms of compromise covers the whole thing. Therefore, the appeal is allowed.
Appeal is allowed ಅಂದ್ರೆ ಏನಾಗುತ್ತೆ ನಿಮ್ಗೆ ಮುಂದೆ we are not passed.
So you don't want the decree which has been passed, dismissal, that should not be set aside.
That should be modified.
What kind of modification in terms of dismissal?
As per the terms of the compromise.
Dismissal is there. Question doesn't arise.
ನಾಗಭೂಷಣ್ ಅವರೇ ಮುಂದೆ ಹೇಳಿದೇವಲ್ಲ ಸೂಟ್ ಇಸ್ ಡಿಕ್ರೀಡ್ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಅಂತ.
That covers the whole thing.
Correct.
Therefore,
Sorry, we do not find anything. Learned counsel for the respondent submits that the sentence in the order dated 9 in the operating portion of the order dated 9/8/2023 to the effect into inverted comma number. The appeal is allowed has to be deleted. The suit was against, the appeal was by the plaintiff against the dismissal of her suit for partition. Since the parties before this court entered into a compromise, unless the appeal is allowed and the dismissal of the suit is set aside, the compromise decree, compromise cannot be recorded, could not have been recorded, and further order could not have been passed. There are no grounds to modify the order in any way. Therefore, the order dated. The prayer for modification of the order is rejected. ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನು ಆಗಿಲ್ಲ. You are getting confused. ಅಪೀಲ್ ಅಲೋಡ್ ಅಂತ ಅಲ್ಲಿಗೆ ನಿಲ್ಸಿದ್ರೆ ಸರಿ. ಅಪೀಲ್ ಅಲೋಡ್ ಅಂದ್ರೂ ಕೂಡ ಸೂಟ್ ಹಾಗೇ ಇರುತ್ತೆ. Then we have said that suit is decreed in terms of compromise. We have not decreed the suit as prayed for before the trial court. Yes, next.
Number 2, K. Suryanarayan Rao.
I am for the appellant, not in this matter.
For awaiting service of notice of our court. Yes. 22/8 को issue ಆಗಿತ್ತು. 4/9 issue ಮಾಡಿ. We'll list it after some day because 20 ಇನ್ನು postal tracking ಏನು ಹಾಕಿಲ್ಲ ಅವರು. Registration register postal track ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಿ ಹಾಕಿ. Registration verify the status of service of notice on proposed respond number 4B and C and postal tracking list on
B and C and 6A.
4B and C ಅಷ್ಟೇ ಆಗಿದೆ ಅಲ್ವಾ?
6A and B.
ಫಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಆಗಿರೋದು legal representative respond number 6 of proposed 4B and C and the legal representatives of respond number 6.
6AB.
M. Arun Ponnappa.
Respond number 2 no Response number 2.
Yeah.
And TCRs are also received. This appeal is against rejection of claim 2007. So we are not asked them to prepare the paper books. Last time, correct. ಅದಕ್ಕೆ paper book during the year 2022 and 28/8/2022. If you file the application, they will list it. Right, file ಮಾಡಿ. Therefore, appeal against the responsibility is awaited. No? Side, right side. Updated ಅಂತ ಅವ್ರು ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಎಲ್ಲ ಆಗಿದೆ. 7/8/2023. Correct. List ನೋಡಿ, appeal list. Go and file it in the registry. But paper books. One date here, file ಮಾಡಿ ನಾನು abatement ಅದು ತೆಗೆದ್ಬಿಡು, because it's already recorded. 14. You should file the paper. Pleadings are required for both of us to see that.
Pleadings.
Pleadings ಬೇಕಲ್ಲ ಅದು. See, order 7, rule 11, we to consider that have to see the pleadings. Yes, paper books now last time not dispensed with. It was not dispensed with. It was only said it is against order 7, rule 11. Paper book will be very small for that. In the last time,
Very small, this thing will be there.
paper books will
Because
be very
ultimately
small.
seven.
Yes. 14th.
You file the application.
File ಮಾಡಿದ್ರೆ again
You file
notice has to
application,
go.
that has notice has to be issued, no? To LRs of R2.
No, the anxiety is only to see that it is postponed. Correct. ಹಾಗಿದ್ರೆ you file application. Go and file it in the registry and file the paper book. Paper book will also will not be very bulky. With plain written statement, IA objection. Yes. 14.
Anyone against number 4? Udita Ramesh? Vishnu Mishra?
People are dead there. A. Memo you have filed here now. In this you have filed memo. Revana Siddhappa is appellant number 1. But his LR is already on record. So this memo is redundant. This was filed on 31/8. The counsel for the appellant submits that memo dated 31/8/2023 reporting death of appellant number 1A. So again 1A also died. ಅದನ್ನ ಅಲ್ಲಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕಾಗುತ್ತಲ್ಲ, she died ಅಂತ appeal in appeal memo you have to endorse that she is dead and P to D are her LRC. That you have to endorse in the appeal waiver. Probably that's why we are directed to do that, it seems. Right. See, appellant number 1 died. His LRC had brought on record. Now we are reporting the death of appellant number 1A. About her heirs, you have to tell us. You have to report that. ಅದನ್ನ ಹೇಳಿದಿರಲ್ಲ, ರಿಡಂಡೆಂಟ್ ಅಂತ ಯಾಕೆ ಹೇಳ್ತೀರಾ? ಮತ್ತೆ ಇನ್ನೂ ಒಂದು ಹಾಕಿದೀರಾ, which is the other 31 August 2023, which is the other memo, even have you file? ಅದು ಒಂದೇನಾ? ರೇವಣ ಸಿದ್ದಪ್ಪ ಇಲ್ಲ ರೀ, ಅಪೆಲೆಂಟ್ ನಂಬರ್ 1A ಅಂತಾನೆ ಬರ್ದಿದ್ದೀರಾ ಅದ್ರಲ್ಲಿ. ಕಸ್ಟಮ್ ಮನೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ, ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ. ಇನ್ನೊಂದು ಯಾವ್ದೋ ಅರ್ಲಿಯರ್ ಮೆಮೊ, ಇನ್ನೊಂದು ಯಾವ್ದದು, ಇನ್ನೊಂದು 31st August ಆಲ್ರೆಡಿ ಲೀವ್ ಇಟ್ ಕರೆಕ್ಟ್. ಇನ್ನೊಂದು ಮೆಮೊ ಹಾಕಿದೀವಿ ಅಂತಿರಲ್ಲ, ಅದೇ 30th August. ನಮ್ಮ ಹತ್ರ ಯಾವ್ದು ಇಲ್ಲ, ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ ಇದ್ರೆ ತೋರಿಸಿ ನೋಡೋಣ. Under the memo dated the memo anta beda, the memo dated 31/8/2023 reporting the death of appellant number 1A. Along the death certificate is taken on record. As per the memo, appellant number 1A is survived by appellant number 1B, B to D and 2 to 4. The appellant's counsel shall amend the constitution of the appeal memo accordingly and furnish the amended appeal memo. ಇದರಲ್ಲಿ ಇಷ್ಟೇ ಅಲ್ವಾ ಇರೋದು? We are not finding another memo ಎಲ್ಲಿದೆ ಅಂತ ನಮಗೆ ಅದ್ರಲ್ಲಿ ಬೇರೆ ಮತ್ತೇನೋ ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲ ಇದೆ ಅಲ್ಲ. ವಾಟ್ ಇಸ್ ದಿಸ್ IA 1 of 2017 ಫಾರ್ ಪರ್ಮಿಷನ್ ಅಲಾಂಗ್ ವಿತ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್. ಸೊ ಅಷ್ಟು ಮಾಡಿದ್ರೆ ಫೈನಲ್ ಹಿಯರಿಂಗಿಗೆ ಲಿಸ್ಟ್ ಆಗುತ್ತಾ? ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಮೆಮೊ ಫಾರ್ ರಿಪೋರ್ಟಿಂಗ್ ಡೆತ್ ಆಫ್ R5A ಸೇಮ್ ಪಾರ್ಟ್. 4.1 memo dated 31/8/2023 filed by the counsel for response 5B to D reporting death of respond number 5A is taken on record. It is admitted that respondents 5B to D and 6 to 8 are the surviving heirs of respondent number 5A. 6 to 8 ಅಲ್ವಾ? ಮತ್ತೆ ನೀವು ನಿಮ್ಮ ಅಪೀಲ್ ಮೆಮೊದಲ್ಲೂ ಹಾಗೆ ಹೇಳಿದಿರಲ್ಲ. No, in your memo you have said the other parties there are surviving.
Sentence, last but one sentence.
ನಿಮ್ಮದ್ರಲ್ಲಿ ಓದಿ ಮೊದಲು. Please read in your memo. In the first matter. ಎಷ್ಟು ಕನ್ಫ್ಯೂಷನ್ ಮಾಡ್ಕೊಂಡು ನಿಮ್ದು ನಮ್ದು ಎಲ್ಲರದು ಟೈಮ್. ಬಿ ಕೂಲ್, ರಿಲ್ಯಾಕ್ಸ್. B to D and 6 to 8 are the surviving heirs of respondent number 5A. The memo is taken on record and handed in. The appellant's counsel shall amend the constitution of the appeal memo and furnish the copy of the amended appeal memo accordingly. List for final hearing on 12. Synopsis.
Synopsis. Respondent.
Is not written that the nodal have been nodal. Item number 1 is part number 2. Item number 1 is part 2. The order set by the contractor. Page number first page the deposit of page number became marked. Page number 44. And you think again, then my admitted para one, page number 44. Yes, so 1 90, 97, 98, 97. I think it's a kind.
Yes.
But in para one, it is technical director of creative company. I'm aware of the RCS scheme introduced by the Court of Karnataka 1991. The implementation of the said RCS scheme for housing was resulted in the Third Housing Board. The scheme was about providing housing to sections of the society. The scheme covers the entire state of Karnataka, mainly in rural area. The purpose of the scheme, the Karnataka Housing Board called them for tender for construction of houses for the poor people. Creative company also submitted tenders to creative company was awarded with the contract for the scheme in Belgaum and Dharwad district. The creative company was given contract for land transmission in Belgaum district and several transmission in Dharwad district. After the acceptance of tender, formal contract was reduced in writing and executed. But come next madam, the creative company was awarded with the contract to construct 10,281 houses. So land transmission 88,079 houses in 7 Dharwad district. In contact with concerned executive engineer of the Karnataka Housing Board was required to hand over the site to the demarcation of the houses. But this evidence is this evidence. And can you see my next page number 72. Page number 72 the evidence of the DW1 that SK Mathur, one of the my in cases. DW1 page number 72. Page 72 para 11. But para 11, we have completed the construction of 60 houses. Among the size portion of the which was delivered by the board. It is far to say that there was entry made in 77. No? The construction of 60 houses was not fully completed. Exhibit 77 was prepared by us, except Exhibit 77, there is no other document to show that the construction of 60 houses was completed. But this the construction of construction houses, the government has fixed 15,000 one RCS scheme houses and 16,000 one houses. But 16,000, 15,000 considered only the complaint the contractor entered only 9 lakh compensation, not more than that. After 16,000 considered 9 lakh 60,000. But this evidence entire CTA, what is led by the witnesses of the creative where the contractor That not at all considered by the every this evidence is overlooked by the transaction. No matter only on the base part the entire 15 crore in one scheme and 12 crore in one scheme. Rava and Dragon. On that scheme, 50,000 equals interest on granted to damages 4 crore 61 lakh and 38,000 38. But this only evidence is considered would have given only 9 lakh or 10 lakhs by the time court. The contact number the even one chartered accountant examined as PW4, but he also stated that one in the same evidence matter. He stated that the court man even the contact can create the vouchers for vouchers ಅಂತ ಅವರು ಹೆಚ್ಚು ಮಾಡ್ತಾರೆ ಯಾರು chartered accountant ಮಾಡಿದೆ ಪೇಜ್ ನಂಬರ್ 84 ಮಾಡಿದೆ chartered accountant ಎನ್ ಶ್ರೀನಿವಾಸ. But in para 3, 84 DW2, Srinivasa, chartered accountant of the contractor. But in para 3 then, in 1993, page 85, in 85, para 3. Since 1993, I have been the auditor of the second respondent. It is true that second respondent is only perfect company. I set off to exhibit 107-110 was we are submitted by second respondent to the income tax department and another set register company. So it is true that audit work was done by me on basis of the account service by the second respondent. I have prepared a 107-110 on the basis of the accounts and supporting documents like bills, vouchers, bank statements, etc. Vouchers are prepared by the company in respect of expenditure, incurred and purchase made. Bills are the documents given to the second dependent by others. Few of the vouchers are supported by bills in respect of payment made to the external agency. In respect of some vouchers, evidence for the expenditure were not available. In respect of some vouchers, no evidence or supporting document will be available to show that expenditure. Generally, vouchers in respect of miscellaneous expenses towards conveyance etc. are not supported by other documents. It is false to say that auditors will not consider correctness of the authenticating bills in vouchers. It is true that we do not look into the correctness of the vouchers and bills can be created. So this is the chartered accountant chief examination. But this whole amount not the transportation granted in the compensation of all the 4 lakhs for on this whole and the entire scheme amount. But that is your entire amount not deposited by the not invested by the contractor in this suit are not created anywhere, not created in the plane or evidence, nothing is created that entire amount is invested. But try for assuming that the amount only on the basis of amount the 50% imposed on interest to then granted 4 crore 2 lakhs. But 60 nevertheless everyone is not 60 houses only. But one Supreme Court 1991 2001 Supreme Court. What is the Supreme Court that what is the construction by the contractor? Only that amount should be given not by the excess amount. Yeah, that by the Supreme Court 92 Supreme Court. ಅದಕ್ಕೂ ಕಾಪಟಿ ರಿಪೋರ್ಟ್ ಗೆ ರಿಪೋರ್ಟ್ ಇದೆ ನಾನು ತೋರಿಸ್ತೀನಿ ಏನು but this only this ಮಾಡಿ evidence consider ಮಾಡಿ this matter is required for demand for consideration press matter again press this is judgment entire judgment ಮಾಡಿ one sided but the price is committed error in granting this heavy amount this is prejudiced to the appellate court. But I have read the evidence only consider my duty engineering evidence 1 to 4. But these 1 to 4 is the PM1, PM2 of the contact is evidence. So now it has considered referred in the judgment. Suppose it is not in the order is perverse order, not sustainable in law. This requires not remanding matter time out to set aside and remand matter for press consideration. But one of the resolution, one judgment of legal weight as for currently the judgment of the legal weight product. Mother than set the 2014 again the argument is made by not the judgments are argued by the bundle is given of list.
Both of you have given two absent.
Fact. And the details not the reference to even of the existing business. Direction of path and something.
The rest of the documents.
Like, okay.
Page number 6.
Which judgment?
Page number 6 not. Page number 6. Now the division is the setup back. 2003 not KCHR 2304 division 2304. And Malaprabha cooperative was pinning related to Belgaum ultimate private limited. But the civil procedure code section 20 contact act 1872 section 42 and 43 agreement to construct building. The tender was called for at Saudati. Tender submitted at Saudati. Contact accepted at Saudati. Only some correspondence made from bank office at Bengaluru. That issue or recovery of money due to under the contract has to be filed before the court at Saurati, not at Bengaluru. This is the details not following our earlier judgment of this court matter in para 7. The issue was raised by this court matter in para 6. Then finally is given para 7. Ultimately, my appeal is allowed and order is set aside. And the territorial jurisdiction, the same set of facts. In this case also, the tender is given at Belgaum, Dharwad, and work order issued Belgaum, Dharwad, and construction also be constructed at where the place situated Belgaum and Dharwad, 7 constituencies, 9 constituencies. There is no call of at Bengaluru.
Yeah, argued already last time. So no repetition.
Yes. But therefore, to begin the number 9 is to Supreme Court cases 315. And this is the threshold jurisdiction. Page number 26 not the judgment of page number 26 2011 Supreme Court matter 2979. Total is number 27. I don't need The contract section 73 damages. Government contract, works contract with the private party for those who work was to be executed into the section. Second piece of contract never executed by a private contractor that applied by the state government showing that the estimated cost of work had been recovered by contractor. Relief claimed by the contractor was beautiful profit without carrying out the obligation to execute work just on technical relief. Contract who had not complied with the terms of contract cannot claim damages in respect of work not completed by him. 35-36.
This
And in respect of non-considered reverse there are 2-3 limits. I mean, bank guarantee not the interest dispute is not bank guarantee. Bank is not categorically admitted in the agreement that when I demand, but the board of the bank has to refund the amount. But this bank only the bank all match two type of only on that breach of contract. But breach of contract is also now as read the para 7 of my voice suit not the suit was filed. Sorry, it was filed. If the bill filed, suit filed from 92 to 95, 3 years. Only try only see courts, the other two courts only surrounding courts. But where he consulted only admitted that 60 houses is not completed. Even assuming yeah, evidence not 60 houses even not completed as admitted in class. Because the 2017 to Supreme Court the non-consideration of evidence.
which page? Yes, madam, which page or paragraph?
I'm not. Head note no game para 13, 14, 15. Head note A can A. But section 96 head note game.
Yes.
Procedural code 1908 head note section 96 Art 41 to 31 and Art 20 to 5. Judgment in judgment in first appeal. Powers and duties of the first appeal court created is the final court of action. Hence, the judgment must reflect application of mind in this judgment. First appeal court must take points for determination, decision thereon, and reasons for decision. However, mere omission of frame point number determination does not vitiate judgment for first appeal court, providing their appeal court its reasons based on evidence adduced by both parties. The court regards reasons based on evidence adduced by both parties. In the present case, first appeal court or high court, this is neither framed point for determination nor discussed evidence adduced by the defendant. In this court, in the judgment, this case, the evidence is not considered. then Supreme Court decided that appeal order, decided order for consideration of entire evidence produced by both parties. That is paragraph 113. Then 96 Supreme Court. And respect of bank guarantee order, bank guarantee.
Yes.
The 96 Supreme Court order 2367. The state of Maharashtra and affiliated National Construction Company. But in this case, only bank guarantee, without bank guarantee. And this is the admitted fact by the bank Maharashtra before the time court, no fraud is alleged in denying the bank guarantee. And this para 14 order. Article 14 order. And the seems necessary to unless the law gives the guarantee. The rule is well established that bank issuing a guarantee is not concerned with the underlying contract between the parties to the contract.
Yes.
Contract. The duty of the bank under the performance guarantee is created by the document itself. Once the documents are in order, the bank giving the guarantee must honor the same and make payment. Ordinarily, unless there is an allegation of fraud or right, a court will not interfere directly or indirectly to withhold payment. Otherwise, trust in commerce, internal and international, would be irreparably damaged. But that does not mean that the parties to the underlying contract cannot settle their dispute with respect to allegations of breach by resorting to litigation or arbitration as stipulated in the contract. The remedy arising contentious is barred and the cause working from same independent and enforceable for the guarantee. Ultimately, the appeal is allowed and the order is set aside.
Yes. Yes.
We can involve the trial court and the entire evidence is not one. And then jurisdiction that is backed by parties that being not the consultant was given at Harvard and Braga. And there is no agreement executed at Bangalore. But he has also committed breach. Only finding given by that housing board is committed breach, and that some document then some sites are not given. Admittedly, 1,155 sites and 206 sites given, but the exhibit D1 to D6 not considered R6 to 9. What is the effect of document? That is not exhibit only unilateral cancellation the application of trial court. But the exhibit notice issued by admitted by the contractor before the trial court. But the exhibit D1 to D6 not considered by the trial court at all. But finding it unilateral cancellation. but the notice issued by the board is admitted by the contractor before they are quoting evidence. But whole evidence is not at all considered or being appreciated by the trial judge. Not this order is perverse order, not sustainable in law. So for my submission that my entire appeal is but ಇನ್ನೊಂದು submission ಇಲ್ಲಿ ಇಂಟ್ರಿ ಮಾಡಾರ 3/3/9 but they say intri ಮಾಡಾರ ಈ order and he contractor filed application for withdrawing the amount. But this court directed the contractor if the appeal is allowed refund the amount with 12% interest. But against that order not contractor filed essentially to Supreme Court. Supreme Court the modified order only granting instead of 12%. By 6% 425 lakhs and withdrawn subject to furnishing bank guarantee before the subregistrar.
How much?
But 2 crore 25 lakhs.
2.25 crores.
Crores, but 25% of the decree amount. 461 lakhs and odd. But that has to be directed to the contractor to refund the amount with 6% interest. But as my son referred the judgment of Supreme Court. What is the serial number? What is the date? Abu Sinatra mentioned my son also.
Take all the previous judgments also, make a different compilation.
Yes. Yes.
That's all? Yes, the response counsel.
First respond that dealing with 5.1 and 5.2.
You appear for the bank.
Right.
5.1 and 5.2. Yes, sir. 12.50.
Responded to the meaning of the process. If in the original civil suit as well. And I was beginning with a brief description of the matter and the party because there is multiple appeal. And we have filed a brief synopsis on behalf of the respondent on 6th of July 2020. There's two documents filed on that. One is the brief synopsis, and the other one is the contentions and remarks of the respondent, the reference to documents and evidence relied upon. So those two documents may not be the two things I'll be using on. In the very first page of the synopsis, we've set out with respect to each case number, what is the position of the parties. And that now should hopefully give some clarity to the position we take. And before we move into the actual merits, I mean, very quickly set out what the background of the case is, what has happened, and why is it that we are this particular project, which was commissioned by the appellant, the Karnataka housing, it's under the Ashrayas. Now, under the Ashrayas scheme, what they wanted to provide housing to low-income groups across the state. Now, multiple such projects were given, multiple such contracts were awarded. The two contracts that are relevant to us, which are before us, or the two districts which are before us, is Dharwad and Belgaum. Now, even within Dharwad and Belgaum, there were multiple work orders that were issued, all of which are identical. take my words for that. But essentially, the case was that in each of these districts, somewhere in the region of 10,000 houses, and I want to emphasize that point. We are talking of about 10,000 houses being constructed across a spectrum of more than 100 square kilometers of land. And that really is the extent of the project that we're talking about. Now, in these projects, the idea was that they will give us the project, they will give us the land. Once we get the land, we have approximately 6 months to complete construction of the house, and that's broadly what the scheme was. A tender was closed with the successful bidder in that case. We started constructing the houses where lands were given, but the problem was when the contract was awarded, we were supposed to have been given the land. They did not give us the land. In fact, even until the end of the project, more than 10,000 houses that had been constructed, hardly about 1,000 across the two projects, lands were given. And that now that take us through a little bit of detail, I just want to give some context and set something. The places where the land were given, we undertook construction. We did a lot of preparatory work. We did a lot of, we invested a lot of money in constructing factories, in getting contracts with the various vendors, etc. And we started constructing the houses, and we were making good progress. And I can take my words from the exact. While we were in the middle of the project, they terminated. We had 6 months to complete the project. Even before the expiry of the 6 months, they terminated the project. And why? That becomes apparent. I take my notes to the end. They terminated the project because within a few days of the termination of the project, they gave it to some other contractor without intent. That really is the bird's eye view of what this matter is. And I wanted to set that out before going into the specific fact, because that help us anchor most of the arguments that we make. Now, coming to some of the specific. Now, when we're talking about this contract, there are two projects that I was talking about. One is Belgaum and one is Dharwad. Now, there are 7 separate identical work orders with respect to Dharwad, and there is a common work order with respect to Belgaum. So, totally there are 8 contracts, but all of them are identical. So, we have not gone into identifying specifically, we did not, as part of the paperwork, given every single one of them, we only identified the broad level contracts that are there. Now, if I may request us to start there with the contracts itself at exhibit P6 to P21 in the paper book, page 8, paper book volume 2. This contract, there is a few aspects that I want to take us through. This is one of the examples of the agreement. You see, the name of the work is tender for the construction of RPRP EWS houses in both urban and rural areas.
Where are you reading?
Page number 8, P6 paper.
Yes, got it. Page.
What? This one is a work order for constituency Ramdurga. Total number of houses in that particular constituency is 1,147. Now, the cost of work as per the estimate is rural 15,000. So, per house it was 15,000, and the total cost of construction was 1.73 crores across the 1,147 houses. Amount of contract is that the agency was Navikas Builders, which is the respondent who I represent. The authority that set out, approving of the tender is done. Next page number. The period of construction, and this is where something important will start coming. 6 months excluding monsoon. Entered into between Navikas Builders, contractor Karnataka, I being Navikas Builders, who thereby undertake to execute such work as enumerated and described in schedule P appended. Such work of construction of houses in rural areas under the Ashraya scheme in Karnataka, subject to the conditions specified in the clause of the enclosed agreement and having both the agreement. I will also agree to complete the work and hand over the same in a satisfactory workmanlike manner within 9 months, including monsoons. Period from the date of the work order. So you will see that there is 6 months excluding monsoon, 9 months including monsoon. So the 3 months of the monsoon period, they provided some concession. Then at the very next page, we come to the actual terms and conditions of the contract. I mean, there is a lot of clauses. I only take my work through the most important ones. You can see. The rates are all works proposal to be executed by contractor will be notified in the form of invitation to tender, put up on the notice board of concerned offices. It can also be published in the Gazette or newspapers wherever required. Now, ordinarily, I may not have read this clause as being important because there is some question regarding jurisdiction that my learning friend and I've come to these aspects here. That the work proposal were to be put up on the notice board of the concerned offices and published in the Gazette or newspapers wherever required. And the place of putting up of these books, place of publication, etc. I'll come to that in just a moment when we go to the evidence. The form will say the work to be carried out rather than the date of submitting in tenders and the time allowed to carry out the work, also the amount of money deposits to the work. Every contractor who intends to transfer the work advertised by the Karnataka Housing Board will already be a registered contractor. Authorized copy of specifications, designs, and drawings and schedule of fees and any relevant documents required in connection with work shall be open for inspection by Karnataka Housing Board authorities. So the Karnataka Housing Board authorities have maintained these documents. In the event of a tender being submitted by a firm, it must be signed separately by each partner. So the receipt of payment made on account work and executed should also be signed by the partner. That is the basic outline of what the tender condition. Now, at the next page, page 12, is when the details start coming. First, I will read clause number 11. Time allowed for the work from the date of work order to the contractor is 6 months, excluding the period of rainy season from 15th June to 15th September. Now, we saw in the first page that it was 6 months excluding monsoon, 9 months including. This adds further clarity. Monsoon means from 15th June to 15th September. Thereafter, the next few clauses are not very important. Then we come to the conditions of the contract at page number 14. Like in any typical construction contract, they have some advance deposit, earnest money deposit, bank guarantees, etc. But the key portions for us will start from, because the name regarding bank guarantee, I read AC 1C, which is the last paragraph in 5. When the further EMD deducted from the bills exceeds rupees 1 lakh, the amount in excess of 1 lakh may at the request of the contractor be released to commence the production of bank guarantee for the equivalent amount of the credit. This bank guarantee is not the bank guarantee which is subject to our theory. So I just want to say that there are mentions of bank guarantee because these are not the same. There are bank guarantees that were given in advance of the works. There were bank guarantees that had to be given during the course of work. This talks about the bank guarantee given in the course of work. That particular bank guarantee is not used. So I just want to make that clear. Now we talk about page 15. What does the contract say? Written order to commence work at the end of that page. Clause 2A. After acceptance of the tender, the executive engineer shall issue a written order to the successful tender to commence the work. The contractor shall enter upon or commence any portion of work only with the written authority instructions to the executive. Without such instructions, the contractor shall have no claim to demand the measurement of the payment of the work on time. And this again becomes important because by the court there is the date of signing of the work order. When does work actually commence? When does the time period actually commence? It is the written order to commence work. So until the written order to commence work, I am not entitled to payment, so there is no reason for me to actually do the work. Then program of work. The time allowed for carrying out the work as entered in the tender shall be strictly observed by the contractor. It shall be reckoned, and this is the most important part, it shall be reckoned from the day of handing over to the contractor the work site area either in full or in parts. So when we talk about the 6 month period, when does it start is what this particular clause says. It says it shall be reckoned from the day on which the handover of the work site happens, either whether in full or in part. Then, the next clause, the next page please. The work shall throughout the stipulated period of the contract be proceeded with a amount due diligence, timely being the essence of the contract and part of the contractor. To ensure good progress during the execution of work, the contractor shall be found in all cases in which the time allowed for any work exceeds 1 month to comply the time schedule according to the program for execution of work as agreed upon and enclosed in the contract. In the absence of the prescribed program, the contractor shall be bound to complete up to roof level of the work in 40% of the time. Completion of the work is 60%. The balance and handing over of the building to the concerned BDO to accept the contract after taking into consideration the circumstances of each case, and the contractor shall abide by the program of detailed progress done by the officer. Next, this again is an important review of progress and responsibility for delay. The progress of all works shall be reviewed by the executive engineer with the contractor during the first fortnight of every month. So the duty of the appellant is executive engineer to review the progress of the work in the first fortnight of every month. Such review shall take into account the program fixed to the previous fortnight. So the point is that every 15 days you're constantly keeping a work. Who's doing things, who's responsible for delay, are we sitting against you? That kind of progress report was supposed to be prepared. Next, apportionment of responsibility for delay between contractor and court. In case the progress achieved falls short by more than 25% of the cumulative program, the reason for that shortfall shall be examined and the record made thereof, apportioning the responsibilities for the delay between the contractor and the board. The record shall be signed in full and dated by both the executive engineer and the contractor. Again, please see the intent of the contract. They don't want disputes to become escalated, to the very end. Every 15 days, they say, please tell me, are we sleeping up? What is the program saying? How much have we? For that, if there is a slip up, who is responsible? Both of you sit together, make a measurement, find a joint report, identify you are responsible, you are responsible. That is the intention of the contract. Next, shortfall in progress made up subsequent. To the extent the shortfall is assessed as due to the delay on part of the contractor, a notice shall be issued to him by the executive engineer to make up the shortfall in the succeeding week. If the shortfall is not made up before the progress of the work is reviewed during the second month, succeeding the month in which the shortfall is observed, the contractor shall be liable to pay penalty as indicated in clause B below. So what does it say? It goes further. First you identify the delay. Who's responsible? After you identify, you tell him, okay, listen, you are responsible for delay. Within the next 1 week, you have to make up for this delay. If you don't make up for this delay, I will impose penalties. That is the sequence in which it occurs. Beyond of extension, right? No extension of time is normally allowed. In case of any exigency deemed fit by the executive engineer of the concerned Karnataka Housing Board, the concern will obtain the extension of time from the Housing Commission of Karnataka Housing Board to the executive engineer case, provided the contract applies for the same within 1 week from the date shortfall is noted. Here again, there is an extension of time that's been granted, that's not denied, but the only thing I want to highlight in this paragraph is that the extension of time is obtained from the Housing Commission of Karnataka Housing Board. Housing Commissioner sits in Bangalore. Just to say that even the performance of this contract required a lot of activities to be done. Review of progress by chief engineer. The chief engineer shall review the progress once in every 2 months. So, every 15 days you are reviewing ongoing. Then it escalates. The chief engineer should review the progress once every 2 months. These reviews are in addition to the monthly review required to be done by the executive engineer. The results of the review by the higher authority shall, wherever necessary, be incorporated in the next review by the executive engineer. Next, settlement of disputes regarding shortfall. In case of a dispute between the executive engineer and the contractor regarding the responsibility of shortfall in progress, the matter shall be referred to the decision of the chief engineer, who shall be final and binding on the contract. The executive engineer. The language again is more on an ongoing basis. We mark it. No, our contractor, you are responsible for delay. I will say no, you executive engineer. On the ongoing basis, project in disputes, but chief engineer, his decision is final and binding so far as during the performance of the works is concerned. Next, penalty for delay. In respect of the shortfall in progress, process due to the delay on part of the contractor as per clause 2B and 2C, the contractor shall be liable to pay as penalty an amount equal to 1% of the estimated cost of the balance work assessed according to the program for every day that the quantity of work remains incomplete, provided always that the total amount of penalty to be paid under the provision of this clause shall not exceed 7.5% of the estimated cost of the entire work as shown in the tender. Provided further, as an event, the contractor making up the shortfall in progress and stated by extent time of completion, the penalty to be recovered may be refunded on an application in writing by the contractor. This again talks about what happens in case there is a delay, there is a penalty, and this talks about how much is the penalty. Per day, it is 1% of the estimated cost of the balance work. So what is the sequence of events? If there is a shortfall, I will say you are responsible. If you dispute that, you go to the chief engineer. Finally, someone is found responsible. If you are found responsible, I impose a penalty. If I impose a penalty up to 7.5%, I can keep imposing penalty and I give you time to make up for that shortfall. That is how the contract in this article performance works. If the executive engineer considers it necessary, he should be entitled to take action indicated in 3D also. Now, 3D is something that will come to a bit, but that is only after all of these mechanisms have been resolved. Adjustment of excess or overpayment. Excess or overpayment action as I discovered to be adjusted in the next week. This is not very relevant for us. Action when more PMT is overpayment is not particularly relevant for us. Then go to page 18 and 19 of I'll just say clause 3 and clause 3A at page 18 and 19. Talks about the contract awarded to the contractor, which is capable of being cancelled if the cumulative penalty equals the earnest money deposit. So, if you will see at clause 3, page 18 and the last page will be more there. In any case in which under any clause or clauses of this contract, the contractor shall have rendered himself liable to pay compensation and/or penalty amounting to the whole of this earnest money deposit, the executive engineer on behalf of the Karnataka Housing Board shall have the power to adopt any of the following recourses as may be best suited in the interest of the Karnataka Housing Board. Next page, for feature of EMP, without prejudice to the board, right to recover any loss from the contractor under subclause B and C of clause B of the contract to resign the contract, of which rescission notice and writing to the contractor under the hand of the executive engineer shall be conclusive evidence. And in that case, the EMP of the contractor, including whole or part of the lump sum deposit is time, shall stand forfeited and be absolutely at the disposal of the court. So, what does it say? One blow, you delay another penalty and then held penalty each amount of it says in case where the compensation or penalty amounting to the whole of the EMP is payable. So here now that you need to say if you I keep imposing penalty, I can impose penalty up to 7.5%. But the minute the amount of penalty is equivalent to the earnest money deposit amount, what rights do I have as the contractor, which is the appellant? Resign the contract, terminate the contract. So the right of termination only comes in if the compensation that I have to pay, the penalty that I have to pay is equivalent to the earnest money deposit. So that is the scheme of the act. It provides for a periodic review, it provides for penalty, it says once the penalty exceeds the EMP value, only then, and this is at page 19, first 2 lines, without prejudice to the board of right to recover any losses from the contractor under clauses of the contract to resign the contract. The right of rescission only comes when these clauses have been met. This factual background matters that we need to assess whether the plaintiff, now the respondent's prosecutor, are entitled to money, whether the appellant is entitled to resign or terminate the contract. In particular, we need to see if the steps prescribed in the contract have been complied. With that background, I'll come to the actual facts of the matter. Now, when the contract was awarded, and there is no dispute that I was a successful tender, so I'm not going to trouble this one to report to that. I will go only to the actual works. At the very outset, what is the scope of work that I was doing? At page 20, if my log is kindly see the very next page. Exhibit P25. We have highlighted in my you will see with the line the extent of land across which the projects were to be completed. Now, the work area was spread out over a period of over 145 kilometers by 62 kilometers in Belgaum and 107 kilometers by 85 kilometers in Bharwad district. So, totally, it is hundreds of square kilometers over which I am supposed to be doing this construction. And you will see in respect of Belgaum, there were 10,251 houses. With respect to Bharwad, there were 8,079 houses. In Belgaum, there were 9 constituencies. In Harvard, there were 7 constituencies. So totally, 18,000 children money now Sumar, thousands of square kilometers worth of land is what I had to work on. So the idea of this and contract was important was because of the extent of land. This is we will have to go back in time. This is 90 to 90. 90 to 90, all the development. So this was entirely so far as housing is concerned. Ali factory Ali brick manufacturers Ali concrete the infrastructure was not there. This is 30 years ago. Because of that, it was important for us to be given all the lands in one. That's why economies of scale happen. So I'm factory factory in bricks not there, concrete not there. I need to be able to service now. The investment is documented. And that is the background. If we enter, we got as soon as the contract is entered, they will give us all the land. I said give us 18,000 houses concerned. But unfortunately, that wasn't. Now, because there is a lot of work that has to be done, because it is an extremely complex project, even before the contract was ordered, we were asked to commence.
Work sites were identified. Work sites were identified.
In fact, mark out orders and take us to the evidence. Mark out orders on hardly anything here. Mark out or exactly mark out orders are not here.
They used to acquire certain lands for this scheme and deliver those lands.
Indeed, madam. But even within those lands, they had to identify exactly what amount was given. That was not done. And I take my word from the evidence, including by their own officers, as to whether mark out orders were issued. And our main grievance is that mark out orders were not given, sites were not. Because of the extent of this project, what was the instruction given to us? I think we should go back a few pages to page number 6.
So,
The same volume. See now, this is a letter dated 23rd of January 1992. On this day, work orders were not issued. Before issuance of work order, letter of intent, what does the housing board say? And please see now who is writing. Office of the Housing Commissioner, Karnataka Housing Board, Kaveri Bhavan, Bangalore. They write to me. With reference to your application cited under reference, the construction of houses under Ashaya Housing Program in Harvard, 7,000, district company 7,679 houses at an estimated cost of 11.5 crore, 3,000 per tenant infrastructure. The details are shown in the income statement. Therefore, you are requested to make all preliminary arrangements such as conducting the Reconnaissance survey of the area, taking over possession of the site from the chairman, task force committee, deputy commissioner, Tehsildar, begin to make necessary arrangements to start the work immediately after and receiving technical manual. Also, one model house is being constructed very close to the district and inspection of dignity, receipt of the data technically acknowledged. So they asked me if your agreement will be there, please make preliminary arrangements through marketing. They issue one letter. Pursuant to this, we took preparatory work. Now, what is the preparatory work that we took? You may kindly request you to look at pages 21 to 32, the same volume. This is a typed copy, my lords. Stamp paper, typed copy from visible. This is a long-term exclusive supply arrangement with concrete block manufacturer. Please see the date of this agreement. The date of this agreement is 1st day of July 1992. So July English, I already entered into an agreement with these suppliers. NBP are a construction company engaged in the business of civil construction. SD are a well-established manufacturer of cement concrete blocks in whereas and the fully active factory located at Kolkata. NBP has a requirement of taking concrete blocks for the housing project in Belgaum. This is SD as a position to supply the blocks and are willing to supply to NBP under an exclusive long-term arrangement. The exclusive long-term arrangement we entered into. This is exhibit P26. Page number 24. If another such exclusive agreement, this one with the HCP, Cosmetic Cement Products, and whereas recited same. established manufacturer of cement concrete blocks. And whereas the third website is special and exclusive long-term arrangement. Similar agreement at page number 28 with Amit Investments. The fact that I want to highlight is that these are exclusive long-term supply arrangements. So basically, what I've gone and I've told these concrete block manufacturers, not one to break out. In fact, go through the process of this contract. It says that AI, which is the company, will not supply blocks to anyone else. And if in case AI supplies blocks to another party in violation of this agreement, NBD will have the right to claim damages and compensation. So that is the kind of agreement that we entered into. So that we had sufficient capacity. Only even the order on Nange supply our we entered into exclusive arrangement. Next. At exhibit T30, page number 36. He also entered into an agreement with technical director Navika Builder. Purasabha Karyalaya Kacheri. You see Mukhtarikari Purasabha Karyalaya Haveli district. This is a letter for lease of land in Haveli from the Haveli Town Municipal Council for setting up concrete block manufacturing factory. ಮೇಲ್ಕಂಡಿಸಿದ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖ ನೀವು ಆಶ್ರಯ ಯೋಜನೆ ಅಡಿಯಲ್ಲಿ ಸಿಮೆಂಟ್ ಇಟ್ಟಂಗಿ ತಯಾರಿಸುವ ಬಗ್ಗೆ ಬಗೆಹರಿ ಕುರಿತು ಈ ಪುರಸಭೆಯಿಂದ ನಿವೇಶನ ಒದಗಿಸಬೇಕೆಂದು ಕೇಳಿಕೊಂಡಿದ್ದನು. ಉಲ್ಲೇಖ ನಂಬರ್ 2 ರ ದಿನಾಂಕ 17/7/92 ರಂದು ಜರುಗಿದ ಪುರಸಭೆ ಸರ್ವಸಾಧಾರಣ ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸಿ ತಮ್ಮ ಮಾಗಣಿಯಂತೆ ಸರ್ ನಂಬರ್ 327 ರಲ್ಲಿ ತತ್ಪೂರ್ವಕವಾಗಿ ಖುಲ್ಲಾ ನಿವೇಶನವನ್ನು 1 ವರ್ಷದ ಮಟ್ಟಿಗೆ ಲೀಸ್ ಆಧಾರದ ಮೇಲೆ ಪ್ರತಿ ತಿಂಗಳಿಗೆ ₹500 ಬಾಡಿಗೆಯಲ್ಲಿ ನಿಗದಿಪಡಿಸಿಕೊಳ್ಳಲಿಕ್ಕೆ ಮಂಜೂರು ನೀಡಿ ತರಾಯಿಸಿದ್ದು ಇರುತ್ತದೆ. So they have given me for 1 year lease at a certain rate of made these arrangements. Next. At page number 38. We have made arrangements for factories and long-term arrangement. I issued purchase orders at page number 38 on April 30th, 1992. We saw the previous agreement was in July. The actual contract was in March 1992. Because pending those long-term supply arrangements, delay after we issued purchase orders from ad hoc people also. So purchase order on 30th April 92. We referred to a performa invoice dated 20th March 92 and also product literature and other information submitted to the letter under reference dated 12th March. So even before the contract, I started issuing letters to them. We please to place this order for purchase of the following. Minato silicate concrete block, ram and mold solid blocks, concrete mixer, keeping narrow capacity. So this also I have done. Concrete block manufacturer I have entered into agreements. So 7 months. We both agree in that. Engineers and other technical and supportive staff have been recruited, and this is there in my evidence affidavit. Definitely multiple projects, multiple finance. Now, this is the amount of preparation that I took. So contract work immediately I was setting. So what then happened? I did not get this. So what did I do? I wrote at exhibit P41 page 46. Now the respondent wrote to the executive engineer at Harvard and Belgaum, updating them on the above preparation, and they are inspected and are fully aware of this preparation. So we take further to a recent discussion on the status of the work in Australia. I would like to inform you as follows. We have our office at the following address. It is set up, office set up firstly. Our engineer Chief Prakash Lakshman Rao available to the officers in this office for recruitment to our mandate. We have made arrangements for immediate supply of block with an engineer running block factory with casting yard, cooling tank, and villa premises division of Haveli. They can supply required precast from precast. We have offered to buy the entire existing stock and the production in coming months. We therefore have an immediate source of supply of block. Since the factory runs on no profit roll-off, we get block at their cost. We offered them factory management to run it as an extra help. In addition, we are finalizing land lease for block factory casting and go down in Haveli. So at this point in time, Haveli is going to be able to inform them. With this order for block with NSHK, We're buying and leasing out foundation digging machine, increasing the rate of excavation considerably. We expect this machine to excavate 40 to 50 houses per day. Excavation, even money out of it. We've deputed a full-time graduate engineer on site. Some site assistant and field laborers are also being employed. More engineers supervisor and other projects to be deputed. Excavation works are coming from Federal railway station site. We have requested assistant engineer to hand over to us more village locations and Rani River and Yardley constituency so that work can come in there also. We are assured that they're making all of the and complete work. That is that. So, there are a few things. One, preparation mining. Preparation mining ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀನಿ ಅವ್ರಿಗೆ ನಾನು ಯಾವ ಸೈಟ್ ಗಳಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೋ ಅಲ್ಲಿ ನಾನು ಅದೇ ಕೆಲಸ ಶುರು ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತೀನಿ ಬೇರೆ ಕಡೆ ರಾಣಿಗಳು ಬ್ಯಾಡ್ಗೆಲ್ಲ ಇನ್ನ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ ನಮಗೆ ಸೈಟ್ ಕೊಡಿ ಅಂತ ಕೂಡ ಐ ಹ್ಯಾವ್ ಇನ್ಫಾರ್ಮ್ page number 48 the very next page the second excavation work is in progress for 50 houses in Haveli constituency, Karagari railway station site. Updating them on progress. Next, page number 50. We inform them about the delivery of the following machinery that has been supplied. Next comes where the field problem starts. Page number 52. February 19 ಶುರು ಮಾಡಿ ಕೆಲಸ ಅಂತ ಹೇಳಿದ್ದಾರೆ. This is the letter of 9 August 1992. And please remember, let us go back and remember, July to September is excluded monsoon period. July ಇಂದ ಮುಂಚೆ ಶುರು ಮಾಡಬೇಕಾಗಿತ್ತು because then some progress is from July to September I couldn't do progress. But at least ಇದು ಸೆಪ್ಟೆಂಬರ್ ಅಲ್ಲಿ monsoon ಎಂಡ್ ಆಗುತ್ತೆ. ಅಲ್ಲಿವರೆಗೂ ನಾವು ಕೆಲಸ ಶುರು ಮಾಡೋಣ ಅಂತ ಹೇಳಿ 9th August ಆಗಿದೆ. We refer to your above cited letters. The letter number 7 also. As we have been requesting to you earlier, so this is not the first time. We need clearly and accurately marked out sites to be handed over to us in different villages. The housing commissioner has advised us in the discussion in Jubilee Circuit House on 25th July that PhD will be handed over clearly marked out sites for in a systematic manner in different villages where construction commenced straight away. But we have been facing problems in getting marked out. For example, in village Tadas in Shroud constituency, we had to spend a lot of time in trying to locate the local village authority to give mark out to us. It will have a lot of delay effect if we have to go to the search the local village authority for each village because most of the time they're not available and village because most of the time and we have to go again and again to locate them. And then also we are not sure who are the technically competent and authorized persons who show us and give us the mark out correctly. It is normal engineering practice to locate buildings that correct location. Hence, as advised by the housing commission, we request to examine the site that clearly marked out prior to you showing them. Needless to say, dimensional location plans, layouts, also showing offset distances from existing building codes and beneficiary list should be provided for. Beneficiary list is necessary because it gives the site number to which Ashaya house has to be constructed. As you are aware, at several locations, the number of sites is more than the number of houses to be constructed. It does become necessary to know which house, which site Ashaya house is constructed and know which house site Ashaya house is not to be constructed. We also request you to ensure that sites are legally and physically clear and also brought to formation level prior to you handing them over to us for construction. We therefore request you to ensure the above factor prior to showing us the site. We request you to show us the site both on the Ashaya and Dr. Ambedkar celebration together. This is obviously necessary because by getting the village, we would like to complete house of both things being simultaneously. Because coming back once again for that village for remaining house is very expensive and delays and disturb the construction program. Based on the above, we request you to give us the program and over the site to us. But return of email. In fact, immediately on visit of a letter and a reference form, we had directed our engineer to contact our subdivision number 1 office. But unfortunately, our engineers did not find an engineer in office. Our engineer contacted engineers only on Friday, 7th August, and that day also 3 village locations were thrown to him. At this rate, it will take 19 days before we make 55 villages in a letter. We therefore request a program for showing the 55 village locations and giving in a letter and a reference form to more urgent action. Regarding completion of 1732, Ali Tanka, we are talking about mark out and Guttilla, LV. We talk about we put it of Jalu and the money. Regarding completion of 1725 numbers foundation and 700 houses by end of 2019, we like to mention that we have shown to you a revised program and handover schedule having completion in March 1993. We intend to do our construction as per that program and request you to review the progress accordingly. As referred to in the executive assistant executive subdivision 1 later numbers also, we'd like to inform you that mark out was given only for one location, that is Karjani railway station site in Haveli constituency, and not the entire constituency mentioned in the letter, where, as you are aware, we have already commenced construction and shortly all the houses will be completed there. We are surprised about that it is mentioned about the letter that there is no progress in the work has already started. And in the progress is only one village location the mark out was given. In addition, we like you to note the following steps we have taken after signing the agreement. Office was established, technical staff deputed, arrangement of engagement, job making, supply of construction material, arrangement of manpower, work has commenced. After a lot of effort and circle, super site for the casting are the super site for having water and electricity located. Land belongs to government. We like to mention that there was a delay in the mobilization and transfer. So we had applied for mobilization and transfer. We were only on 30th June. So this is the complexity of the thing. We like to assure that we are putting our efforts and we extend all our help in complexity to meet the target. This is the one letter I will read in a little bit more detail. The remaining numbers are very similar. So I just quickly go to the very next page, 50 seconds. August 26, 1992. We recently visited some villages with a section officers in different constituencies. These are the which are given here. But as we see, none of the sites have clear cut markup. None, zero. Most of the sites have no markings, while others are improperly and inadequately marked. That is, boundaries of sites are not clear cut. Shigam district, Taras 1, Taras 2, Timapura, Visanalli, Haveli, Devagiri, Himmaradi, Kanakpura, Devagiri. It's a full list of things we did. It's in alert that the handover of the sites, and we would again go back to the contract. The time period must be computed from the day of handover. In a handover markup put it out, and they constantly writing to them about this issue. In page number 58, it is in September, so August or like September. In continuation of discussion held on 7 September 19, the right to become the please deputed engineer to take over the site to Yadagi. Ali, they write to us in September. Please note, this is the most important part. They write in September. They say, in one constituency in Yadagi, please depute an engineer to take over the site. Which again, if you will see in the next page 59, 22nd September, they say in Shirahatti and Shigam, depute an engineer to take over the site. And these again are illustrated. So where we are at September 1992, the work orders are issued in March 9. According to the contract, I am supposed to be given sites immediately. Time is to be calculated from that. But even as of September, they are saying, now I will release the site. So our finger or you want. Now, just to give you a sense of what was the status at this stage, if you will kindly go to page number 4. I'm sorry, I'm doing a little bit of a back and forth. But I wanted to give some context before going to exhibit E1, which is at page number 4. This is my lord, the status of the handover of the sites as on the date of cancellation, because cancellation happened in August and September, and I've taken you through what was happening in August and September through letters. I will give you the glimpse of a snapshot across various numbers, district across district. Page number 4 to start. Belgaum district.
This is bilateral or it was submitted only for the convenience purpose?
This is a
Correct. This was, was under the signature of both of you, or what was the statement?
Under this, the content of this document have been confirmed through witness evidence. We confronted him, and to that extent, these numbers are corroborated.
Was a chart given by you?
It is prepared by us. It is not a content. We were asking them, give us the details. They were never giving it to us. The number of letters are there. This is a consolidation of all of it. This was given to the trial court. This document was confronted to the witnesses also. that extent it's not fresh given to this high court, it was given in trial effect. Exhibit P1, page number 4. We see under each constituency, Bagewadi, Bailamungla, Kittur, Ramadurga, Paraskara, Kanapura, Belgaum Corporation, Uchigam, Boka. Total number of sites supposed to be handed over 1097. Total number of sites handed over to date of cancellation 100. Date of handover of sites may be July, August. Completion date as per the contract was March, 15th March. That is the monsoon period until September, 15th September can exclude after. So 15th September plus 6 months, 15th March. Date of cancellation 11th August. So please see, July ನಲ್ಲಿ ಕೊಡ್ತಾರೆ monsoon time. ನಾನು ಏನು ಮಾಡಕ್ಕಾಗುತ್ತೆ ಶುರು ಮಾಡಕ್ಕಾಗದೆ ಕೆಲಸ ನಾನು ಸೆಪ್ಟೆಂಬರ್ 15ನೇ ತಾರೀಕು 11ನೇ ಆಗಸ್ಟ್ ಗೆ ಕ್ಯಾನ್ಸಲೇಷನ್ ಮಾಡಿ ಏನಕ್ಕೆ ಪೂರ್ ಪ್ರೋಗ್ರೆಸ್. As on August, I still have 7 months. Under the contract, I have 6 months, but including monsoon, I have 7 months for each of those sites. And that is the same pattern you will see across every single constituency. In Belgaum, all of the cancellations happened in August 1992. The sites were only handed over in July. In 1, 2, 3, 4, 5, 6 constituencies, not a single site was handed over. And yet they go ahead and cancel it, calling 4 voters. Now coming to Harvard district, the page number 5. Harvard 1, 2, 3, 4, 5, 6, 7 constituencies there. Haveri, Shiragati, Shikam, Yadgir, Ranagiri, and K. Handal. Each of them approximately 1,147 to 1,197 sites to be handed over. The maximum sites were handed over in Shiragati, which is 684. Please see the date of handover of the sites there. August, September, November. November ತಿಂಗಳಲ್ಲಿ 222 site na handover ಮಾಡಿ. ಅಲ್ಲಿ completion date is again March to May 1993 ಅಂತ ಇದೆ. Date of cancellation December. So here, especially for those 222 sites, and even for the remainder of the site, a mere 3 months or 1 month after the date of handover, they cancel the contract. Whereas I still have more than 3 to 4.5 months left to construct those houses. But I understand from the other submission that 15 ತಿಂಗಳು ಆಗುತ್ತೆ ಮನೆ ಅಂತ. ಈ 15 ತಿಂಗಳು ಮನೆ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ 4 ತಿಂಗಳ ಮುಂಚೆ ಏನು ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತಿದ್ವಿ on grounds of poor progress. And I saw that we have excavators which can do 30 to 50 houses of excavation per day. That is the kind of machinery they have built. I have long-term supply arrangements, and yet within a month they cancel. And the interesting part is that in respect, just one very interesting example. Underlining over there, 8 sites are handed over on 13th October. They cancelled on 20th. So I give you the site, I cancel it on grounds of poor progress. And then I go back to our contract. Every 15 days you go to a progress review meeting. After that you give delay, I mean you apportion a liability, you give them 1 week to rectify that. If they don't rectify it, impose penalty. If penalty exceeds 7.5%, then we can cancel. They cancel it within 1 month. Going back to the question I was asked about, is this really contemporaneous record? I explained that it was a convenience document prepared, but I will take you to contemporaneous record which supports this. So I kindly request you to look at the judgments to start with, so that we see what the trial court has done at Faithful number 1, page 122.
Yeah, referring to judgment, trial court judgment. You can see that in the paper, this appeal papers.
Very.
So that would be convenient to refer to the documents.
That para number 25.
Page number
42 numbers. 42 of the judgment.
Page 42.
But in page number.
Ink page means then you have to refer to which appeal memo.
At page number 42. Another.
Internal page.
Page number 20, paragraph 25.
Yes. Para 25.
25.
21 ಅಂತ ಶುರುವಾಗುತ್ತೆ. Now coming to the evidence of
As regards T1 and T2.
ಲೆಫ್ಟ್ ಸೈಡ್ ಅಲ್ಲಿ ನಂಬರ್ ಹಾಕಿಲ್ಲ ಜೊತೆ.
42 ಅಂತ ಹೇಳಿದ್ರು. 42 ರಲ್ಲಿ para 21 ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ. Next paragraph with regard to OS 74.
Paragraph later 25. Paragraph 25 is the thing.
That's exhibit P1.
As regards T1, it's about 4
That is the internal page 50 in our record. ಇದು ಬಹುಶಃ ಅವ್ರು ಕೊಟ್ಟಿದ್ದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅವ್ರು ಕೊಟ್ಟಿರೋ ಪೇಜ್ ಅಲ್ಲ ಅನ್ಸುತ್ತೆ.
trial court to the report, but paragraph 25. That's as regards the exhibit P1 and P2, which is the documents the Karnataka Housing Board has filed exhibit P75. It discloses number of sites in Dharwad district that were handed over to the contractor and differently. This document tallies with exhibit P2 as far as Haveli, Shirvati and Shika are confusing Dharwad district in relation to the number of sites that were handed over to the contractor. Therefore, the contention of the Karnataka Housing Board that it had handed over all the sites as well be handed over to the contractor is without any merit. It is pertinent to note that exhibit P75 is the document issued by the Karnataka Housing Board. This document disputes exhibit P5, the letter issued by the Karnataka Housing Board to the contractor to the effect that it has handed over all the sites in Dharwad district to the contractor to the exhibit. In present, exhibit P5 number was that before contract they said start preparing work and that is the exhibit. The court says that exhibit P75 directly corroborates exhibit P1 and P2. Now let me take us through. So the exhibit P75 itself. Now going back to the page of figure P earlier, it is at page number 72. P75, page 72.
Yes, sir. Yes.
Sites handed to the agency Navika's builders. Haveli, Shikam, Shivahati. Mure Kota. Number of sites is the date of handing over of site. Because my lords, I didn't want couple my lords to turn page here and there. I took my lords to the trial court has done the extra, we have not disputed that. Even after I see that this document is signed by next page and it is 73, signed by AEE, number 1 subdivision, Karnataka Housing Board. So the appellant itself has confirmed that. Please see the date of handover. September, October, July, April, and Karjali Matra. You will see that Karjali, you also acknowledge that you received that site. October, July, September, November. Then I kindly also request you to that page number 109. This one is contemporaneous record, but not issued by the relevant officer, but it's still given by Taluk officer. Indicate Gramadali survey number 183 ಕ್ಷೇತ್ರ 1.3 ಎಕರೆ ಈ ಜಾಗದಲ್ಲಿ ಒಟ್ಟು 32 ಆಶ್ರಯ ಯೋಜನೆ ಮನೆಗಳನ್ನು ಮಾಡಲು ಉದ್ದೇಶಿಸಿದ್ದು ಈಗಾಗಲೇ 20 ಹಕ್ಕು ಪತ್ರಗಳನ್ನು ವಿತರಿಸಲಾಗಿದೆ. 20 ಮನೆಗಳನ್ನು ಮಾತ್ರ ಕಟ್ಟುವುದು, ಇನ್ನು ಉಳಿದ 12 ಜನರಿಗೆ ಹಕ್ಕು ಪತ್ರ ನೀಡಿಲ್ಲ. ಇದರ ಬಗ್ಗೆ ಕೋರ್ಟಿನಲ್ಲಿ ಮೊಕದ್ದಮೆ ಇದ್ದು 12ಕ್ಕೆ ತಡೆಯಾಗಲಿದೆ ಅಂತ ಬರೆದುಕೊಟ್ಟ ಸರ್ಟಿಫಿಕೇಟ್. So ಇದು ಯಾವಾಗ if you will kindly see they are talking about the August of 1992.
There is no date for
There
this.
is no date. I just checked the original of this also. But this was around that period, and the original maybe the seal it is there. Again, talking about the handover of limited number of sites by relevant local authorities. You will see the next few pages members. Page 119, page 107, page 110, exhibit 119. This is to confirm that given mark out to Navika's builders for Ashray House on the date 20th July 1992. Pradhana Mandali Panchayat, Vendigeri Taluk, Belagavi. Next page 120. July 1992, Rajamanan Ali, Junior Engineer Taluk Panchayati Samiti Bayahumla, 17th August 1992, Karkotta. Next to 121 Nali, Vendigeri, 14th August 1992, Chairman Village Panchayat Vendigeri. Next to 20, Comparati, 20 Cope now, 20 Cope ಮತ್ತೆ ಕಂಪೇರಿಟಿವ್ ಕುಡಿ ಕೋಪ್ ನಲ್ಲಿ 7 ಮನೆ ಕಂಪೇರಿಟಿವ್ ನಲ್ಲಿ 4 ಮನೆ ಅಂತ ಹೇಳಿ ಬರ್ಕೊಡ್ತಾರೆ. ದಟ್ ಇಸ್ ಆಲ್ಸೋ ಜುಲೈ 1992 ಟು ಆಗಸ್ಟ್ 1992. ಇದೆಲ್ಲನೂ is consistent with our document. While I understand exhibit P1 and P2 are not contemporaneous records in that sense of the term, they are corroborated by all of these various documents. In fact, the other two documents are page 58 and 59, which you already read, so I'm not going to take my words through it. This is the letter that I referred, which is written by the applicant was the deputy engineer to take over the site, and tell 15 September. That's September and I'm over the site. So all of these documents, so that sites were handed over in an extremely related fashion, and on or around September 1990. Why I say September? Even if it handed it over in July or August, it is irrelevant. That period is excluded. So for all practical purposes, handed over on 15 September 1992, because that is when the construction could start, and then they cancel the contracts in October. That is the reality. That is the uncontroversial fact. So what did I do? I have already taken my lords through some of the letters that I wrote, saying poor handover of sites, kindly handover. There are more such letters, which is there in my contentions with the doc references. I have given all of the document references. I'm not going to trouble my lords. When I expressed this problem, they did not dispute it. They did not say, yes, I'm sorry, whatever. They simply went ahead and terminated the contract. Now, what should they have done before termination? I took my lords through the contract. Now, let me take you to the correspondence and see if it mirrors what the contract is. With this, my lords, may kindly look at page number 97. What did I do during this window? Onlinelagi site delay handover agale that is there. Where sites were handed over, because the question obviously comes to mind. Okay, fine, they didn't hand over everything, but where they handed over, did you do the work? Because if you didn't do the work, maybe this court has some sympathy to the appellate. They say, yes, you didn't do work, and therefore they terminate. I might still understand it, and therefore let me even dispel that notion to say we didn't do any work. Page 97. This is in May 1992. As Navika's builders second course also has entered into agreement to 23/3/1992 for Ashera and all 9 months. Excavation work is in progress in Bagewadi village of Bagewadi constituency. So, May and there are contemporaneous records showing that I have started doing the excavation work. And others in the same compilation at page 48. Which I already read, which is progress excavation work is in progress for 50 houses in Karnataka railway station site, which is again in May 1990. Page number 48. At page number 65. I just read this one letter because this is one of those letters where we've done the work and they started making some allegations of poor progress. So if you just read this one, this June 26, 1992, please note, June 1992 is when only one conference was conducted. We are in receipt of the above letter dated 22 season. We are very much surprised to note the impression that we are not in a position to tackle the work infrastructure. After entering into agreements with you, we are explaining from time to time the elements of our plan to carry out the construction of 10,223 houses within the time and cost constraint. Our original plan has also been discussed with the chief engineer and deputy director, and it has been explained to them as to how we propose to tackle this massive and complex project. We have also made progress on other aspects, for example, opening office in Belgaum, appointing and identifying so starting work in 2 constituencies as okay. Therefore, there is no valid ground to conclude that they are not in a position to act the work, and that action needs to be initiated under the agreement. After entering into the agreements in 2023, requested him to give us the site plans. After entering into the agreements in 2023, requested him to give us the site plans, beneficiaries, and show us and hand over sites for construction. We were told some sites informally on 16th April, not on 23rd as stated in the letter, only in Bagewadi. We plan to start work in Bagewadi within some sites in March. There was, however, a standing crop on these sites with delayed start, which was brought to your notice. As soon as the crop was due, we commenced construction, but the food stopped from working by the previous owner of the land, but not being paid for acquisition. Our engineer took up the matter with the village authorities and also persuaded the landowner, but to no avail. This was also brought to your notice. We are now taking up the other sites in Bagewadi and have also started working by the Hongal. It has also been explained to you on many occasions that delay in the receipt of mobilization advance have been major setbacks. We can implement our work program fully well and progress at a faster pace once the advance is received. We give it to understand it will be dispersed very soon. We've identified existing concrete block manufacturers who are ready to supply the total of engineer and your good said that visited 3 of these factories. So Apple has also visited these factories on 2016 and found the facility there satisfactory. Besides, we are also negotiating takeover lease of a factory which we will install more machines. We also plan to set up new factories to ensure total blocks will remain in time. As per our original plan, the complete list of beneficiaries and site received by us on 28th February 1990. All of you have so far given us the partially our plan for Bagewadi, Bailawal, and two companies, where assistant executive engineer letter dated 6 June 19, received by company and request you to furnish us layout plans, list of beneficiaries, and for all the companies they get. Subsequently, the program of handover of site after joint inspection can be drawn up after this. We again assure you that work centers are to be carried out. Therefore, even when they are making these allegations, please see the kind of allegations they are making, which have no support, and identify these problems. But even at this point in time, it is not how the contract is. Contract payment means go on the site. How much is the progress? Idinalli ee plan prakara interest istu ಮಾಡಬೇಕಾಗಿದೆ. ಇದು ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೋಸ್ಕರ ಯಾರು default ಇನ್ನೊಂದು ವಾರದಲ್ಲಿ ಇದನ್ನ rectify ಮಾಡಿ. That is not all what they say. They simply say we don't think you are in a position to perform this contract. Actually, a very broad line, and we respond with very specific and responses. None of that have been responded to by them. Then, if you will look at page number 72, I handed over that I have already taken over. Page 68 number, sir. Which is exhibit P7. It's in July 19. This by this time monsoon has already started. We'll actually bring you notice the status of Ashaya sites in the following details. Samtown village people conference. We had gone to this village yesterday, which has about 49 Ashaya houses to mark out and start along with the engineering. On site inspection, none of the sites is clear and almost all existing huts and houses over there. We were told that some sites have double paths. We were told that not to be able to commence construction. We request you to have these sites cleared so that we can commence construction. First of all, we want village in Bagewadi constituency is going to have 59 Ashaya houses to mark. So there again, we still continue to have this mark-out problem. Now, insofar as the progress of the works is concerned, even the appellant's witnesses have admitted that there is progress of the work. Can I kindly request you to look at paper book number 2, volume 1, paper book number 2. This is all the depositions of the witnesses. This is that page 8. The relevant question this particular witness's cross-examination is not very long. So, if I mean, with the permission of this court, please read the cross-examination of this witness starting at page number 7. Just 3 pages. I'm going to give it. And giving evidence only on behalf of first plaintiff. First plaintiff court has not passed resolution authorizing it to evidence, so on and so forth. Witness says the Housing Commission has authorized it to evidence. First plaintiff has not. Since July 1999, I've been serving as manager of finance at first plaintiff. Prior to July, I was not working in plaintiff. Now, it is true that stipulated period for the construction of houses are semi-independent for 9 months. What is stated in my affidavit under so and so, the effect of stipulated period for construction of the houses was 6 months, including monsoon period, is not correct. It is true that the period of 9 months had to be calculated from the day on which the sites were handed over to the second dependent. All the sites for construction of 1,141 houses were handed over to the second dependent. I cannot give the date on which all the sites were handed over to the second dependent. So also all the sites for the construction of the house and Rani Bengal period until this handed over to the second dependent, but I cannot give the date. So his testimony yellow put period. Witness again says that in spite of the several letters, second dependent did not come forward to take possession of the site. Executive engineer and division of the first plaintiff was in charge of the site and he has to hand over the sites to the second dependent. No acknowledgement is taken for evidence handing over possession of the sites to the second dependent. I mean, I don't know how this is believed. How a government agency will hand over the sites and not even take acknowledgement. Except correspondence, there is no acknowledgement to show that possession of the sites are handed over to the second dependent. Those correspondences are not produced in this. Except correspondence, there is no other document for the executive engineer and another officer to hand over possession of the sites to the second dependent. The second dependent cannot take possession. So, low letter. A letter not putting a letter prakara evidence are he does not identify how his own documents come to work. Now I cannot give the date on which possession of the site is offered to second. Without verifying records, I cannot say that only 32 sites in Rani constituency were handed over to the second. So without verifying records, I cannot say that no sites in Rani Bengal and indicated were handed over. Similarly, without verifying records, I cannot say I see only 8 sites are given to the zone. So one better way that all sites put in. But because of mistake I put in actually record verifying. If you really believe that everything was handed over, you will say no, everything was handed over. But he says I have to verify it. Obligation on part of the first plaintiff referred to.
He was not a site in charge. He was not a site in charge.
But he is deposing to those facts.
He was administrative.
He is a finance manager. Very well. But we will see.
Any other witness was examined.
There are other witnesses. Well, maybe they were doing their.
Actually, the site in charge is.
Yes, no, one part I want to say vaguely, just so that we finish this witness. It is true that wherever sites were handed over to the second dependent, it has shown progress. Without verifying record, I cannot say whether progress verifying meetings were conducted. It is true that if progress will be meetings were conducted by executive engineer, record will be there with the second first plaintiff. There is no impediment to produce this record. So he acknowledges that there was progress. Next, the second witness that we will see. Mr. J.K. Sridhar, he is again manager of finance.
Manager finance.
That is key. 32, my lords, is the executive engineer. Mohammed Faisal. Maybe his affidavit I'll tell this week. Because I just want to read one affidavit to my lords just to give you a sense of where the state is coming from. And I read cross-examination of Mr. Faisal. This is page 30. Since 2002, I have been serving as executive engineer in the plaintiff court. I was not in charge of the execution. I was serving the plaintiff court during the. I was not in charge of the execution of Asha and Dr. Ambedkar. I was serving in plaintiff court during 1990. So, while of course he's not the site person, he was on the board. So, he had knowledge of the matter. At the time, I was serving as assistant engineer in Ballard. It is true that I have no personal knowledge for the execution of the so-and-so centuries. I am giving everything on the basis of record. Before giving instructions to prepare my affidavit, I have gone through the agreements, bank guarantee, correspondence, and other price available. Plaintiff has documents to show the particulars with regard to construction area and cases are given to the second. There is no records to show the particulars regarding distances in the construction. At the time of agreement, details regarding construction area and cases are given to the second. It is true that the second defendant had to take up construction work on the site provided by the court. Subsequently, sites were given to the second defendant. It is false to say that on the date of the agreement, details regarding construction area were not furnished to the second defendant. Now, when the is settled in, now we start with the correct evidence. On the date of letter of intent, sites were not ready for handing over to the contractor. It's true that second defendant has conducted preliminary survey of the area subsequent to the letter of intent. Preliminary work and later. It is true that after the second defendant has complied with the requirements of letter of intent, agreements were entered into. So even before agreements were entered into, I started doing work is what his testimony says. I have not gone through the files and records pertaining to background mistakes. I have gone through the papers and records and to constitute the Dharwad. My evidence is restricted to Dharwad. Plaintiff has records in its office to show the dates on which sites were handed over to the second defendant in different constituencies of Dharwad district. The said documents are in correspondence file. On the date of exhibit P6, sites in Rani constituency were not handed over to the second defendant. Subsequent to exhibit P6, all 1,197 sites were not handed over to the second defendant. Witness says that part of the sites were handed over to second defendant. I do not remember the number of sites out of 9,197 sites in Rani Venu constituency were handed over. It is true that on the date of work order, no site in any of the constituencies of Dharwad district were handed over to the second defendant. So, letter of intent denied, work order denied. It is true that in none of the constituencies, all of the sites were handed over to the second defendant. He also acknowledges that in none of the sites, all of them were handed over. I do not remember as to how many sites were handed over to the second defendant. This again is important because the very first line he says the plaintiff has records in his office to the dates on which they were handed over. And yet he says he did not remember and he does not produce any such records. And the fact that the state does not produce records is a relevant fact. I do not remember that no site in Hideki constituency were handed over to the defendant. I do not remember date and number of sites handed over to the defendant. Haveli, Shiraki, Shikao, Vyati, Nandar constituency. Witness volunteer, approximately 700 sites in 7 constituencies of Dharwad district are handed over. This Manoj is the one line which corroborates everything we said. He doesn't remember exactly, and you will see broadly coincides with what we have also said. This also stated the period of 6 months, excluding monsoon period of 15 was granted to the second defendant under the agreement to complete the construction on the date of delivery of the site. He is controverting the contract. Mobilization amount of release in the month of June 1992. So you also see June 1992. Contract of March and June and month of mobilization. Even before that, you will see he may have started doing work. So I have started doing work even before mobilization. Plaintiff has documents to show that some sites in different constituencies are handed over to the second defendant prior to the date of mobilization. It is also stated before releasing mobilization advance, only 30 sites in Haveli constituencies are handed over. Executive engineer was supervising the progress of construction. Plaintiff was records regarding progress achieved by second defendant in the matter of construction. It is handed over. Which plaintiff has records regarding progress. That again is not being produced. It is true that construction work is in progress in the sites handed over to the second. The last line is very, very important. It is true that construction work was in progress in the site handed over to the second defendant. Markout order means clearance given to second defendant to start the work. Markout order was given not in respect of each site, but in respect of each job. It was not necessary for the second defendant to wait for markout order to commence the construction work. Markout order does not disclose number of sites, site numbers, and name of construction. Ali, again, I don't understand this statement. We have been writing letters to the Propan and getting the boundary and the please give me. And then he says, no, markout order is not mistake. Layout and letter are available home construction. That is the testimony of the executive. I do not remember whether markout orders are not seen by me before filing. There is no markout order in writing. That is important. There is no markout order in writing. It is false to say that second defendant has sufficient infrastructure to proceed with the construction. It is true that the plaintiff has cancelled the agreement even before expiry of the period of 9 months. That again is very important. It is true to say that the plaintiff has cancelled the agreement even before the expiry of the period of 9 months. Localized problem means problem of labor, water, etc. It also includes problems created by owners of land from whom lands are acquired. I have no idea that the local people have created problems for the second defendant to start construction. It is true that the executive engineer had to review the progress of construction once in a fortnight. Right? There is no record to show that the executive engineer has reviewed the progress of the work. So that not there. He's admitted that there is no record. It's true that the chief engineer had to review the work once of 2 months. Recorded there in our office to show that the chief engineer reviewed the progress of work on but probably suddenly he realized that oh, I'm saying something which is 30 minutes. Records still unfolded. It is true that after the terms of contract, if there is shortfall in the work carried out by the second defendant, notice by the executive engineer and chief engineer will be inspected and is not reviewing for the second defendant, contract was directly cancelled. So he admits that first the executive engineer has to notice, chief engineer has to notice, then it has to be remedied, and only if it is not remedied, it can be resigned. He admits that. So letter dated 6th August 92. Time was extended till March 1993 to complete the construction work by the second defendant. Plaintiff has copies of the letters addressed to the second defendant. So you will see that, in fact, so far as Dharwad is concerned, even though some sites are handed over early, the time was extended till March 1993. So the actual period of construction of project table and incomplete, we have shown it as being in January and February. It was extended till March. So I not even had 4 months. I in fact had 5 to 6 months to complete construction. This to the plaintiff was entitled to import time guarantee. Damage was suffered. Damage suffered by the plaintiff to import time guarantee was escalation in cost of this quantum of damage was not assessed by the plaintiff before invoking bank guarantee. That is also an important admission. It is true that immediately after cancelling the contract of second content, construction work was interested to Swarnamukhi. I do not know whether tender was called before interest was Swarnamukhi banking component. So this really matters the real reason. Without tender, they are awarded interest. It is false to say that the plaintiff has cancelled contract of the second figure only to pay the Swarnamukhi building component. It is false to say the second defendant has performed all its obligations. It is false to say the plaintiff has committed fee and illegally so on so. The next one is on invocation of bank guarantee. I do not know the contents of bank guarantee. So it is true that plaintiff had to invoke bank guarantee in the case of loss, damage or loss because of the by addressing so. It is false to say the bank guarantee will invoke it. That will be on the basis of documents. I don't want to So even on the basis of the witnesses' testimony, there are two things that are combined. One, letter of intent dina allowed to say to Dinaka, but what are Dinaka, Yaw say ready Dinaka, Oka. Adame, who say Putilano, Oka, total very old say Putila and Oka. One thing out of Munchi terminate Madison to Oka, executive engineer, chief engineer, the periodic review meetings, Madu Oka. So, really, just on the basis of this witness statement, which is corroborated by documents, I didn't want my lawyers to base my case on witness statement because ultimately it's contract, civil, commercial dispute, and documents speak for themselves. So I took my lawyers to the document. But even on the basis of the evidence, you see that it's all corroborated and everything that they have provided is consistent with what they said. So one more document I will request you to look at is page number 76 of volume 2 of the paper, which is the document. My lord, is a document that we prepared. So my witness is prepared. This is not a contemporaneous record, but he sworn an affidavit and he's given this record. What they're saying is in each village, the date of handover of the site, the number of sites that are handed over, and the progress of the site. So you will see, my lord, that in Shirahatti, for instance, August by the date of cancellation. So we are talking about Harvard district cancelled in December. September, we had monsoon. So between mid-September to December, which is in a period of about 2.5 months, excavation 100% complete, flooring 100% complete, wall 70% complete. Sorry, at least foundation, flooring 50% complete, roof 30% complete. That and you will go further down. Different constituencies, different level of progress has been achieved. So this clearly goes on to show that I was making very significant progress.
This is W.
Yes.
W. What is that? W.
W is the walls. So, excavation, no? Excavation, foundation,
Yes.
walls,
Down.
flooring, roof. Next to doors, windows, wall finishes to correct. There again, different projects, different progress of work have been achieved. This is the status, my lords, in August, September, November. Around that time, this was the status of the various projects that were done. What happened thereafter? Kindly page number 79. This is 11th August 1992. Office of the Executive Engineer, Karnataka Housing Board. The Chief Engineer. The Chief Engineer, Karnataka Housing Board, Bangalore awarded the work of construction of houses. Please note that because there is a jurisdiction problem. Chief Engineer, Karnataka Housing Board, Bangalore awarded the works of construction of houses in rural urban under the above in Belgaum district covering 9 counties. By his letter dated so with the direction to attend my office within 2 days to execute the agreement on and to commence work immediately. To enter into the agreement with me on 23/3/1992 as follows. Details of various agreements. By this office letter, agreement number 131, dated 21/9/92, to direct to commence work immediately by contacting. So indicating that there is by contacting assistant, indicating that there is no progress on the site shown to you by the assistant on 23/3/1992 in Bhagavad. Consequence. 23/1992 the Yahoo site totally allowed because even their own engineer says that as of the work order, which is 28 March, there was no site which was handed over. But they say, oh, you close this, until you should not. Close it. Right from February 19 to 19, of meetings in Central Office conducted by Chairman Housing Commissioner Karnataka Housing Board, Bangalore. Again, another link to Bangalore. All these total meetings or whatever review meetings are held in Bangalore. To impress upon the agencies and department officers the urgency of early. Also, the infrastructure created by you, but also reviewed and it was found that no infrastructure of any other preliminary arrangement made by you. No preliminary arrangements are made by you on that. Whereas their own witnesses contradict this. They say, no, yes, preliminary arrangements are. In fact, their officers visited the sites. You remember my was about 5 minutes ago, I took you to that. Till 15 June 19. Therefore, a notice is served by me to you on 16 June. The reply submitted by you by a letter dated 26 June made to me conclude that you are not in a position to tackle the work, and as such, I submitted to the Chief Engineer Karnataka Housing Board, Bangalore, to permit me to take action in terms of the contract agreement. The decision came from Bangalore. In turn, the Chief Engineer Karnataka Housing Board, Bangalore, by the letter dated so directed me to issue cancellation notice. This is the decision to cancel the contract agreement taken by the central office. In person of the above instruction, I am my signature issue cancellation order as the terms and conditions of the meeting. The following agreements, you read this as a cancellation order. So, once again, I go back. This is, we are at 11th of August 1992. When, so this is well done. Sites were only handed over in July and August 1992. In fact, this 11th August when the letter was there. On 11th August, they hand over sites. So, that really, my lords, is what happened in Bed. They say ostensibly because I have not achieved progress or I am unable to perform the contract. Contract ಪ್ರಕಾರವಾಗಿ ನೋಡಪ್ಪ ನೀವು ಪ್ರೋಗ್ರೆಸ್ ಮೀಟಿಂಗ್ ಮಾಡಿ ಪ್ರೋಗ್ರೆಸ್ ಮೀಟಿಂಗ್ ಮಾಡಿದ್ಮೇಲೆ ನನಗೆ ರೆಮಿಡಿ ಮಾಡಕ್ಕೆ ಒಂದು ವಾರ ಕೊಡಿ ವಾರ ಮಾಡಿದ್ಮೇಲೆ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಪೆನಲ್ಟಿ ಇಂಪೋಸ್ ಮಾಡಿ ಪೆನಲ್ಟಿ ಇಂಪೋಸ್ ಆಗಿ ಆ ಪೆನಲ್ಟಿ 7.5% ಆಗಿ 7.5% ಇಂದ ಆಗಿ PMT ಮನಿಗಿಂತ ದೊಡ್ಡ ಜಾಸ್ತಿ ಆದ ಆಗ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಬಹುದಾಗಿತ್ತು they give a complete go by the entire contract. That is better. Next numbers is very similar. It's a story for Harvard page number 83. Contract cancellation order. That's not also an after program in Harvard 7,000 page 84. The work of construction of houses under Australia and Harvard district in 7 constituencies and noted of below have been entrusted to Navika Builders after the letter of intent. The agency has acquired the agreement confirmed. Period of completion is 9 months, including the period of months. Agreed date of completion is 22/12/1992. So there again, that is a mistake they made because they assume that it is 9 months from the contract, but it really is the date of handover because the contract says time needs to be calculated from the date of handover. It is noted that displeasure that the progress on about 1,000 under different constituencies are too poor and far from satisfactory. Even constant persuasion from the office and the subdivision officer. The progress achieved by the agency is very little. The contract showed disinterest in commencing work in all the 7 constituencies as per schedule, though there was full scope to him to work. The contractor was informed about the slow progress in a later date, 16 September, indicating the previous references already made. This officer there was no reason to begin the agency to complete the work within the scheduled time. Order. Under the circumstances explained above and with the letter of the Housing Commissioner Karnataka Housing Board, Bangalore, the contract awarded to Navika Builders so in respect of construction of house and Russia and later in 4 constituencies is hereby cancelled in the interest of the board under the provisions of 5 years agreement executed by the agency. As the case can't afford to wait anymore and hence unable to take the balance of the date completed by alternative means. Only thing they correct about is because they wanted to do it by alternative means. Really matters what has happened again here is exactly what it is. Well done. As on the date of this order, which is in October 1992, we will again once again see the status of the handover of the various projects, which is an exhibit B2. Most of the sites were only handed over in August. In fact, some sites were handed over on 15 October 1992, subsequent to the issuance of the cancellation order. Therefore, that act of cancellation we challenged. We came to the court challenging the cancellation of the contract in the Belgaum and Dharwad districts. Now, what has the trial court said? Now, giving you the brief background leading up to this, now we are at the dispute stage. And a very quick background there was then I went to the trial court, I applied as an indigent person. That application to prosecute as an indigent person was allowed, and thereafter the suit came to be filed. Now, what after a 10-year period of trial. What is the trial court text? May kindly refer to the text. Judgment of the trial court. Para 22.
Yes.
Page number 1. Now, the point to be considered is who has committed breach of the contract, whether the plaintiff or the second defendant. In this regard, both the parties are net for oral and concrete. Before I proceed to appreciate the oral evidence submitted by the party, I propose to refer to the relevant agreements entered into with the party. All these agreements are stuck with same terms and conditions. Separate agreements have been entered into with respect to future circumstances. Exhibit P to P21 are the agreements with respect to several assembly constitution question. Exhibit P22 contains the general conditions. P6 to P14 are 9 separate agreements executed in respect to the work in question to be executed in 9 assembly constitutions. Clause 2B, which is common in all the agreements, states that the period for completing the work in question shall be reckoned from the day the site or worksite area is handed over either in full or in part of the contract. As per condition number 11, the work in completion shall be completed within 6 months from the day the possession of the site or worksite area is taken, excluding the rainy season from 15 June to 15 September. The agreements pertaining to both the districts in question are dated 23/3/1992. On the contractor side, exhibits P1 and P2, which are the charts furnished by him regarding the number of sites that are handled over to him as on the date in which the agreements for both the districts came to be cancelled. As per exhibit P1, the number of sites that were supposed to be handed over to the contractor in respect of Bagewadi, Bairamula, Tikkuru, Ramadurga, Paraskara, Khanapura, Belgaum, Pakam, and Goka, were so and so respectively. As against this, only 101 sites, 20 on 15 July 92, 15 on 20 July 92, and 66 on 11 May 92, and handed over to the contractor in respect of Bagewadi, and he talks about the various remainder of it. 4 lines, 5 lines from the quarter, 6 lines from the quarter. However, no sites are handed over to the contractor in respect of Ramadurga, Paraskara, Khanapura, Belgaum, Mushka, and Goka. 6 months of time stipulated from the completion of the work has to be reckoned the date the sites are allotted to the contractor, excluding 3 months during the release. Exhibit P1 also shows that the work in question in respect of Bagewadi, Bairamula, and Tikkuru constituencies were going to be completed on or before 15 March 1993. The contracts for the execution of the work in question in respect of all the aforementioned constituencies were cancelled on 11th August 1992. Thus, it is clear that the contracts have been cancelled within a period of about 1 month and 1 week from the dates the sites were handed over to the contractor in respect of Bagewadi, Bairamula, and Tikkuru constituencies. Whereas, even before handing over a single site, the contract has been cancelled in respect of Ramadurga, Paraskara, Khanapura, Belgaum, Mushka, and Goka. The said chart exhibit P1 also reveals that the time given to the contractor to complete the work in question was 7 months from the dates the sites were handed over, because there is 1 month of monsoon period. The chart exhibit P1 also makes it clear that the contractor had still 7 months of time to complete the work within the time stipulated in the agreement. Exhibit P2 is a chart similar to P1, but in relation to 7 assembly constituencies, Harvard district. It reveals that the number of sites was supposed to be handed over, and he talks about the Harvard district for the remainder of the time. I won't read through that about the next, the same paragraph a little later. It says, thus it is clear that the contractor had still 7 months of time to complete the construction from the date of cancellation of the agreement as per the stipulation in the agreement. From these two crucial documents that exist, P1 and P2, it is clearly evident that the contract in respect to the work in question has been cancelled much prior to the dates stipulated in the contract to complete the work in question. These two documents have not been challenged or controverted by the Karnataka Housing Board. Not even a scrap of paper is produced to rebut exhibit P1 and P2 with regard to various aspects as found there. Exhibit P1 and P2 also makes it clear that the contractor was not handed over the sites that were supposed to be handed over to the implementation of a couple of constituencies. Not even a single site was handed over. These things are clear pointed to the fact that it is the Karnataka Housing Board which is deviated from the contract question, but it really actually cancelled the agreement. Question. It is done. The evidence used by Sri J.K. Sridhar Murthy as exhibit P1 has been some relevance. In its cross-examination, he categorically admitted that the time stipulated for the construction of the houses by the contractor was 9 months, including further stated that the period for completion of the contract construction was 6 months as stated by him in his affidavit filed in the examination evidence in chief is incorrect. This makes it clear that there is a contradiction in his say as made in his affidavit filed in the evidence in chief and his oral say before the court. In the same 4th page, he has categorically admitted that the period of 9 months has to be calculated from the date on which the site was handed over to the contractor. Though he has stated that the site in respect to the assembly constituency question was handed over to the contractor, he has continued to say that he cannot put the dates on which the said site was handed over to the contractor. He has stated that though several letters have been written to the contractor, he did not come forward to take possession of the site in respect of 4 assembly constituencies. In his cross-examination, he admitted that those correspondences are not produced in this suit to evidence the same. Therefore, whatever PW1 has stated in this regard becomes only self-interested testimony and nothing beyond that. In his cross-examination, PW1 has admitted that even before the expiry of the security period of 6 months, including the monsoon period for the execution of the project in question, the Karnataka Housing Board has cancelled the contract, but he stated that the contracts in question were to be cancelled as there was no progress in the works entrusted to the contract. As regards P1 and P2, the Karnataka Housing Board has filed Exhibit P75, disclosed the number of sites. This are red maps, so I'm going to keep the reading marks. Disclosed the number of sites in Ragala district that are handled with the contract. The document tallies with Exhibit P2 as far as so and so districts are concerned in relation to the number of sites that are handled. Therefore, the content of the Karnataka Housing Board that has handed over all the sites that have been handled to the contractor without any letter. It is pertinent to note that Exhibit P75, the document issued by the Karnataka Housing Board. This document discloses the Exhibit P5, the letter issued by the Karnataka Housing Board to the contractor, the evidence that has handed over all the sites in Ragala district. P2 Sri PR Kosu Executive Karnataka Housing Board has filed an affidavit containing examination in chief instance. He has stated that the facts narrated by him are based on the record that his personal knowledge about the fact. He has stated that he has no knowledge about the affairs of the board in relation to the examination. He has stated that there are mark-out areas which mean that the exact location of cases in the house were to be found. According to him, the mark-out orders are issued with respect to different places, but he is not aware that any such mark-out orders are produced in the suit. But he has stated that the Xerox copies of the mark-out orders are available in the office of the Karnataka. He has admitted that the Karnataka Housing Board has to give the mark-out sites to the contractor to take up the construction work. That's an important difference. You must give it to the contractor to take up. As already stated, the mark-out order in relation to the project in question are not produced by the Karnataka Housing Board for the reasons best known. PWP one Sri Mohammed Fayaz who is working as executive engineer Karnataka Housing Board. He has filed his affidavit containing the evidence in chief. He has deposed the facts relating to the assembly consequences in Karnataka. Regard to which the contractor given to the contractor. He too has reported that there are records in the office of the Karnataka Housing Board so the dates and which the type of factor in respect of the different consequences in Harvard. He stated that the said documents are in the correspondence file, but the said file is not. One Shiti Malana, executive engineer Karnataka Housing Board as PW4 has filed his affidavit containing his examination. He has deposed that he has no personal knowledge about the contract. He stated that he is giving evidence based on record and based on information collected. He has stated that he cannot divulge the information as regard the exact number of sites he can handle with the contract. He has admitted that no sites are handled with the contract and the others. He has stated that mark-out order means work order. He has reported that work orders have been issued in favor of the contractor, but there is absolutely no evidence to the sites are handled as per the work order issued in favor of the contractor. Therefore, with P1, P2, 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 P3, and P7, clearly reveal as the exact number of sites that are actually handled with the contractor. Now, coming to the aspect of progress achieved by him in the matter of execution of work. The contractor is relying on exhibits P11, 5 to P12 marked in zones. In this regard, total evidence has been used to its witness DW1 Sri S.K. Market, who is one of the directors of the contract. Through him, exhibit P40 was company marked. In OS Going, this is a letter dated 7/5/92 to the office of the chief engineer of the Karnataka Housing Board from the executive engineer of the division of Karnataka Housing Board. The said letter reveals that the contractor has entered into an agreement with the council regarding the construction of houses in 7 assembly constituencies and that the work orders have been issued in them. The said letter also reveals about the work as regards the construction of 50 houses near Karnataka railway station in Haveli constituency. Apart from this, PW1 who is being examined on behalf of the Karnataka Housing Board has admitted there was progress in the work entrusted to the contractor with reference to the sites that were handled with him. In this regard, its DW1 has got marked exhibit P76 in this. This is the progress report in relation to 7 assembly constituencies in Harvard district. It is a summary of the progress achieved with regard to work in question as on 17/8/1992. In the same suit, exhibit P83 has been got marked on the contractor. It is in relation to arbitrary, illegal, and unjustified cancellation of contract. Question. The contractor has also marked exhibit P76. It is a report in relation to progress of the contractor in relation to work in question in respect of Harvard and Belon Harvard district on the date of cancellation of contract. So, in respect of the sites handed over on 24/9 in relation to Harvard district, the contractor at time 21/1995. To work and each site to work was completed by end of March 19 as stipulated in exhibit E1. The said letter has been admitted by the witness examined on behalf of Karnataka Housing Board. The said letter is supported by the chart in exhibit P1. The letter of cancellation of contract in question at exhibit P80 dated 22/7/92. No reasons are assigned as to why that the contracts were cancelled, except stating that the progress of the work was not satisfactory. But as discussed by me above, very much prior to the expiration of time stipulated for completion of the work in the question, the contracts in that regard have been cancelled. The contracts entered into between the Karnataka Housing Board and contractor exhibit P23. There is a stipulation for review by the chief engineer of the work done by the contractor monthly every 2 months. It is also stipulated therein that these reviews are in addition to the monthly reviews required to be done by the executive engineer. Clause 2C of the contract is stated. Progress of all work shall be reviewed by the executive engineer. The contractor in the first fortnight of every month. Such a review shall take into consideration the program fixed for the previous fortnight. It is also stipulated that the result of the review by the higher authority shall wherever necessary be incorporated in the subsequent review by the executive. Here in the case, and not even a scrap of paper is produced to show that such a review of the work of question was done by any of the engineers of the Karnataka Housing. Every fortnight or once in a month or once in 2 months. In this connection, the witnesses who have been examined and draft Karnataka would have categorically admitted that would have not produced any documents to show that such a review was done by any of the. So it's very close to show that for some extraneous consideration, the contract in question has been cancelled as rightly considered by the contractor. What has held back alert? The use of the word extraneous is significant. Therefore, for the opposite reason, it is very evident that it is the Karnataka Housing Board was submitted to the contract and not the contract. The reciprocal obligation that exists of the contract, Karnataka Housing Board should have responded to the request of the contractor and over the site well in time to the contractor to facilitate and to execute the work in question. Well in time, as created in the agreement, the board should have also offered necessary help to the contractor to remove obstacles if any by hand site. On the other hand, here, the officials of the board, by sitting in the chambers, must have made correspondence without taking into account the actual state of affairs that prevailed at the spot. Then they go on and also enter into a discussion on the law. And I come to these aspects in just a little bit. But the reason I spent some time reading the judgment of the honorable file, that everything that we have taken into account has been in some detail. Their allegation that my evidence has not been taken to me, their evidence has been taken is not true. They are taken into account everything. They refer to my exhibits, they refer to the document, they refer to their cross-examination. And cumulatively, they have come to the conclusion that so what is the cancellation of the agreement is concerned, that is invalid. And that is invalid for all of the reasons that and they given reference to various Supreme Court judgments, which again have not been controversial, so I'm not going to go into that. Now, coming to the contractual aspect. So this is the part that I've taken some time to go through what are the contracts say, what are the facts, how do the documents and ethics. Now I'm going to marry the two of them and just very briefly set out what are my conclusions. The very first thing I'm going to say is that the appellant, that is Karnataka, is in breach because they have terminated the agreement pre-mentioned. Now the cancellation is not in terms of the contract for any number of reasons, but most significant. One, cancellation could only have been done after a multi-stage that has not. In fact, that 7.5% which says that it has to exceed and the earnest that has to exceed. That works out to somewhere around 27,85,000. So first they should have imposed penalty of up to 27,85,000. Other may have voted them present, then they could have cancelled. Today, not a single rupee penalty. No single review has been done. That's what the court also below confirms. Therefore, because the procedure as set out in the contract has not been followed, the cancellation. Number two, the sites were not handled. And that is something I will spend a lot of time on. I'm not going to belabor it. Of the 18,000 odd sites that had to be handed over, a mere 206 plus 1,155, somewhere around 1,300 sites are handed over, and even their progress was made. And when you have not even handed over sites, and please note that separate work orders are issued for different constituencies. Let's say, for instance, for one constituency, they're given 80% of the site, none of it was. But let's say they're given it. They may have in that particular work order you have defaulted and cancel that work order. But where not even a single site has been handed over, how can they cancel the entire thing? And the fact that they're cancelling the entire thing is clearly evidence that it is for extraneous circumstance. So when sites are not handed over, time for completion cannot even have set to begin in these circumstances. Termination for alleged non-performance of contract cannot be sustained. But where sites were handed over, the cancellation is premature because we had 9 months excluding 3 months of monsoon. At the very least 6 months to complete the construction. As was argued, it does not take very much time because these are simple houses. We are not talking, these are low income group houses. But it made around Shavani, these are not houses which require months on end to construct. These are days that first construct. So that is why 6 months was held to be sufficient to construct 18,000 houses. Other than to solve money to run an article construct not right. So therefore, for them to say you are incapable of completing the contract, they must have come with some very reasons that is not good. Therefore, even in respect of those projects, the cancellation is premature. I have taken my logs to the relevant supporting documents. And therefore, my decision is a breach of contract, not a breach of contract. The termination.
That contract provides for this piecemeal cancellation.
My lord, it does not predictably take place. So far as Harvard is concerned, each is a separate contract. So there is no one overarching contract for. There are separate work orders, there are separate.
Work orders may be different, but contract?
Contract is part of the work order. There is no overarching work order. There is no umbrella contract. So it is not that there was one umbrella contract under which work orders were issued. Each district, each constituency was a separate work order. In Belgaum, there was one work order and
Work
contract.
orders will be issued, consequent to that contract.
No, the contract, there's a letter of intent. The letter of intent is regarding to district. Let's say Belgaum district and district, and Harvard district is single letter of intent. So two, there's one for Belgaum, one for Harvard. But the letter of intent is only a letter of intent. It's not actually a contract binding. The actual contract is separate for each constituency for Harvard. For Belgaum, it is one. So on. But in any event, my submission is not even a single work order, not even a single constituency terminated because none of them satisfy the requirements. Submission report is on all of that. The termination is easy. And that takes us to the next question, the breach of contract. You must prove breach, you must prove damage, and then you must prove causal link between the breach and damage. So what I will now move to the next phase. What is the consequence of this breach? Now, if you are now at a position where we say that there is a breach of contract, what is the damages that happens? I, my lords, have entered into this contract as a commercial entity to make profit. How much the profit I am supposed to make is, again, I will take you to the document which established. The profit that I was entitled to make, I was unable to make. I was entitled to get 15,000 rupees per house. That 15,000 rupees had a profit element. How to make that profit? Now, because of premature termination, I was deprived of earning that profit, and that is the damage that I suffered, and that is the damage that the lower court has awarded. So there again, they are in a plea, we are not in a plea. Now, what is this loss that I have suffered? For that, I kindly request you to look at the actual claim itself, volume 2, page number 3. The figure is at page number 10. Actually, my apology. This is a tool by the Karnataka Housing Board. My apology. Being to that page number 56. See, the same.
Some letter correspondence. It's with P48.
This is the volume 2 paper book 2. This is the pleadings, the pleadings table.
April
Judgment
15.
detail.
First volume.
Pleadings are
ಅವ್ರದ್ದು ಪೇಪರ್ ಬುಕ್ ಬೇರೆ ಮಾಡಿದ್ದಾರೆ.
part 1.
So there are two paper books. Then how do we refer to this? No, each one of you have given paper, separate paper books. Each one of you have given separate papers. Now we marked everything you argued in that case. In that
Yes, that is the document, that is the references I have made also. This
Correct.
is the pleadings bundle. There is, in fact, there are ತುಂಬಾ ದಪ್ಪ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿ separate books
Correct.
ಮಾಡಿದ್ದಾರೆ.
ಈಗ make one consolidation where we have to refer. Now, so far as this pleadings, we have to refer this paper book submitted by whom? Common paper book anta ಇದೆ.
This is common paper. That's at page number 72 of that.
Para 11, no?
Para 11M. The plaintiff estimates the damages suffered by it is 5 crore 36 lakh 38,077 rupees on account of, and this is the breakup, loss of profit at 15% of the aggregate contract value, excess of expenditure over the mobilization advance of rupees 61 lakh 29,750 rupees, and interest. Those are the three heads, my lords, that I have claimed. Now, the detailed breakup of this, my lords, is in volume 2.
First one, which you were
This
told,
one, the one that
which you were first referred.
volume 2 in part 2 of common paper.
Part 2.
Volume 2 part.
Just to be referred, no, that.
In this,
Breakups.
at page number 3 months. It says statement of plaintiff's claim for. Okay. This is a detailed breakup of how the 5 crore 36 lakh 38,077 has been arrived. Number 1, 15% profit on the contract value to the construction of 8,000 houses in Harvard district. There is a contract value of 12 crore 25 lakh 95,000. 15% of that is 1 crore 83 lakh 89,000. So I'm not claiming for the 50,000 rupees entire, because obviously our clients are a cutter. So I'm not asking for what I would spend. This is only the profit element, that is 15%. And where the 15% comes, I'll take my loss. 15% profit on the contract value, since contract value is 12 crores, that comes to 1.83. The next is expenditure incurred by the plaintiff on executing the work of the Harvard contract. That's 70 lakh 75,980. I justify each of these figures in just a minute. Now, of this, I received a mobilization advance of 61 lakhs. So the way the claim has been calculated is, if I had been given 15,000 rupees for every house, I would have recovered the cost and I would have made the profit. But now today, I have not spent that money, but I have been deferred. So the way I'm doing is, I'm recovering the loss of profit. That is the profit. The cost I would have incurred if I have been paid 15,000, but now that I have not been paid 15,000, I'm asking for the cost on 1:1 basis. If I spent 100 rupees, I'm asking for 100. There is no profit markup on this. Now that is 70 lakh 75,981 rupees, and I'll take you to where the numbers come. Of which mobilization advance are going to be there. Mobilization advance. So from that, I've deducted the mobilization advance. The outstanding amount is only 9,46,230. That one is respect to Harvard. Next is Belgaum. Belgaum, the amount of money spent is 23,68,152. And number 6 in note there, 15% profit on the contract value, which is 15 crores, which is about 2.33 crores. Those two are for Belgaum, 3 and 6. Then is interest on items 2 and 3 from the date of incurring till date. That's 10 lakhs. That of course, today is significantly higher. Then general damages on account of loss of business and loss of reputation of 75 lakhs. So now that 75 lakhs again, I will justify. But I just wanted, before going into the breakup of each single valuation and causation, I just wanted to set this out a little bit. Now, I will deal with the easier ones first, which is the 15%. Contract value is not disputed. On the 100 crore contract value, 108 crore contract value is not enough. So the only question is, what is the multiplier you apply on that? What is the profit margin that you apply? The Honorable Lower Court has applied correctly the profit margin of 15%, and where we get this 15%? At volume 2 paper book 2, which is the same bundle we have at exhibit P84, page 94. This, my lords, I'll just take it to the very next page. If you see the date of the document, 20th November 1991. So, contract award in the Munche. This is the estimate that we had proposed. Here you will see excavation issue, PCC issue, so on, so on, so on. But the relevant portion is, my lords, You see at the very end, 12,734. That is the total cost of construction. Per house. 15,000 rupees on a third day, and cost of 12,730. That gives us a profit margin in excess of 15%. So contemporaneous records show that this is the profit margin I was anticipating. And now we also have to look at this. This is in 1991. It was not as stable as society. The economy was not as stable. So you needed higher profit margins to make your business even viable. And we are talking about operating in remote lands in Belgaum and Harvard where there was no infrastructure. So this was necessary. So therefore, I only urge for us to be looking at it from a commercial lens in 1991. And this is what contemporaneous record. I'm not applying today's record. I think 1991, this is what they said was the profit margin that I want. Now, that comes to 5.107%. We are aiming a profit margin of 15%. 15.107%. We are aiming a profit margin of 15%, which is a profit margin of 2,266 rupees per house. So one the money cut the other profit per calculation. Now, while considering this claim, the learned trial court has gone through whether this is sustainable and they have referred to multiple judgments in their analysis. So far as this 15% is concerned, the learned trial court went through
I have 41 on it.
at page number, para 41. Para 41 is when they start analyzing the issue. The relevant discussion on 15% is at para 42, the very next paragraph. As regards the claim of the contractor regarding the loss of profit on the correct contract value, it is relevant and intended by the relevant counsel to the contractor that he is entitled to loss of profit at 15% of the agreed contract value. In this regard, he is invited the attention of this court to the ruling reported in AR 1977 SC 1481, wherein the Honorable Apex Court has upheld the judgment and decree passed by the trial court by setting aside the judgment and decree of the Honorable High Court regarding the award of damages at 15% of the correct value of the contract. Similarly, in the decision reported in AR 1984 SC, the Honorable Apex Court has held that Contract Act Section 73 work breach of contract is entitled to pay damages on basis of expected profit on balance works contract. Measure of damages depends on facts of each case. The facts of the case in hand and the one involved in the reported decision are each other. In the reported decision, the Honorable Apex Court has held that the contract is entitled to 15% of the balance of the price of work as damages in case of breach of contract. The review of the dictum resolved by the Honorable Apex Court in the above said decision, I'm of the view that the contractor in this case is justified in paying the damages at 15% on the net of loss of profit. If the contractor would have won at the time is a contract investment, it will be from the court. As already pointed out by me above, the contract was not allowed to complete in a portion of any situation. But on the question of 15%, one, the contract, the contemporaneous record says about 15.1%. Supreme Court judgments that the Honorable Trial Court has relied on, and we also have a compilation, also show that 15% is a reasonable amount of loss of profit to give, and especially in the case, like he said, in that Supreme Court case, there was exactly the same case of premature termination of the contract. They have held that price is the damage is the loss of profit at 15% of the contract value of balance. Because the entire work is balanced because not even a single invoice was raised by him, not a single payment was made. On that basis, our claim is for 15% of the contract value. We also set out our evidence technique, but I'm not going to go into it because I think the records are reasonably self-evident on that. We have also provided some updated significant judgments. The two specific judgments that I will discuss. What is the 1999 Now you some judgments may not have at the very end of month. So that is on loss of amount. 9% contract. Very simple, very straightforward. The next is the expenditure. Now, what I have said is that we incurred expenses on the project. If we had billed them, we would have been paid them. We could not bill because that threshold for billing was not achieved because of premature. So we are recovering the actual cost of performance. Now, what is the actual cost of performance? Now, the actual cost of performance, my lord, has been set out by a chartered accountant.
It's bit
Srivasan and Co. Chartered Account. Certificate. This is a certificate that Navika's builders has incurred an expenditure of 94,44,133 till 30th September 95 towards the cost of construction of low cost housing scheme and Telangana for Karnataka Housing Board. The details of expenses are here. We have verified the books of accounts, vouchers, etc. of the company, obtained the explanation as considered necessary. This witness allows us this statement was also subject to examination by the High Court, and they found no reason to doubt that. In fact, if you will see, if you go back to the including judgment, para 41. Para 41. The plaintiff has claimed the damages towards loss of profit and has also claimed rupees 5 crore 36,38,075 towards the loss, damage, and injury cost of the contractor. On account of breach of contractor report, loss of reputation interest. In this connection, on the contractor side, one Mr. B.K. Mathur and another S.K. Mathur are there. The evidence in which the related to the same facts have been narrated in the case. Regarding the breach of contract on part of the court and also regarding the loss incurred by the contractor to the premature company. It is also spoken to about the arrangements that were made to execute the work of the contractor side. In paragraph 27 of the affidavit filing with the exam, each is stated that the expenditure incurred by the contractor is between 94 lakh as per the account to maintain the against ledgers, playbooks, etc. as per exhibit P85 P93 to the relevant document have also been produced. And because the volume of those colors is not produced as part of the data, but it's part of the color. It is also spoken about exhibit P94 to 105, which are the vouchers to support the expenditure incurred by the contractor. It is also spoken about the audited financial statement for the year 1992 to 9596 as per exhibit P106 to 110. It is stated that these accounts are maintained regularly in the income service. It is also stated that these accounts have also been filed with the income tax authorities and the registrar of companies. Then he has a word about the chartered accountant certificate for the total expenditure of the project and bifurcation between Harvard and Telangana. Then he stated that at the time of executing the work pertaining to the suit contract, the contractor was not executing any other works. Further, he has also stated that all the entries in the account books produced as per exhibit so pertain to the suit contract. He has also stated that the work executed in the Harvard district have incurred an expense of 20 lakhs. He stated that after deducting the mobilization advance of 61 lakhs 29 paid for the board, still the loss about the contractor comes to 9 lakh 46,000. He has further stated that with regard to the contract in respect to the work in Belgaum district, the contractor has incurred an expenditure of 23 lakh 68,000. He stated that the contractor did not receive any mobilization advance in the work case in Belgaum, and therefore this expenditure is a loss cost of the contractor. The contract cancellation. He also spoken to about the arrangements made to execute the work, like establishment of 6 complete block making factories in Harvard and Belgaum, obtaining land in present town municipality, Haveri, conducting record land survey. In this regard, he got marked exhibit P26 to P32 and 40. He stated that the contractor, after the completion of the work has not raised any bill as per the contract. is further stated in the contractor could have raised the bill for 100%. It is also stated that since the contractor was not allowed to complete the work in the sites and the government, the contractor came to cancellation early, the contractor could not raise any bill. From these documents, this is clear that the contractor has incurred a considerable expenditure for making arrangements to execute the project and also to execute a part of the work in the site and handed over to the contractor. Therefore, they have the honorable trial court has gone through not just the certification, but also the underlying voucher, the underlying purchase order, and they said, yes, the number that you're saying is justified, and therefore, so far as those expenses are concerned, you will be entitled to recover because you could not recover it in your bills. Accordingly, the trial court granted that. Now, in respect to both of these are the most significant aspects of it. The one layer above that is the interest paid. Now, I come in reverse order. So far as the expenses are concerned, the honorable trial court has awarded interest at the rate of 18% per annum with respect to these expenses on the ground that it's a commercial contract. In a commercial contract, as commercial parties, you expect these, so therefore we give it. But so far as the loss of profit is concerned, the learned trial court has only granted 4% interest as compensation. Now, we have filed a cross objection against that judgment in the limited aspect of that 4%. We feel the 18% parity should be maintained between both loss of profits and the expenses incurred because the trial court has rightly held that 18% is the correct figure in a commercial contract. 6% has been awarded, not 4%.
So that is future prospects.
So
Future-
from the
future.
date of from the date of liability till the date of payment. This is there in the judgment.
From the date of the suit till its realization, pending suit. 6% is pending suit from the date of the suit till its realization.
That's correct. So far as loss of profit is concerned, the loss is calculated from the date of termination. From the date of termination till actual payment is split into two parts. From the date of termination till initiation of the proceedings, and from the date of the judgment till actual realization. You see now the judgment, impugn judgment at the order portion, which is very last portion. The suit in OS so and so are hereby dismissed. Suit in OS 11145 is hereby decreed as under. Plaintiff is entitled to recover a total sum of 4,61,38,077, together with interest at 18% per annum on ₹33,14,383 and 6% per annum on 4,17,56,000. So from the date of the suit till realization. And the justification for that is para 43. 2 pages before that. The contractor is claimed interest at 18% per annum. The contractor is claimed interest at 18% per annum. On the amount claimed in the claim, he is claimed interest only the actual expenses incurred by regard to the work in question at shown in item number 2 and 3. The contractor is justified in making in this regard because they spent the money for execution of the work in question by borrowing from outside. Since the transaction in question is commercial in nature, the contractor is justified in seeking interest at 18% per annum on the amount expended by him in the execution of the work in question. So they very clearly recognize that 18% per annum is a commercially reasonable rate of interest. Now, so far as the loss of profit is concerned, is that para 44 out para 44, which is at page 153, at the very last about 8 lines from the bottom. As regards the future rate of interest. Para 44, what 8 lines from the bottom. As regards the future rate of interest, I am of the view that the contractor is entitled for future interest at 18% per annum on 2 and 3 only from the date of the suit realization. With regard to claims at item number 1 and 6, the contractor is entitled for interest at 6% per annum only from the date of the suit realization. Hence, so they are not really explaining why only 6% is being granted for one portion of the claim, whereas 18% is being granted on the other portion of the claim, and which is why we are in appeal to this court as part of the cross objection.
The trial court says on other heads you had claimed 15% interest.
15% is the loss of profit.
You yourself had claimed 15%. Now you are saying 18% should be awarded.
We have claimed 18%.
Para 44, read para 44.
Yes.
Head of loss of profit at 15%. The contractor has
Loss of profit is 15% of the value of the contract. So the small distinction, the value of loss of profit is 15. On that amount, 18% per annum. This 15% is the lump sum value. 18% is per annum. That distinction the trial court is rightly made, that loss of profit is 50% contract. But on applying how much interest needs to be paid from that date to realization, they restricted it to 6%. And then I have some judgment that I will take my loss to show that in a commercial contract of this nature, 18% is an appropriate interest rate to apply.
whether your suit claim included that previous interest also in the date of the filing of the suit. Because you had filed the suit as an individual person.
That's it.
Your claim included the interest up to the date of the filing of the suit.
I don't immediately have to answer that. I'm allowed to get time to allow to check that. I don't waste time. I get the question, which is from the date of termination till the date of the suit, whether we have claimed interest. I understand the question, let me quickly check that.
Because now we question this awarding interest from the date of till realization.
Indeed, and because we only limited our appeal to that ground, the period from the date of termination to the date of the suit was not that significant. We are willing not to press that for the reason that it's 20-30 years since then. Now, more likely it could happen, it may not make that much difference. But I will confirm that based on the document and then get back.
If your claim was there, then it can be granted.
Very well. I will check it. Yeah.
Considered, not granted.
I am. Well, so far as so that is the two heads of claim that the trial court has allowed. There's another head of claim that the trial court has not allowed, which is the loss of reputation. No matter this, what I will submit is that so far as the issue of loss of reputation is concerned, which is the third claim of 75 lakhs that I have tried. There are a few things that I wish to highlight to this one people. And I will also identify some limitations in my own case because I need to be fair in my submission. As an officer of the court, I need to be candid in terms of where I have problems, where I have. So far as the claims of loss of profit, expenses are concerned, every single rupees are. Now, so far as the 75 lakh claim is concerned, this is based on what happened to me because of the termination. I am the fact that I filed an application as an initial person and it was allowed should reflect to the Supreme Court that I was not a company like Reliance, like Tata, like Adani, who had thousands of projects going on at that time. This for me was the only project that I had. And therefore, my entire sustenance as a company depended on this project. When therefore this project was awarded to me, I did not take up any other projects. This was the only project, this was the sole project. And the success of this project was crucial to the viability of me going forward as well. Now, given the scale of the contract, the respondent had devoted all its resources to this project. Next, because of what happened in project 1, I spent somewhere around 94 lakh as expenses, as evidenced by the chartered accountant. I wasn't paid for that. So I was out of pocket by 94 lakhs. Next, my bank guarantees were removed. And therefore, while of course the bank did not honor the bank guarantee, from a bank's perspective, I suffered a reputation loss that was irreparable. Because now I am now this guy whose bank guarantees will be invoked. And the invocation of bank guarantees led to further disablement and the respondent's creditworthiness was badly. And what that never meant was I was unable to continue business thereafter. And all of these facts were pleaded in my evidence. So what I essentially said is because of the repeated termination, yes, of course, I suffered loss on that. But because of it, I was not even able to do work post the termination. And I said that had the respondent been able to continue the business, it would have achieved a very minimum, a turnover of approximately 5 crore and a profit of 15% at about 75 lakhs. So that 75 lakhs is what I think. Now, so far as these figures are concerned, so far as the figure of 5 crore is concerned, so far as the figure of 75 lakhs is concerned, I am being as an officer of the court There are no documents saying that I will definitely make 5 crore revenue. There isn't. And we absolutely can. But what is definitely on record is the fact that the termination with the legal, the invocation happened, the fact that I was unable to do any other contract, and therefore that fundamentally hit my reputation. It is on that basis that we have made an estimation of 75 lakhs as being a reasonable estimate of the loss I have suffered over the years that followed the termination. Insofar as the cross-examination is concerned, that has not really been disputed. They simply said, have you had any records to produce it? No. So these are inherently the kind of claims for which you cannot have a record, because it's loss of reputation. Loss of reputation cannot, I can't do a, there won't be a chartered account and see the reputation of this company person. So, but given the contract that I had, which is this contract with the Karnataka Housing Board, my credibility in the market is evident, apparent in the face. And the fact that I was unable to do business is a matter of record, proven to evidence by witness testimony, and therefore I made the claim 75 lakhs, which is being disallowed by law. And here we are cross-objection, appealing against that as well. So that matter is the claims that have been before. I'm conscious of time. There are elements of their arguments that I need to address. So, for instance, they have taken defenses of jurisdiction, they have taken defenses of whether it's an arbitration clause, etc. I need some further time.
Then also we asked him, where do you file your suits?
Exactly.
Then you want to argue on that further.
No, in this case, I have my written arguments on that are very self-explanation. In fact, given a reference to a number of judgments also. So very quickly, literally 2 minutes. My case is very simple. The contract was awarded by Karnataka Housing Board Chairman Bangalore, admitted by the chairman. I read my reading. I paused to point out this contract awarded. The decision to terminate the contract was taken by Karnataka Housing Board Chairman in Bangalore. In fact, the Belgaum order says Chairman has told us now we have no option but to terminate. So clearly the decision was taken in Bangalore. The tender was floated in Bangalore. Veterinary publication happened in Bangalore, and a lot of the works, including several meetings and correspondences, a lot of procurements happened in Bangalore. So to that extent, Bangalore has jurisdiction to these matters. They have filed a suit as this counsel rightly pointed out exactly the same.
Yes, argued, so you want to reply.
No. Exactly for one minute.
What section 50 is where the cause of action arises, where any of the defendants reside.
Right. Very well.
You have to argue only about this 75 lakhs and the past interest.
In which case, those 2 elements, there's a couple of judgments that I want to rely on, which again.
First, you have to show us you had claimed that interest in your claim.
If I may be given no more than 10 minutes in the second half, I will take no more than 10 minutes. At the second half of the break, I will finish my argument. Okay.
He wanted to give a quick break for you and your colleague. Both are you are standing for such a long time. Why all of you are coming forward? Madam, your matter, your take up after this. 2:30 ಇವತ್ತು ಯಾವ್ದು ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ ಸ್ಟಾರ್ಟೆಡ್ ಇಲ್ಲ, ಹಾಗಾಗಿ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀವಿ. 2:30 ಅವ್ರಿಗೆ ಯಾರಿಗಾರ ಅಡ್ಜರ್ಮೆಂಟ್ ಬೇಕು ಅಂದ್ರೆ ಕೊಡ್ತೀವಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 11 in which list? First list, 7. Government advocate. 2010. We'll say only adjourned at request.
Serial number 9, my lord. Serial number 9. My lord, serial number.
One ನಿಮಿಷ. Your matter is adjourned. Yes.
Yes.
You wanted time, no?
My lord, serial number 9, my.
Adjourned at request. ನಾವು ಕೇಳೋದಿಲ್ವಾ ನಿಮ್ಗೆ ಏನ್ರಿ?
ಕೆಲಸ.
13 senior engagement ಇದೆಯಾ? ಯಾರು ಸೀನಿಯರ್? ಶ್ರೀವತ್ಸ ಅವತ್ತು ಹೇಳಿದಾರ ಅವ್ರು ನಿಮ್ಗೆ 13th ಹೇಗಿದೆ ಜಾಸ್ತಿ ಇದೆ ಅಂತೆ ಮತ್ತೆ ಈ ತರ ಆದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ? ಅರ್ಜೆಂಟ್ ಡೇಟ್ ರಿಕ್ವೆಸ್ಟ್ ನಿಮ್ಗೆ ಅವ್ರು ಯಾವ ಡೇಟಿಗೆ ಬರ್ತಾರೆ 13th ಬಿಟ್ಟು ಬೇರೆ ಡೇಟ್ ಯಾವ್ದಾರು ಹೇಳಿಬೇಕಂದ್ರೆ ಕೊಡ್ತೀವಿ. 14 ನಿಮ್ದು ಯಾವ್ದು?
Serial number 9, my lord. Any date?
ಆನ್ಲೈನ್ ಇದ್ದವ್ರು ನಮ್ಮ ಮೊದಲು ಮುಗಿಸೋಣ ಇದೆ ಇಲ್ಲಾಂದ್ರೆ ಅವ್ರು ದೇ ಕೀಪ್ ಇಂಟ್ರಪ್ಟಿಂಗ್. ಅವ್ರಿಗೆ ಪಾಪ ಇಲ್ಲಿ ಇಷ್ಟೊಂದು ಜನ ಇಂಥವ್ರಿಗೆ ಗೊತ್ತೇ ಆಗೋದಿಲ್ಲ. ನಾಗರಾಜ್ ಅವ್ರಗ ಎಸ್ ನಾಗರಾಜ್ ವಾಟ್ ಯು ವಾಂಟ್ ಇನ್ ದಿಸ್?
Any date, my lord, tomorrow or day after.
Yes, 9 urgent. Yes, sir. Serial number 7. There are several matters in this 7.
There are 6 of these.
2006. Huh? 1.4. ನಮ್ ಕೇಸ್ ಮುಗಿದ ತಕ್ಷಣ ಪಾಠಾಡಿರವ ಏನಾರ ನಾವು ಓದೋದಕ್ ಹಾಕಂದ್ರೆ ಕೆಲವೊಂದ್ಸರಿ ಹಾಕ್ತಾರೆ ಇಲ್ಲ ಅಂತಂದ್ರೆ ನಾವ್ ಇಟ್ಕೊಳ್ಳೋದಿಲ್ಲ ರೆಕಾರ್ಡ್ ಅಂತಾರೆ. ನೀವ್ ಹಂಗಂದ್ರೆ ಹೋಗಿ ಇಲ್ಲಿ ಬಂದು ಕ್ರಾಸ್ ಚೆಕ್ ಮಾಡ್ಬೇಕು. ಈಗ ಟೈಮ್ ಕೇಳುವಾಗ ಹೇಳ್ತೀರಾ ರೆಕಾರ್ಡ್ ಹೋಗಿಲ್ಲ ಅಂತ. ಎಲ್ಲಿ ಕೋರ್ಟ್ ಮುಂದ್ ಮಾಡಿದ್ರ? ಆಯ್ತು ಅಲ್ಲ ಈಗ ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದ್ದಲ್ಲ ಅವ್ರು ಯಾವಾಗ ಹೇಳ್ತಾರೆ ನಿಮ್ಗೆ ನಮ್ಮಲ್ಲಿ ರೆಕಾರ್ಡ್ ಬಂದಿಲ್ಲ ಅಂತ ಬಂದ್ ಕೇಳ್ಬೇಕು ಇಲ್ಲಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹತ್ರ. ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ ಏನ್ ಮಾಡಿದ್ರಿ ಅಂತ ವಿ ಡೋಂಟ್ ರಿಮೆಂಬರ್. ಪೇಪರ್ ಬುಕ್ ಹಾಕ್ಬೇಕು 2006. Your further, what do you say? He is seeking adjournment. Both of you are agreeable. Correct adri sir suit heavy iraddu 7 alla needful shall be done. ಒಂದ್ರಲ್ಲಿ ಮಾತ್ರ ಪೇಪರ್ ಬುಕ್ ಹಾಕಿಲ್ಲ. ಇನ್ RFA number 2149 of 2006 within 1 week. 1 week ಅಲ್ಲಿ ಹಾಕ್ತೀರಾ ಕಳಿಸ್ತೀವಿ ಫೈಲ್ within 10 days. List after 10 days. Okay. Number 9 ಹೇಳಿದ್ರಲ್ಲ ಎಕ್ಸಿಕ್ಯೂಟ್ ತಗೊಂಡ್ರಲ್ಲ ಆನ್ಲೈನ್ ನಲ್ಲಿ. ಹಾ ಹೇಳಿದ್ವಲ್ಲ ಅರ್ಜೆಂಟ್ ಅಂತ ಡೇಟ್ ಬೇಕಾ? 2010 2006 ವರೆಗೆ ಡೇಟ್ ಕೊಡ್ತಾ ಇಲ್ಲ. ಆಯ್ತು ಡೇಟ್ ಹೇಳಿ. ಆಸ್ ರಿಕ್ವೆಸ್ಟೆಡ್ ಬೈ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಕೌನ್ಸಿಲ್. ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ದೆ? ನಾಗರಾಜ್. ಅಪೆಲೆಂಟ್ಸ್ ಕೌನ್ಸಿಲ್ ಲಿಸ್ಟ್ 14. ಇವ್ರದ್ದೇನೋ ಆಫ್ಟರ್ನೂನ್ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ ಅವ್ರು ಮುಗಿದ್ಮೇಲೆ ನೋಡೋಣ. ಯಾರು ವನಜ ಅಂಡ್ ಆಯ್ತಮ್ಮ ಅವ್ರು ಮುಗಿಲಿ ಈಗ ಮಾಡ್ತಿರೋರ್ದು ಕರೆಕ್ಟ್ ಈಗ ಮಾಡ್ತಿರೋರ್ದು ಮುಗಿಲಿ ಮುಗಿದಾದ್ಮೇಲೆ ತಗೊಳ್ತೀವಿ.
ಯಾವ್ದಕ್ಕೆ?
ಇಲ್ಲ ಕ್ರಿಮಿನಲ್ ಅಲ್ಲ, ಇದು ಇತ್ತಲ್ಲ, ಅದಕ್ಕೆ ಯಾರು ಇದ್ರೆ ತಗೋತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಯಾವ್ದು ಅರ್ಜೆಂಟ್ ಮಾಡಿಲ್ಲ, ಹಂಗೆ ಇದೆ. ಕೇಳ್ದವ್ರು ಮಾತ್ರ ಅರ್ಜೆಂಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. 14 ಇದೆ. ಇದೆ. ವಸಂತ್, ಕೆ ವಸಂತ್ ಅವ್ರ ಹೆಸರು.
Yes. Serial number 8. First list, huh? List number 2. Serial number 8. Adjourned at the request of the appellant's counsel. Second list. Yes. In list 2 nalli the matters may not reach. Any of you are waiting because we are into parted matters. List number 2 nalli yaradru hearing ಇಲ್ಲ. Orders ನಲ್ಲಿ ಈ ಆರ್ಡರ್ಸ್ ಇದು ಕರಿಸ್ಬಿಡಿ ಲಿಸ್ಟ್ ಇದೆ. ಲಿಸ್ಟ್ ಏನಾಗಿದೆ? Issued R5 no? It is against activity. What are the offences? Yellide, where is the report? Submits the report. Police. According to the report, the fifth respondent not with traced. And the extension for execution of a warrant is sought. ಈಗ reissue ಮಾಡಬೇಕಾಗುತ್ತಲ್ಲ, warrant are returning. This is from which place? ಮಾದನಾಯಕನಹಳ್ಳಿ, ಬೆಂಗಳೂರು. ಲಾಸ್ಟ್ ಟೈಮ್ ಯಾರು ಸೀನಿಯರ್ ಆಫೀಸರ್ಸ್ ಥ್ರೂ ಹೋಗಿತ್ತ? ಇಲ್ಲ, ಅಲ್ಲಿ ಹೋದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗ್ತದೆ. ಅಂಚೆಪಾಳ್ಯ. Reissue non-available warrant against respondent number 5 for execution through Commissioner of Police, Bangalore. List down. Please.
29.
Connected yesterday.
8 objections with the second.
No representation for the appellant. 2 weeks time is 10.50 days. Admission in this
Number 3. N.R. Krishnappa.
As requested by the appellant's counsel, list after 1 week. Yes.
For admission, number 4. Mohammed Sahib.
Both of you were asked to give a list of 3 institutions. Why did you not file it in the registry? Our appellant's counsel. ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ, ಇಲ್ಲ ಅಂತಂದ್ರೆ ಚೆಕ್ ಮಾಡ್ಕೊಂಡು ಕಳಿಸ್ತಾರೆ. ರಿಜಿಸ್ಟರ್ ಫೈಲ್ ಮಾಡಿ. ಲಾಸ್ಟ್ as requested by both sides. Next week. Date ಕೊಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಮೂವ್ ಮಾಡ್ಕೊಂಡು. It will not do the needful. Once you remained absent and again moved the memo. Today I have not filed it in the registry. Date ಕೊಡಿ ಅಂತ ಹೇಳ್ತೀನಿ.
5. We left it.
Where who is for the other side? NCR ಬಂದ್ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಾ? ಅಡ್ಮಿಟ್ ಮಾಡಲ್ವಾ? ಇದು what is the offense? 498A and so the charge sheet was filed 306. Charge was framed for 6 only. Are you sure? You have the records?
Alternative 302 means.
Not to isn't. So if they frame the charge for 306 and right. Other request put in consideration, admit. Yes. We need to submit that I have one of one mill now there madam. I have one of 23. Maybe heard after the receipt of the TCS. Registration prepare a paper books within 4 weeks from the date of the receipt of the paper TCS. List after the receipt of the TCS. 38 years. ಬೇರೆ ಯಾರು ವೇಟ್ ಮಾಡ್ತಾ ಇದಾರಾ? ಪ್ರಮೋದ್ ಚಂದ್ರ, ಮಂಜುನಾಥ್. You are representing Pramod Chandra. ಇನ್ನೊಂದು ಹಾಕೊಳ್ಳೋಣ. As requested by the appellants counsel, list on. ಬಹುಶ ಆಗೋದಿಲ್ಲ, 2 ಮ್ಯಾಟರ್ ಕ್ಲಿಯರ್ ಮಾಡೋಕೆ ನಮ್ಮಷ್ಟು ಟೈಮ್ ಸರಿ ಹೋಗ್ಬಿಡುತ್ತೆ. Yes, 13.
Number 7, Manjunath.
No representation for the appellant adjourned. Right. First.
Number 1 matter, number 5.
We have not made for interest from cause of action to file of suit that we are not present.
Your cross objection was for that only.
No, cross objection.
Rate of interest.
From date of suit till actual payment, they are awarded 6%. I am seeking an enhancement to 18%. To that extent, my lord, there is no claim for pre-suit interest at all. As far as the claim for 18% is there, there's just a couple of documents that I had, and in fact, I'll actually take my lord to the CPC because that's where the power emanates. Section 34 of the CPC.
You can read that because basic.
Regular interest, where insofar as the decree for payment of money, the court may, in the decree, order interest at such rate as the court deems reasonable to be paid on the principal sum adjudged from the date of the suit to the date of decree. In addition to any interest adjudged on some principal sum for any period prior to the execution. So, with further interest at such rate not exceeding 6% per annum, the court deems reasonable on such principal sum. From the date of the decree to the date of payment or such early date as the court deems paid. Importantly, provided that where the liability in relation to the sum so adjudged has arisen out of a commercial transaction, the rate of that further interest may exceed 6% per annum, but shall not exceed the contractual rate of interest, or where there is no contractual rate, the rate at which monies are lent or advanced by nationalized banks in relation to commercial transaction. In the present case, my lords, the contract is silent as regards interest. If you will kindly see, my lords, our submission on the synopsis we have given the contention, the last page of that.
Submitted on
6 July 2018. There is a document called contentions with supporting
brief synopsis.
There is a separate one called
Yes.
contentions on behalf of the respondent.
Yes, got.
Yes, page 39.
That
is, my lords, extract from the State Bank of India, the nationalized bank relation interest in it. You will kindly see page number 41.
So, as on the date of the suit.
So 41, you will kindly see.
Page 41.
Page 41. So you will see, my lords, from 1991 in there. So at the time of termination, you will see, my lords, it was 18.5, 20%, 19%, 18%. That is the period at which the termination happened. So the interest prevailing as on that date was 18%.
It is lending rate or?
This is prime rate of lending. If you will see, my lords, at the first page 39.
So this section proviso refers to lending rate or?
Proviso rate Monies are lent or advanced by nationalized banks. Lent at the level.
Advance. Yes, both
Lent at the level.
rent or advance. Both advanced also means the same. Yes.
Lent or advanced. And we have provided the benchmark prime lending rate.
Hmm.
So therefore, my lord, as the relevant period of time, the prevailing rate of interest was approximately 18%. Now, in support of this, we've also
But
provided.
you have not led this evidence before the trial court.
My lord, it's there in the judgments that we provide. And I take my lord to the judgment, which is reflected there as well.
Had led the evidence to show that this is the lending rate.
My lord, based on judgments, we had let it, my lord. I'm not sure that the specific bank rate of interest was mentioned. But so far as the judgment
No,
are concerned,
anywhere in the evidence it had come that the prevailing lending rate was this much.
my lord, from the records I have seen it.
It's not
I'm submitting that credit. But what we had done, my lord,
because it is the first appeal. We can't take it like that on record. This chart you have given, this downloaded copy.
no, I understand, my lord. I will therefore substantiate the judgments, my lord, all of it say the same thing.
So when you filed the suit, it was 14%. Your suit was of the year 1997.
Suit was of year 1995.
His is 95.
95.
PVC is in 95. So 16.5%. No, we have to take it as on the date of the application. Indecent person's application.
My submission would be that it be taken as on the date of the termination, but at least as on the date of the filing of the indigent person application.
Now there is no question of taking it as on the date of the termination because you said you have not claimed pre-suit interest.
I understand. Right.
Otherwise, you should have paid the court fee and that also.
Very well. Yeah.
Now on the cross objection, you have paid the court fee.
Yes, ma'am. So what where it's being marked you have. In so far as the rate of interest, my lord, I just take my lord 2 or 3 judgments. The first one is in a comparison that we've just given. The judgment of ITC Seneca at page number 44. The relevant paragraph is that para 66. I mean, that page 66.
Yes.
Page 66, para 21. This my lord is the division bench judgment of this honorable court itself. That's the meeting the bench. Para 21. In the facts of the case, as the defendant had benefit of rupees 50,000 from the date it was received and it was not repaid even though the contract was terminated. They are liable to pay interest at the rate of 80%. As there is no agreement to pay the rate of interest, the plaintiff will be entitled to interest at the rate of 6% from the rate of payment. However, this amount is paid in connection with the commercial transaction. The interest from the date of suit till the date of payment would be at 18% as awarded by the trial court. So they make a distinction between pre-suit and post-suit. Post-suit, they say it should be 18% because it is a commercial suit and a commercial nature. The trial court has also admitted this matter. I read the portion of the trial, they said 18% is the correct sum. But so far as the loss of profit is concerned, they without explaining why they have adopted a different interest rate, they only adopted 6%. So our submission is that the same 18% must be applied across the board. There are a couple of other judgments in my synopsis. I'm not going to read that. I did say I will only take 5 to 10 minutes.
Right, if they are relevant, you can show us.
Right, then in which case I just take 2 minutes to. There is a list of citations that was filed earlier
On which point?
on rate of interest also.
See, one Supreme Court judgment or one High Court judgment which is relevant. No? A larger bench judgment, if it is there. Why do you want to multiply them?
No. The judgment that I gave was the division bench of this honorable court. There is a Supreme Court judgment. The Supreme Court judgment talks about the reasonableness of 18%. I just take it to that one judgment. The managing director and GMTA versus Mrs. Gudla Carpet. It was filed on. It was filed
Earlier compilation. You make one compilation.
People matter.
Yes.
In this judgment, at para 7, the very first judgment at page number 4. Para 7. This, however, does not take away the jurisdiction of the court to allow interest in the date on which the award is made, rule of the word, and so we are of the opinion that the case of the response will be allowed interest in the amount of. Coming to the question of the rate of interest, the agreement between the parties contemplates the interest to be applied by the respondent in a certain condition at the rate of 80% per annum. This matter is not applicable. The said rate, in our opinion, can be taken as a reasonable basis for fixing the rate of which interest to be awarded to the respondent for the simple reason that the applicant considers the rate to be recoverable. So the only reason I'm mentioning this is because we don't have a contract agreement. So the Supreme Court is saying that 18% is reasonable. And section 34 says the court can award reasonable interest. That's the limited extent to which we have relying on. Then, so these are the two judgments that I wanted to take note of, a revision bench and the Supreme Court judgment on this. The Malala submission is only for 2 or 3 small points of issue. There is an argument on bank guarantee that has been raised. There is an entire suit. I'm a respondent in that suit. That is on my part to make just 2 brief submissions of that. The bank guarantee Malala was invoked by the appellate upon terminating the contract. Now, so far as the invocation of the bank guarantee is concerned, before going to the invocation, if I may kindly request you to look at the bank guarantee itself.
Paper.
The bank guarantee in the body of the at page number 160.
Column 2, part 2.
Yes, column 2, part 2.
Page
Page 116. So this is the bank guarantee. State Bank of Hyderabad, now State Bank of India, had issued the bank guarantee. The key clause is at page 117. Paragraph. We State Bank of Hyderabad do hereby undertake to pay the amounts due and payable under this guarantee without any hearing of the demand from HB. This is the important part. Stating that the amount claimed is due by way of loss or damage caused or routine caused or suffered by KHP by reason of any breach by the said contractor of any terms of the conditions contained in the said agreement or by reason of the contractor's failure to perform the said agreement. So the invocation is dependent on a claim that must be made in a certain format, which is that they must state that there is loss and damage caused or it will be caused, or that there is a breach that will be suffered. That's the language of the bank guarantee. Now, the invocation method is at page 119. The invocation says the contract interested to methods Navika's builder for construction of houses, so and so input function were withdrawn under this office order. Therefore, requested to pay immediately an amount of rupees so and so. So there is no mention.
It's a copy of the cancellation contract is enclosed on it.
Yes, madam, but even the cancellation contract does not talk about any loss or damage suffered. So we read the cancellation order earlier, both the Vietnam and Apart. Neither of them make any reference to loss or damage suffered, although the invocation very clearly says that the invocation must say
breach. Loss of stating that loss or damage caused or will be caused by reason of any breach of contract. So the statement of breach of contract alone is not sufficient. We have to say that that has caused loss.
Very well.
According to you.
That's my meaning of this statement. Now, in any event, we are today at a stage where we are arguing the merits of the matter and whether or not loss has been suffered. So any invocation decision and whether or not the bank should have honored that cannot be divorced from what I already argued in the last 2 hours, my lord, as to whether or not there is a breach, whether or not there is a loss suffered. Because if today the court were to hold that the invocation must be done and the bank honors that invocation and pays the money, I have to pay the bank.
And that is still in force, that bank guarantee. That
it is not. So because the suit,
the suit itself has become infructuous now.
my lord, that is my submission. In fact,
that was for which duration? Bank guarantee?
bank guarantee was
6 months. So bank guarantee has lapsed now.
yes. Fact, my lord, the bank guarantee.
So they have sought damages also against you.
Because of the BGM.
Correct. So they have sought damages from you for not invoking bank guarantee.
Yes. And so far as I am concerned, I will say it is that I have no liability to pay. That's the limited extent which I want to make. I have learned from the bank to address the argument so far as the bank.
Again, when for that damages claim has to be considered if they have suffered damage. If they fail in their suit, when
by all this cannot be done. This is my solution.
if they succeed, then It has to be considered.
That's absolutely correct. The last two things I will say, my lords, is there is a list of citations that are given. I'm not going to take my lords through the entire thing. The first compilation, the earlier one, I just identify what propositions we have provided the judgments for.
Yeah.
First compilation.
The earlier compilation, the older looking compilation.
Idi.
But they've also extracted the relevant portion. The first three judgments are on interest. We've already addressed that. Then hint construction is the serial number 4 is on time not being of the essence of the contract. So here the contract provides for remedial measures, the contract provides for penalties, so time is not the essence of the contract. The subsequent judgments are on damages, and the one judgment I want to just pause a little bit is that serial number 6, 80 bridge falls in versus state of Gujarat. That, my lords, I already had an occasion to refer the trial court's judgment on this. What it essentially says is the quantification of damage, because I can read some arguments to say that even if damages were to be awarded, it must only be awarded on the houses they are actually constructed. My lords, that is not the law on the point, and that is not the consequence of termination. The judgment in 80 which falls in, my lords, at page number 36 of 36.
I have already referred to that.
I have already referred to what it essentially says is that
Expected profit.
and that profit must be calculated by reference to the balance value. That is the one expression for which I want to refer that. Here, the entirety of the work is balanced with more capital, and therefore, loss of profit must be calculated in the entirety and not on the basis of the houses constructed. Because if the houses are constructed and I only pay money, then there is no damage for termination because you are only giving me the money for constructing the houses. That is not the consequence of the breach. The consequence of the breach is that I will prevent it from gaining profit, and that's what this judgment says for the remainder of the value of the contract. Actually, number 7 is on adverse infringement documents of effect. That becomes relevant in this case because they have admitted in their evidence that they have records to show handover of sites, marking out of sites, inspection, progress report, none of which have been produced, and therefore adverse infringement. Then the next, serial number 8 is on damages. I'm not going to go into that. At 9, 10, 11, 12, 13, my lord, the 5 judgments that I have provided on jurisdiction. My lord, I'm not arguing that point because my lord, I've already heard, and I think the reality in their argument is evident. But the only point I wish to make is under section 21 of the CCC, even if there is a lack of jurisdiction, an appellate court can only consider lack of jurisdiction if there has been a substantive denial of justice at the trial court level. So even if this court were to come to the conclusion that yes, maybe Harvard or right now, the court must consider has there been a substantial failure of justice on that front. That's what these judgments point out. In our present case, they have read evidence, they have given documents, and therefore, even if there is no jurisdiction, this appellate court cannot overrule that.
Inherent lack of jurisdiction. That question arises if there is inherent lack of jurisdiction.
Absolutely. And that is primarily to do with subject matter jurisdiction. When it comes to territorial jurisdiction, there is no inherent lack of jurisdiction. That's what these judgments say. Then at 14 and 15, there's some general principles of damages, which again I don't want to trouble my lords because my lords are very familiar with that area of law. Now, the judgments that we have provided are the latest compilation. The first 2 judgments are again on jurisdiction. My lords, I don't want to make that point once more. The third one is on the question of jurisdiction on bank guarantee. Hindustan Construction versus State of Bihar, where the courts have held that a bank guarantee must be read strictly. And that goes to my argument to say that in this particular instance, the bank guarantee must have talked about loss. Then ITC Seneca, we've already talked about the interest at 80% of commercial transaction. There is also an argument that they trying to make in that appeal matters on whether it is an arbitration clause. I understand that an argument has not been canvassed in oral arguments. I'm not going to deal with that. 6 and 7. 6 is on condition for invoking bank guarantee and how to meet the adhered. And on the last judgment, KP Rangara, that the objection to jurisdiction must be taken at the very first instance and consequent failure of justice must be there. Neither of which are satisfied because when the payment was filed as an indigent person, at that time jurisdiction objection was not taken. In fact, they themselves filed the same court on jurisdiction. It was again afterthought that jurisdiction. That's the extent to which these compilations are relevant. The final 2 points, my lord, there is one document that I had read which
There was no issue regarding jurisdiction.
No, there was an issue regarding jurisdiction. The court answered it. they said that the court has jurisdiction and the
Hard by
objection
nature.
of jurisdiction was rejected.
There are different issues in different suits. In different suits, there are different issues.
That's correct, because in
Only
their,
in your suit that issue.
that's correct, because in their suit we take that objection. Now also they take it and the court said no, there is use. And so housekeeping, just two final points. There was one document that I had read about exhibit T11A, which is that Panchayat Karyalaya, they said that the sites are handed over and there was no date mentioned in that document. In the original, it has a date of 14 August 1992. The date is not very material to us, so it's consistent. I just wanted to say that I verified it and it has a date of 14 August. This is
118.
at page 109.
Mention. What is that date?
It is 14 August 1992. That is there in the original document.
Yes.
Fine, all of my arguments are set out in those two documents that I referred at the very start. There's one synopsis, which is a 9-page document, 10-page document. Then there is a slightly longer document which has all cross references to all exhibits and judgments that they're returning. There's just one judgment that is missed out because the bench office will allow us to write that judgment by hand in the synopsis. But with that, our arguments are on record. Like at the time, and also a very patient period.
Bank.
51.
211. ಅದು ಅವ್ರ ಅದ್ರೊಳಗಡೆ R1 ಮಾಡಿ.
Yes.
5.1 and 5.2. I have tried to reach now dates are given. The day before you. I have 211.
Yes. What?
But please. After all, I'd like to start where my friend stop. So I'm like,
Perhaps you need not repeat now.
that's what I'd like to just take it forward. So, is the bank and stand of the bank being that they facts are that the BGs were issued and that there was an implication of the bank actions. And as the implication was not as per the terms of the bank act, the bank refused payment of the bank. Thereafter, these two suits were filed against the bank. That is OS number 7462/95 and OS number 8665/95, which came to be dismissed by common judgment at 16/6/2008. Now, Your Honors, can I take Your Honors quickly to the hearings and the documents which I would like to bring to your reference.
Your suit was, suit against you was this, which 1255 or 1251?
I'm sorry, Your Honors.
Suit against you regarding the bank guarantee was OS 7462 or 86?
7462/95 and OS number 8665/95. Yes. Okay, Mr.
This is in which paper?
I would like to, if Your Honor, and permission, I would like to rely on the reference in the three paper books. One is part one of the common paper book, the green book, and volume 1 in part 2, and volume 2 in part 2.
Yes. Yes.
Please. May I, Your Honor, kindly quickly to the written statement of the first defendant. That is at page 12. In page 12 and OS number 7452, written statement of the first defendant. Now, read the relevant portions here. In page 13, paragraph 13, that sets out my defense. May I read from the same? The argument of this bar is denied. The defendant was not in a position to comply with the demand to honor the bank guarantees for the following reasons. A. the liability of the defendant under the four bonds was expressly limited up to 31/12/1992. A proper demand was required to be made before that. No valid or proper demand was made. The invocation letter dated 09/11/92 was not valid according to the terms of the bonds. B. The claim or demand is barred by invocation and became unenforceable. C. The grounds on which the invocation letter dated 9/11/92 was made was not on account of breach of contract by the second defendant and consequent loss or damage suffered by the plaintiff, but withdrawal of the contract. In the plaint now filed, allegations of breach of by the second defendant and suffering loss or damage has been made for the first time. No such grounds have been made out at the time earlier. There is contradiction of the stand taken by the plaintiff earlier on 9/11/1992 and now. There appears to be no nexus between the original ground and the invocation and no breach. Next, D. No breach of contract and loss and damage has been established or proved so far. The plaintiff allegations are all based on grounds of breach of contract committed by the second defendant. My friend, because as agents want to go through the terms of the packet at the cost of repeating myself, may I take the honors quickly do this because that is very relevant to my case.
Page number. Exhibit number.
It is easier. And read from volume 2 in part 1. Page 119, please.
6 is the bank.
116, and I tried that. 116 is the bank guarantee. P9, invoice number 3462. Now I read the relevant. The rest of the conditions. I'm reading from paragraph 2, page 116, page 116. May I continue, please?
Yes. Yes.
B. State Bank of Hyderabad. Do hereby undertake to pay the amount due and payable under this guarantee without any deadline, merely on the demand of the THB, stating that the amount claimed is due by way of loss or damage caused to or be caused to or suffered by the THB by reason of any breach by the said contractor of any of the terms or conditions contained in the said agreement or by reason of the contractor failure to perform the said agreement. Any such demand made on the bank shall be conclusive as regards the amount due and payable by the bank under this guarantee. However, all liability under this guarantee shall be restricted to an amount not exceeding rupees 8,67,000. Can I take a honest guidance to the invocation letters? Two invocation letters are there. One is at page 119. Exhibit P13 is here. This is a letter dated 9/11/1992. Sent by the THB to the manager State Bank of Hyderabad. My reading is letter dated 9/11/1992 from the THB to THB. Sir, subject construction of office under Rashtriya in Dharwad district by now because reference contract cancellation order number. The contract interested to the now because builders of private limited Bangalore for construction of houses under Rashtriya program in 4 constituencies, that is Andhra, Nilekuru, Raipur, Gandhi, were withdrawn under this office order number cited above. So therefore requested to pay immediately a sum of rupees so by demand draft towards advance paid to the said contractors against bank guarantees number 25/92, etc. Soon after receipt of the demand draft for rupees 34,64,500, the concerned bank guarantees will be returned to you. A copy of the cancellation contract order issued in this regard and reference made to contractor to refund advances enclosed for reference. That may I take your honor stand into the next letter, please. Invocation letter dated 22/12/1992. This is being produced at exhibit P10, invoice number 8665/95. This is from very similar terms. This is from THB to SBS. Subject invoking bank guarantees. Reference contract cancellation order number. From page in page 122, your honor. The contract interested to Such now we call Builders Private Limited Bangalore for construction of houses under Rashtraya and Dr. B.R. Ambedkar centenary celebration in 3 constituencies, that is Haveri, Sikari and Cheraki, are withdrawn under this office represented under reference above. Therefore, I, the undersigned, the experienced engineer, H.V. Vincent Pugli, representing the Karnataka Housing Board, hereby invoke the bank guarantees, namely so and so furnished by you, and the claims is herewith lodged accordingly. You are therefore requested to pay an amount of rupees 26 lakh 25 to 50 by demand draft, the amount covered under 3 bank guarantees herein, which is the amount due to the Karnataka Housing Board soon after the receipt of demand notice covering the 3 bank guarantees, the central bank guarantees to be given. Thereafter, the bank has sent a reply. A reply dated 14 March 1995. That I based upon your Honor's separate memo.
It's not there in the records.
It's not that we could not earlier we could not find it in the record.
No, it was not produced before the court.
Mark.
Is that exhibit number?
Exhibit 350 in OS number 7462 bar 95.
So it is not in any of these paper
It's
books.
not in the report. What is the report? Not finding it.
Right foot records. OS number 76, 7462.
7462 bar 95. Yes. Exhibit 3 15. 1.
Right, first we'll see in the.
Yes. 1.
Punch, last page.
Yes. Now give us so that if that is the same one, we'll continue.
Sorry.
Where is that the
This is letter dated 14th March 1995 from State Bank of Hyderabad, addressed to the executive engineer, Karnataka Housing Board, Hubli Division, Hubli. The reference number is F/PG/603. Is it the same?
yes,
May I proceed, Your Honor?
yes.
Yes, sir. Subject encashment of bank guarantee issued on behalf of Navavikas Builders Limited Bangalore. May I proceed, Your Honor?
Yes.
Please. We thank you for your letters 10/195 and 7/3/1995 requesting us to encash the bank guarantees of our constituents in view of the Honorable Supreme Court having vacated the stay order in respect of appeal number 2355/93. We have examined the copy of the judgment of the Supreme Court vacating the stay granted by the earlier and are found that there is no direction for the court to release the monies under the
Bank guarantee.
earlier the Honorable Court of High Court of Karnataka has observed bank guarantee was published in lieu of advances payable by the contractor or termination of the contract. The board is entitled to see unutilized amounts including bank guarantee. Bank guarantee was the nature of contractual power. It is not done by way of recovering damages. The invocation of the bank guarantee in terms of the guarantee to arise only when there is a loss or damage caused or be caused or suffered by you by reason of any breach by the said contractor or any of the terms of the contract or by reason of the contractor's failure to perform the said agreement. In these circumstances, and in the absence of a clear demand in terms of the bank guarantee, we are not in a position to comply with your demand. This consistent stand of the bank has been supported by PW1 and PW3 in their process. I take your Honor's kind attention to the scene.
What is the settled position of law? Whether they should prove the breach of underlying contract. We agree that invocation was not in that terms.
Yes.
That if that may be the defense, but they have not proved the breach of contract. That is not the ground for the rejection of this invocation or encashment.
Just a few minutes.
This is all the matter, no, in your case.
Yes,
They have not, now by this time they have lapsed.
yes.
When it was done, they had not, it was not in terms of the bank guarantee. You need not expand,
Was not in terms of the bank.
you need not expand beyond that, that the breach of contract was not proved, etc.
That is not the case. All I have the solution was BW1, who is finance manager, and BW3, executive engineer of the case. We agree with the case. I just take 2 minutes.
It means they had not stated so in their letter. That invocation letter, they had not stated so. They rely on these invocation documents, which are the exhibits.
In the process, in the process.
They can't go behind those documents on the entire denial.
They also say that the invocation was not as per the terms of the peace.
PWH,
One, please.
which paper?
I'm referring to volume 1 in part 2, which contains the reposition case.
Page number?
10, please, Your Honor. In page 10. Married from the same. PW1 is recalled and unit 1 and on 12/4/2002.
Yes, yes, yes.
Let's say top heading is OS number 7462/99. Please. He is a JK Caesar manager finance. So obviously he knows what he's talking. May I read from the same cross examination of 10.30 A.M. by advocate for D1. I am aware of the fact of the case on the basis of available records. I know the contents of exhibit P30. It is true that bank guarantees produced at exhibit 9 to 12 were enforced till 31/12/1992. It is true that the housing board could have enforced bank guarantee only in case of breach contract by the second defendant, now because builders, causing loss to housing board consequent to the breach of contract. It is true that housing board has revoked bank guarantee because contract was withdrawn from the second defendant. It is false to say that housing board has not revoked the bank guarantee for the reasons stated in the guarantees. It is false to say that I am not removing false things. How may I take a last kind attention to cross examination of three pieces. At page 35 pieces of the same book. May I proceed? Cross examination by T.A. Murphy for D1. This is of PW3, Mr. Mohammed Fayazuddin, executive engineer case. May I read from this content? I do not know the contents of bank guarantee and letter invocation. It is true that plaintiff had to invoke bank guarantee in case of damage or loss sustained by because of breach of contract by addressing the letter to concerned bank stating the above reasons or by stating that the contractor was unable to perform his obligation. It is false to say that the bank guarantee was incorrectly invoked by the plaintiff and that Bank of Hyderabad is justified in not making payment to the plaintiff. It is false to say that the first defendant is not liable to make any payment to the plaintiff in respect. Not your honor. It is one entity endorsed twice. That the invocation was not as per the terms of the BG. It is a separate contract between the parties. The bank and the case. So, I take another right attention to the might take your honest hand attention to the common judgment, where the learned court below answers this point in my opinion.
Exhibit P15.
Or paragraph number?
Paragraph 33 is here. I'm reading from the book, please, the bound book, read.
Paragraph number is correct.
Please, paragraph. Because there was some confusion.
Yes.
It start with now coming to the aspect of unification. My
Yes.
now, I mean, the previous paragraph, my friend has taken. Paragraph 53. Now, coming to the aspect of revocation of bank guarantee by the board. The reasons assigned by me Sutra regarding the illegal cancellation of the contract prematurely hold to this aspect also. As per the terms of the bank guarantees offered by the contractor to the bank in favor of the board, it is relevant to refer to one of the conditions of the bank guarantees. Since the bank guarantees offered by the contractor to the bank to the board are similar to each other, I'd like to refer to one of them as available at exhibit P9 at verse number 462 clause 2 of the said bank guarantee reads. Just now I have read through this thing and I skip the same. As already discussed by me above, the breach of contract is committed by the board and not by the contractor. If the contractor had sufficient time to execute the work in question, as per the terms of the contract, and after expiration of the said term, if the bank guarantees had been invoked, then the things would have been different. But it is not so. In this case, in this regard, the learned counsel appearing to the bank has invited my attention to the ruling reported in AR 1989, Calcutta 184. That note which is being held on. Performance guarantee issued with the bank. Enforcement of beneficiary must. As a quantum of loss and damages and mentioned a certain figure in letter of invocation. Invocation letter not in terms of bank guarantee cannot be enforced. I have gone through the said decision in detail. The facts involved in the said decision are similar to the facts involved in this case regarding the invocation for bank guarantee. What is held in the opposite decision is that the beneficiary must assess the quantum of loss and damages and mention the certain figure in the said invocation. It is further held that if the invocation letter is not in terms of bank guarantee, such a guarantee cannot be enforced. But importantly for me, this judgment has been overruled. So it is no longer good law.
It appears presently the law is that you cannot decide the breach of the underlying contract.
But
Only they have to make a statement. They have to state this in their invocation letter, that's all. But you cannot call upon them to prove the breach of underlying.
That is not like this.
So that,
Never been like this.
for that reason, this judgment might have been overruled. And that- underlying transaction and- So what is that judgment now we are referring to regarding this terms, invoking the bank guarantee in terms of the bank guarantee? Which state is it? Last it should be in accordance with that. Judgment, Supreme Court.
Okay. This is a part.
What was held? That the judgment. You wanted to show which that judgment where it was reversed. You wanted to show the
That has been overruled.
you wanted to show the judgment in which this judgment is overruled.
Oh, I just want to place it for you.
Yeah, fairly submitted that it is overruled.
Please. Now, I am looking for judgment which my other friend also quoted. This is Hindustan Construction Code of the state. This is very relevant to my case.
Hindustan construction.
Yes. This I find along with
You do have file.
I also find this during 2020.
It's the year of or citation.
1999 SEC 436. We have also furnished the same.
That's why we say you make one compilation only those which have relied, not the other ones which are redundant.
Very well. We need that in the next one.
First of all, the matter is very heavy. And if there is repetition, again
So
unnecessary.
we need a consolidated comparison with all of us. We compare it from the center.
Yes, it is there.
That's it here. I'm sorry. That is what was relied upon by the Senate and
It was
the
over.
judgment of the Supreme Court overruling that one. Both are. We can go to the side.
That this is Calcutta High Court judgment.
That's what I we can mention because the subsequent case will go. But the facts were different.
Overruled in. Okay.
Yes.
1995, no? Year 1995. Yes, yes.
I'm relying upon this Hindustan construction to state Bihar. It's very similar to the case of. I read from the head note case and the relevant paragraphs and just take 2 minutes.
Yes.
I'm reading from the head note to have your understanding. First page head note. Banker and customer, bank guarantee, nature and purpose. When encashing, when can court grant injunction against invocation of bank guarantee? Depends upon the terms of the bank guarantee, which are therefore very material. If bank guarantee is unconditional and unconditional, unconditional terms undertakes to pay the amount without any demur or objection, and irrespective of any dispute, court will refrain from issuing the injunction. But if bank guarantee is conditional, the beneficiary cannot have unfettered right to revoke the bank guarantee, and court can issue injunction against invocation of the bank guarantee in view of the facts. The relevant discussion in the same is that case sorry, para 930.
Yes.
I agree from the same.
Yes.
What is important therefore is the bank guarantee should be in unconditional terms, unconditional, and recite amount would be paid without demur or objection, and irrespective of any dispute that might have cropped up or might have been pending between the beneficiary under the bank guarantee or the person on whose behalf the guarantee was furnished. The terms of the bank guarantee are therefore extremely material. Since the bank guarantee represents an independent contract between the bank and the beneficiary, both the parties should be bound by the terms. The invocation therefore would have to be in accordance with the terms of the bank guarantee, or else the invocation itself would be banned. It comes up like this. And this has been upheld rightly.
So this was also referred before the trial. This is also referred by the trial court.
Yes, no.
Yes.
Right. Same para 13 and 14 can also be taken. The same point, but
The same thing. The same. It is here also. It's the same thing.
yes, I'm saying the same proposition. Specifically saying that just because it uses the word unconditional irrevocable is not determinative. If it creates conditions that have to be fulfilled, then it is a conditional bank guarantee. That's what the Supreme Court has said, just like in our bank guarantee. That's the purpose.
I have explained what is conditional and what is unconditional.
That's it.
But here there is no dispute that there is a condition.
And that's the meaning.
The condition of the contractor is rejected by the trial court.
Page number
Page number 35.
35. 1 second. It's been para here, sir.
Para 35. Number 6.
1 second. Yes.
Number 6.
Hi. Yes, sir.
The condition of the contractor guarantee and the which the board is claiming leave are in the place in the contract between the board and the bank. The further stated that contract is not party to such contract. It is also considered that the bank guarantees do not constitute joint guarantee and hence the no decree to be passed against the bank and the contractor and therefore the suit is not maintainable. But this argument of the contractor is forfeited because only the interest of the contractor, the bank has provided the bank guarantee to the board and security furnished by the contractor. Therefore, no does not lie in the mouth of the contractor to say that it is in no way concerned with the bank guarantee given by the bank in favor of the board. Therefore, the answer this issue is negative.
He did not argue at all this point. He did not say we are not concerned. He said the terms, the invocation was not in terms of the bank guarantee.
Bank guarantee is notified board not be led by them. The entire our assessment liability, what is the amount payable by them, the contract, bank guarantee amount. That is assessed by the housing board in tenders. You guys are assessed money. If bank guarantee, no contract is not applicable to the bank guarantee, we have to report that report. Interest rate is good, whatever the contractor or bank, not concerned to the bank guarantee. This is when the last report. Bank guarantee or no case, no clearly interest contract between contractor or bank is not concerned with bank guarantee. This is the word also used by the court. But in respect of the P50 referred to the father, now clearly last one. But if the contractor not get developed before the court and not any evidence, in the place there is no allegation of fraud by the board. That is material for significant that not the bank has not examined any test. Are made evidence before the court, are not create documents. Only the P54 we have marked that document by the P15, not by the bank. Therefore, the bank cannot deny the payment of the bank guarantee. But inspector might be the contractor argued for 2 times also. But all the documents record in Belgaum, the Dharwad district. There is no only our organization. Chairman discuss ಮಾಡ್ಕೊಟ್ಟಿದ್ರೆ ಲೆಟರ್ ಇಶ್ಯೂ ಮಾಡೋರು ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಏರಿಯಾ ಅದು ಕಾಂಟ್ರಾಕ್ಟ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದವರು ನಾಟ್ ಬೈ ದ ಕಮಿಷನರ್ ಆರ್ ಚೇರ್ಮನ್ ಓನ್ಲಿ ಕನ್ಸರ್ನ್ ಪ್ಲೇಟ್ ಕ್ಲೀನಿಂಗ್ ಮಾಡಿ ಹಿಸ್ ಪ್ಲೇಟ್ 1145/97 entire cleaning but there is no cleaning in the plate so that amount is before invested this 15 ಕೋಟಿ ಅಥವಾ 12 ಕೋಟಿ ಒಂದು ಸ್ಕೀಮ್ 15 ಕೋಟಿ ಚಿಲ್ಲರೆ but there is no assessment there is no reference or inspect of no such cleaning or proof produced before the time court by the contractor but inspect of 75 lakhs not taken the type of currency or page number in para number not para 45 in general para 45 the contractors create general damages on account of loss of business and reputation at rupees 75 lakhs. Right, item number 5. In this regard, some evidence that it will show that the contractor has suffered some loss. But financially and respectively on account of unilateral cancellation of contract in question. But when once the contract has been compensated with 50% of the value, contract in question towards the loss of profit in the relation to the work in question, respect of both districts, I do not think contractor is entitled to any general damages in that regard. If the contractor was involved in the work in question, it is entirely on the assumption that all the sites in question were handed over to them. Then the question of accepting other works from elsewhere does not arise at all. As far as the loss of reputation is concerned, I do not think that contractor is entitled for any damages in this regard. Moreover, no cogent and acceptable evidence is available to make such a claim. Hence, for this reason, I hold that contractor is entitled for the amount mentioned in item 6. The statement that 461 lakhs 38,077. But this granting 4,462 lakh of this purpose for reasons. But the evidence get by the contractor only class examination, no? 60 houses is constructed. Even assuming that there is no documents to show that 60 houses constructed, but that evidence is not considered by court. That evidence is not considered, and another witness scheme mark is not considered by the court. Only that my submitting that this judgment is required for consideration by remand court consideration plus consideration. By the considering this judgment and the evidence get by the contractor.
You don't. You make a compilation, proper compilation. Only for the purpose of submission of those compilations.
Judgment is by the contractor. Companion. Page number 16. This is 93 Supreme Court. In regarding the matter of class action, I have gone up on the judgment of my High Court that same Saugati contract was given, and no some corresponding value is not a ground for decree in this suit.
Listen, there should be some that level of maturity and you have filed the suit here, and now you are saying that their suit is not territorial. There is a bar of territorial jurisdiction. And first, you want us to hear you ours together on that point.
I am an advocate. Court has given case to file it. I have filed this in court.
You could have returned it saying that there is no territorial jurisdiction.
So ಹಾಗಾದ್ರೆ ಯಾರು
ಹಾಗಾದ್ರೆ ನಿಮ್ಮ appeal not maintainable because you have filed against your suit. The appeal which you have filed your suit, if you say that their suits were without jurisdiction, then your appeal also should be dismissed against your suit. ನೀವು ಒಂದು ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಅದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಇನ್ನೊಬ್ರು ಅದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಅವ್ರ ಸೂಟ್ ಮಾತ್ರ ಬಾಡ್ ಬೈ ಟೈಮ್, ನನ್ನ ಸೂಟ್ ಸಾರಿ ಬಾಡ್ ಬೈ jurisdiction. ಅಡ್ವೊಕೇಟ್ ಇರೋದು ಬರೀ ಪೋಸ್ಟ್ ಆಫೀಸ್ ಮಾಡೋದಕ್ಕಲ್ಲ, ಅವ್ರ ಏನಾರು ತಗೊಂಡ್ಬಂದ್ರೆ ಅದ್ರ ಲಾ ಏನಿದೆ ಅಂತ ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು. ಕೋರ್ಟ್ನವ್ರಿಗೆ so that you are not representing a layman, you are representing a statutory body. ಕೋರ್ಟ್ನವ್ರಿಗೆ ಅದು jurisdiction ಇಲ್ಲ ಅಂದ್ರೆ ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ. Yes. Yes, 93 Supreme Court.
Number 16. 93 two Supreme Court cases, 130 pages. In RSTV, Finance and Limited and C.
What?
Glass Workers Limited. Section 20. Jurisdiction transaction where arises amount deposit is paid to the company project bank at Bombay, and the same deposit in the bank account is divided from in the Bombay branch of Cargo. Deposit receipt issued by dividend is enlarged subject to Anand Gujarat decision. Effect that court dated checks payable to native at Bombay issued by dividend is Anand Bank facility. So filed in Bombay on the basis of deposit receipt as well as disorder check. So that transaction allowed in Bombay, hence the Bombay court has to entertain suit. Enlargement is deposit receipt absence of any outer executive clause would not exclude the jurisdiction of the courts otherwise competent to entertain suit. Maximum expressly initial exclude is not applicable. Transaction had arisen in Bombay, a course of itself was paid through the check And we have a
See, you should not read the entire judgment. Ratio ಏನಿದೆ ಅಷ್ಟೇ ಹೇಳ್ಬೇಕಾದ್ರಲ್ಲಿ.
receiver cancel ಮಾಡಬೇಕು
Yes, 25.
page number paragraph 18 19. 18 cancel ಮಾಡಿ activity 21 ಮಾಡಬೇಕು. Result of the above discussion that Gujarat legislature is not competent to regulate, modify existing application and where it is incurred in the relief undertaking declared such as under section 3 of Bombay and outside the state of Gujarat, not can be suspended or there is clear supervision. Therefore, ಮಾಡಬೇಕು paragraph 22 ಮಾಡಬೇಕು. In the result, we allow the appearance exercise the result of the High Court dated 24/91 and restore the result of the power of the single judge and 24 dated to case made to order cast only 55 where the High Court must exercise the order and restore now ಈ ಕೇಸಲ್ಲಿ ಈ involve the non concession of evidence and the process of contact to this court has no
Are you not stopped from taking up that contention?
but I mean
ನಿಮ್ಗೆ ಅರ್ಥನೂ ಆಗೋದಿಲ್ವಲ್ಲ ಅದು ನಿಮ್ಗೆ.
ನೀವು ಸೂಟಿಗೆ ನೀವು ಅಲ್ಲೇ ಹೋಗಿ ಸೂಟ್ ಹಾಕಿದ್ರಿ. Are you not stopped from taking up that contention before in the appeal?
ಎಷ್ಟು rude, I mean, rude way ದಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ party
ನಿಮಗೆ ಅದು ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ. Your board ಗೆ ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ. I am asking you about the board. KHB ಗೆ you are representing KHB. KHB goes and files a suit there only. Are you not stopped from taking up that contention in the other suit? ಈಗ ನೀವು ಆ ಕಂಟೆನ್ಷನ್ ಅನ್ನ ತಗೊಳಕ್ಕೆ ನೀವು WS ನಲ್ಲಿ WS ನಲ್ಲಿ ಮಾಡಿರಿ. ನೀವು ಮತ್ತೆ ನೀವು ಹೋಗಿ ನಿಮ್ ಸೂತ್ರನಲ್ಲೇ ಹಾಕ್ತಿರಲ್ಲ.
You
7462
you take all this. See, unnecessary.
ಅದನ್ನ ನೀವು ಅಲ್ಲಿ ಹಾಕ್ಬೇಕಾಗಿತ್ತು. ಅಲ್ಲ ಹಂಗ್ಯಾಕ್ ಮಾಡ್ಬೇಕು, ನಾವ್ಯಾಕ್ ಮಾಡಕ್ ಹೋಗೋಣ? ನೀವು ಕೋರ್ಟಿಗೆ ಬಂದವ್ರು ನೀವು.
Advocates ಗೆ ಏನ್ ಕೆಲಸ?
ಹೌದು, ನೀವು ಕೋರ್ಟಿಗೆ ಬಂದವ್ರು. ಈಗ ನೀವು ಮಾಡಿದ್ದು ತಪ್ಪು ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಮಾಡ್ತೀವಿ.
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಅಲ್ಲ ಅಂದ್ರೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಲಾ ಓದೋದು ಬೇಡ, ಏನು ಮಾಡೋದು ಬೇಡವಾ? ಕೋರ್ಟೆ ಮಾಡ್ಬೇಕಾ ಎಲ್ಲಾನು? ನಾನ್ ಕೋರ್ಟಿಗೆ ಹಾಕಿದೀನಿ, ನೀವೇನ್ ಬೇಕು ನೀವು ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಆರ್ಡರ್ 7 ರೂಲ್ ಅಲ್ವಾ? ವಾಟ್ ಇಸ್ ದಿಸ್? ಅಲ್ಲ ಇದು ಏನು ಎಕ್ಸಾಮ್ ಬಂದು ಪಾಸ್ ಆಗಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋ ಅಡ್ವೊಕೇಟ್ಸ್ ಬೇರೆ, ಇದನ್ ಮಾಡದೇ ಇರೋರು ಬೇರೆ ಇರ್ತಾರ. ಮತ್ತೆ ನಾವು ಪೇಷಂಟ್ಲಿ ಕೇಳ್ತೀವಂತ ದೇರ್ ಶುಡ್ ಬಿ ಸಮ್ ಲಿಮಿಟ್ ಫಾರ್ ದಟ್. ನಿಮ್ಗಿಂತ ಹಿಂದೆ ನೋಡಿ ಅಲ್ಲಿ ಎಷ್ಟೊಂದು ವಯಸ್ಸಾದವ್ರು ಅವ್ರ ಕೇಸಿಗೆ ವೇಟ್ ಮಾಡ್ಕೊಂಡು ಕುತ್ಕೊಂಡಿದ್ದಾರೆ. ಒಂದ್ ಪಾಯಿಂಟ್ ಮೇಲೆ ಹೇಳಿದ್ರೆ ಅದು ಮುಗಿದೋಯ್ತು. ಅಂಡ್ ಯು ಶುಡ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದಟ್ you file a suit before the same court, and if the other side file a suit before the same court, you say it had no jurisdiction. And now next arguments, height of this ignorance, what should we call it? Now file ಮಾಡೋದು ಮಾಡಿರ್ತೀವಿ, court no return ಮಾಡ್ಬೇಕಾಗಿತ್ತು. what job advocate had then? Sorry.
CPC ಇನ್ನೂ ಇದೆ.
ಅವ್ರದ್ದು ಜಡ್ಜ್ಮೆಂಟ್ಸ್ 2 ಕಂಪೈಲೇಷನ್.
ಬಟ್ ನಿಮ್ದು ಕಂಪೈಲೇಷನ್ ಎಲ್ಲ ತಗೊಂಡು ಸಿಂಗಲ್ ಕಂಪೈಲೇಷನ್ ಮಾಡಿ ಕೊಡಿ. Present. Yes.
Section 8, section 10 will not, because that rule 1 says that there is more than one wife. Below the gate will not, one share. Altogether, take a one share.
No, he had effected partition during his lifetime only. He had taken it to his share.
That is issue property. Emergency take altogether take one. If you want to take each.
Two widows together take one share.
You can second and rule 1.
What is it? Succession Act. You are only to that extent. You are grievance.
Regarding finding of B of the trial court. Finding government of care.
You are referring to section 8, no?
Section 8 ready, section 10. Rule 1.
Section 10 and rule 1. Subsection.
Settled property of the
Yes, last one, distribution of property. So now the trial court has given
not
to
any share to the wives. They have taken and taken.
Kottail.
Okay, wives share
But you represent defend number 11,
11.
not the, you are the son of daughter of from the first wife. So share vary ಆಗುತ್ತೆ ಅಂತ. So first that has to be allotted to them, then again that devolves on the when the suit was filed, both of them were not alive. They were not alive. Now your submission is that has to be together, one share has to be given. Then again that has to be divided 50-50. And accordingly their shares. They should be given to the share of the children of each branch. ಎಷ್ಟು ವ್ಯತ್ಯಾಸ ಆಗುತ್ತೆ ಹಾಗೆ ಮಾಡಿದಾಗ? How many children he had from the first wife and they take along with the children, alva? See, how many children he had? 8 plus. So 18 children. 18 children, ಆಮೇಲೆ ಒಂದು ವಿಡೋ ಅವಾಗ 19 ಆಗುತ್ತೆ. ಅಂದ್ರೆ they have to be treated as one. 19 ಆಗುತ್ತೆ. So they take 1/19 share. Again that 1/19 has to be multiplied. ಎಷ್ಟು ಅದೇ
16 children.
18 children. ಈಗ both widows together 1 ಅಂತ ತಿಳ್ಕೋಬೇಕು. 1/19 share they will get. 1/19 by 2 ಎಷ್ಟಾಗುತ್ತೆ? 38. 1/38. Again that 1/38 has to be divided amongst these many children. Correct. Your branch ಈಗ partition daughters had filed the suit. ಮತ್ತೆ ಅವ್ರ ಶೇರ್ ಅನ್ನ ಡಿವೈಡ್ ಮಾಡಿ ಅಷ್ಟು ಅವ್ರಿಗೆ
ಇದ್ರಲ್ಲಿ ಸೇರಿಸದೇ ಇರೋರು ಯಾರು ಮಕ್ಕಳು?
ಸರಸ್ವತಿ ಮಕ್ಕಳು ಸೇರಿಸಿದ್ರು.
ಅವ್ರು ಇನ್ನಿಬ್ರು ಇದಾರ?
1, 2, 3, 4, 5, 6, 7, 8. 8 children are made parties. ಅಲ್ಲ ಸರಸ್ವತಿ ನೀವು ಇನ್ನೇದ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ ಪಿಡಿಗ್ರಿನ ಅದರಲ್ಲಿ ಸರಸ್ವತಿ ಅವ್ರ ಮಕ್ಕಳನ್ನೇ 8 ಜನರನ್ನ ತೋರಿಸಿದೀರಾ 5 + 3. ಯಾರವರು ಹೆಸರೇನು? ರಾಜಲಕ್ಷ್ಮಿ. ನೀವೀಗ ಇಲ್ಲೊಂದು ಇದನ್ನ ಕೊಟ್ಟಿದ್ದೀರಾ ಏನು ಪಿಡಿಗ್ರಿ ಅಂತ ಕೊಟ್ಟಿದ್ದೀರಾ ಅದ್ರಲ್ಲಿ ರಾಜಲಕ್ಷ್ಮಿ ಹೆಸರೇ ಇಲ್ವಲ್ಲ ಇದ್ರಲ್ಲಿ ತೋರಿಸಿಲ್ಲ. ಇಲ್ಲ ನಮ್ಮ ರೆಫರೆನ್ಸ್ ಕೊಟ್ಟಿರೋದಲ್ವಾ ಇದು? ಯಾರು ಕೊಟ್ಟಿದ್ದೀರಿ ಇದನ್ನ? ನೀವೇ ಕೊಟ್ಟಿದ್ರಾ?
ಅಲ್ಲಿ ಹಾಕಿದಾರೆ ನಮ್ಮ ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಒಂದಿದೆ ಅಲಾಂಗ್ ವಿತ್ ಸಿನಾಪ್ಸಿಸ್
ಬಸ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಹಾ ರಾಜಲಕ್ಷ್ಮಿ ಅಂಡ್ ಇನ್ಫ್ಯಾಕ್ಟ್ ನೀವು ಅದನ್ನು ಇದೆ ಇದು ಯಾರು ಕೊಟ್ಟಿರೋದು? ಹೂ ಹ್ಯಾಸ್ ಸಬ್ಮಿಟೆಡ್ ದಿಸ್ ಸಿನಾಪ್ಸಿಸ್? ಸುಬ್ರಹ್ಮಣ್ಯ. ನೀವೇ ಅಲ್ಲ ಮತ್ತೆ ನೀವು ಕೊಟ್ಟಿಲ್ವಲ್ಲ? ಅಲ್ಲ ಈಗ ನೀವ್ ಹೇಳ್ತಾರೆ ದಿಸ್ ಇಸ್ ಸಿನಾಪ್ಸಿಸ್ ಇನ್ ಯುವರ್ ದಿಸ್ ಥಿಂಗ್. ಇಟ್ ಈಸ್ ನಾಟ್ ದ ಎಕ್ಸಿಬಿಟ್ ಕಾಪಿ ಆಫ್ ದ ಎಕ್ಸಿಬಿಟ್. ಮತ್ತೆ ಈಗ ಎಲ್ಲಿದೆ ನಿಮ್ದು ಎಲ್ಲ ಮಕ್ಕಳು? 875 ಇದೇ ಪೇಪರ್ ಅಲ್ಲ ಇಲ್ಲ. Along with the written statement you had filed it? Yes.
75 has observed that 2 other daughters.
Sir, ನೀವು ಬಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ನೀವು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದಾಗ ನೀವು ಯು ಡಿ ನಾಟ್ ಗಿವ್ ದ ಸಪರೇಟ್ ದಿಸ್ ಥಿಂಗ್ ಅವ್ರಿಗೆ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿ ಕೊಟ್ರಿ ನೀವಾದ್ರೂ ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿ ಇನ್ನೊಂದು ಕೊಡ್ಬೋದಿತ್ತಲ್ಲ.
ನರಸಿಂಹನವ್ರು ಕೊಟ್ಟಿರೋದ್ರ ಒಳಗಡೆ ಇದೆ ಅಂತ ಮೇಡಮ್.
ನರಸಿಂಹನ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ರು ಅಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅಷ್ಟು.
ಇಲ್ಲಿ ಇಲ್ಲೊಂದು ಕೆಳಗಡೆ ಇದೆ ಮೇಡಮ್ ನೋಡಿ ಜೊತೆ ಎರಡು
Page number? Page number. Yes. ರಾಜಲಕ್ಷ್ಮಿ and yes, not a party ಅಂತಾನು ತೋರಿಸಿ. ಎಸ್ ಅಷ್ಟೆಲ್ಲ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಅಗೇನ್ ದಿಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡಿವೈಡೆಡ್ ಅಮಂಗ್ಸ್ಟ್ 18 ಪೀಪಲ್. ಅದು ಸ್ವಲ್ಪ ವ್ಯತ್ಯಾಸ ಆಗ್ಬೋದು, ಒಬ್ರಿಗೆ ಜಾಸ್ತಿ ಮಕ್ಕಳಿದ್ದಾರೆ ಒಬ್ರಿಗೆ ಕಡಿಮೆ ಇದ್ದಾರೆ. ಎಸ್
regarding nature of the property, we have taken the contention that on the property of the property of the dash income, therefore we are entitled to equal share. The trial court held that it is a ancestral property.
ancestral ಅಲ್ಲ joint family property ಅಂತ. No, what is said in that partition deed of 1961? 61 partition deed ಅಲ್ಲಿ ಏನಂತ ಹೇಳಿದ್ದಾರೆ? He treated it as a joint family. It's a joint family property. So when you are claiming through Daya Shankar or Daya Shankar, then whatever he has stated binds you. Page number ಎಷ್ಟರಲ್ಲಿ ಇದೆ partition deed? Exhibit ಎಷ್ಟದು? T12 299 page. It's typed copy only. ನಮ್ಮ ಒಟ್ಟು ಕುಟುಂಬದ ಉಪಯೋಗಕ್ಕೂ ಮತ್ತು ಬೆಳವಣಿಗೆಗೂ ಬಹಳಷ್ಟು ಅಭಿವೃದ್ಧಿ ಪಡಿಸಿ ತಮ್ಮ ಮಕ್ಕಳು ಪತ್ನಿಯವರಿಗೆ ಇದುವರೆಗೆ ಪೋಷಣೆ ಮಾಡುತ್ತಾ ಬಂದಿರುವರು.
ಇಂಗಾಡಿ ನರಸಿಂಹ ಯಾರ ಮಕ್ಕಳಾದ ಇಂಗಾಡಿ ದಯಾಶಂಕರ್ ರಾವ್
ತಮ್ಮ ಪಿತ್ರಾರ್ಜಿತ ಆಸ್ತಿಯನ್ನು
ನಮ್ಮ ತಂದೆ ಕಾಲೇಜಲ್ಲಿ 1999 ಮಾಡಿದ ವಿಭಾಗ ಒಂದು ಏನ್ ಕರೀತಾರೆ ಈ ಕಾಲದಲ್ಲಿ ಟ್ರೈಲ್ಕೋರ್ಟ್ ಅವರು ಏನ್ ಮಾಡಿದ್ರು ಇದೇನೆ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಪ್ರಾಪರ್ಟಿ ಮಾಡೋದು ಬಟ್ ದಿ ಡಿಪೆಂಡೆಂಟ್ಸ್ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ 1935 unregistered settlement deed in that is unregistered and inadmissible. Therefore, it is not.
ಅದು ಬಿಟ್ಬಿಡಿ. ಈಗ you are claiming through Dayashankar.
Yes.
You admit this document. Even assuming that if it was his self-acquired property, when he effects partition, expressing his intention that he wants to treat it as a joint family property, or he throws it into the common hush pot, then it becomes joint family property only. Children.
That is not
So
considered.
you claim through Dayashankar only.
That is why it
So
will become. Then otherwise it will become joint family property only. But Tripod has not considered it. That is what the petition. Helpful has said that despite this
It
evidence.
is a self-acquired property.
Ancestral property will not. Tripod no.
ಎರಡಾದ್ರೂ ಒಂದೇ ಬರ್ತಿತ್ತಲ್ವಾ ಶೇರಿಂಗ್ ancestral property ಆದ್ರೂ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ವರ್ಡ್ಸ್ ಮೇ ಬಿ ಲೂಸ್ಲಿ ಯೂಸ್ಡ್
Only that way. Tripod the concluded that. Therefore, the daughter and wife have no share of product. For wife and daughter have no.
Now, after Vinita Sharma and amendment, whether it is the self-acquired property, whether it is the ancestral property, it makes no difference.
Not made. That is our position. That is our position.
Because daughters are also the co-partners.
ಅದನ್ನೇ ಈಗ ಕೊಪ್ಪರ್ಸನ್ಸ್ ಆಗ್ತಾರೆ ಇವ್ರಿಗೆ ಏನೋ ಲಾಸು ಆಗ್ಲಿಲ್ವಲ್ಲ ಅವ್ರು ancestral property ಅಂದ್ರೆ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಅಂದ್ರೆ ಎರಡರಲ್ಲೂ they were entitled to a share. See, even
So
if
now-
they say ancestral or joint family, whatever it may be, you are entitled to a share. According to, then what difference it makes?
Even though they were there, section 6.
ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ಅವಾಗ ಯಾಕಂದ್ರೆ ಅವಾಗ ಲಾ ಬೇರೆ ಇತ್ತು.
Ah,
When the judgment was rendered,
But they are not applied.
ಅಲ್ಲ, this judgment is rendered in which year?
2010.
ಹಾ, ಅವಾಗ ವಿನಿತಾ ಶರ್ಮಾ ಜಡ್ಜ್ಮೆಂಟ್ ಬಂದಿತ್ತ?
But there are different.
Yeah.
High court statements are there. It is for.
ಅದೇ ನಮ್ದು ರೆಟ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಆಪರೇಷನ್ ಅಂತ ಇತ್ತು ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಇಂದ. ಜಡ್ಜ್ಮೆಂಟ್ ಆಗುತ್ತಲ್ಲ ಪುಷ್ಪಾವತಿ
Padma versus.
ಪೂಲಾವತಿ ವರ್ಸಸ್
ಅಲ್ಲ ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
ಅಲ್ಲ
ಪದ್ಮಾವತಿ.
ನಮ್ಮಲ್ಲಿಂದನೇ ಪೂಲಾವತಿ ಕೇಸ್ ಆಲ್ಸೋ ಫ್ರಮ್ ಕರ್ನಾಟಕ ಬೆಳಗಾವ್ ಪ್ಲೇಸ್ ಇಂದನೇ. ಸೊ ದೇರ್ ಆಲ್ಸೋ ಇಟ್ ವಾಸ್
1961 document is there. That document is concluded partition is there. Therefore, under the provision of the section 6.
ಕರೆಕ್ಟ್. ನಿಮ್ಮ ಅಪೀಲ್ ಅಷ್ಟರ ಮಟ್ಟಿಗೆ ಮಾತ್ರ ತಾನೆ.
ಅದು ಈಗ
Depend on-
regarding the schedule A, C, E were not mission that they are
ಶೆಡ್ಯೂಲ್ ಎ ಸಿ ಬಿ ಅಂದ್ರೆ ಯಾವ್ದದು? Because there was one more property where one brother claims that ಅದೇ ಸೇವಿಂಗ್ಸ್ ಡೆಪಾಸಿಟ್ ಸೇವಿಂಗ್ಸ್ ಡಿಪಾಸಿಟ್ಸ್ ಎಲ್ಲ ಇದೆ ಅಲ್ಲ. ಐ ವಾಸ್ ಅರ್ನಿಂಗ್ ಲೆಫ್ಟ್ ಏನು
front portion vacant veranda that is left out in the partition deed. That is the condition of the plain deed. Trial court held that it is already included in the document.
That is- yes.
And
Okay.
that one map and set is there along with the people. That is not produced by the party. In the absence of that evidence, it cannot be ascertained the correct measurement of the electrode share. Therefore, the court has not allotted any share in that. Our position is that the schedule F cannot subsequently included in the zoom. That is not the front yard portion. That is the area allotted to the all the three sharers in the 1961 document itself. Therefore, if the judgment of the trial court is disturbed, but in the A schedule property, that was to the share of Parvati Bai, and even along with that A schedule property, the portion of F schedule property to go to all the 108 children. To go to all the 8 children. That will not If the lordship accept the submission, Lord, I need not make much submission, further submission on that.
You mean to say F schedule is
Part of
meant
the-
for the users of the A schedule property,
Respective schedule, A schedule in the
common area ಅಂತ.
common area, varanda.
ಅದೇನೆ ವರಾಂಡ ಬರುತ್ತೆ, ಅದು ಎಲ್ರಿಗೂ ಸೇರಿ ಕಾಮನ್ ಆಗಿ ಇಡಬೇಕು.
Varanda ಇದೆ. And
ಇರ್ಲಿ.
When you come to the court, they have come, you also support them. Plaintiff, right? So you have to prove the existence of a property. Whether any, unless it is dispute, admitted by the other side.
But what they defendants say is already included.
Property is for record. ಹೇಳ್ತಾರೆ ಅದಲ್ಲಿ ಇದಕ್ಕೆ ಏನಾರ ಒಂದು ಎವಿಡೆನ್ಸ್ ದೇರ್ ಶುಡ್ ಬಿ
ನಮಗೆ ಈ ಶುದ್ಧಲ್ಲಿ ಕೊಡದೆ ಡಿನೇ ಮಾಡಿದ್ರು, ಹಾಗಾಗಿ ಅಲ್ಲಿ ಅಲ್ಲಿನ ಅವರು ಅಕ್ಯೂಡಲ್ಲೂ ಯಾರು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು.
even saying that first you said the trial court has held that the existence of the F schedule property is not proved.
Even if it is there, if it is a part of A schedule or B schedule that is allotted to the Gayashan Rao, or C schedule in the 1951 document allotted to Saraswati Bai, that goes with that property. That one. And
So it appears you contended that this is the part of the property which were allotted. ಅದಕ್ಕೆ ಅವರು ಅದೇ ಅಬಟ್ಮೆಂಟ್ ಏನಿರುತ್ತೋ ಅದು ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
If A schedule is part of A schedule in this book, and we are all intended for equal share, then furthermore.
No, why should we hold unless there is some material to show that? Show us what is the material.
Finding of the trial court.
Your trial court finding, you are arguing in a first appeal. Trial court says that in regarding the proof of existence of schedule F property, there was no material. ನೀವು ಅದೊಂದು ಪ್ರಾಪರ್ಟಿ ಇದೆ ಅಂತ ತೋರಿಸ್ಬೇಕಲ್ಲ. Yes.
And where in relation to the entire relation of that where is the measurements are kind.
One second, ನೋಡ್ಬೇಕು ಕನ್ನಡ. ಈಗ ಇದು ಪಾರ್ಟ್ ಅಂಡ್ ಪಾರ್ಸಲ್ ಆಫ್ ಫ್ರಂಟ್ ಯಾರ್ಡ್ ವೇಕೆಂಟ್ ಪೋರ್ಷನ್ 55 ಎಟ್ಸಿಟ್ರಾ, ಓಲ್ಡ್ ನಂಬರ್ 231, ನ್ಯೂ ನಂಬರ್ 245, ಪ್ರೆಸೆಂಟ್ ನಂಬರ್ 245/1 ಅಂತ ಹೇಳಿದ್ದಾರೆ. ದಿಸ್ 245/1 is A schedule property, no? Part and piece and parcel of. ಹಾಗಿದ್ರೆ ಇದು ಸಪರೇಟ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಯಾಕೆ ತೋರಿಸಿದ್ರು ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ? If it is part and parcel of A.
ಇದರಲ್ಲಿ ಟೋಟಲ್
347. One sir.
measurement of the property that is gone as property ಕೊಟ್ಟಿದ್ದಾರೆ. ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ ಪೂರ್ವ ಕಡೆ ಈ ಮಧ್ಯೆ ಇರುವ ಪೂರ್ವ 23 ಉತ್ತರ ದಕ್ಷಿಣ ಪೂರ್ವ ಕಡೆ 41.6
Page 347.
347 ಮೀಟರ್. ಈ ಮಧ್ಯೆ
ಪೂರ್ವ ಪಶ್ಚಿಮ 77 ಇವೆಲ್ಲ.
ಪೂರ್ವ ಪಶ್ಚಿಮ ಉತ್ತರ ಕಡೆ 41.6, ದಕ್ಷಿಣ ಕಡೆ ಪಶ್ಚಿಮ ಕಡೆ 41.3. ಟೋಟಲ್ taken as total exposure 70 plus 70 into 41.45. So today it comes to 2,901.50 square feet.
ಅಲ್ಲ ಇದು according to them this is the A schedule property.
This is the A schedule property actually. That A schedule property is a portion following the share of first question.
So out of this entire property,
This property is also a portion of it. Whereas the other portion following the share of second one children is not included in the schedule.
bring it back.
Not included.
Other property fallen to the share of,
The share of second one for the children not included in the pension.
and why they were made party?
Because other property is same the schedule ಗೆ ಈ schedule by plain.
ಅಲ್ಲ ಇಲ್ಲಿ there was partition long back in the ಆ ಫಾದರ್ ಶೇರ್ ಗೆ ಸೇರ್ಸೋದಕ್ಕೆ ಇಬ್ರು ಬರ್ತಾರೆ ಅಂತ ಪಾರ್ಟಿ ಮಾಡೋದು.
ಆಮೇಲೆ later on while writing the notice of the B and C and C schedule, they included all the property.
Correct, ಈಗ there was already a partition. Some properties were given to the children of each wife. They were given. Now partition, ಈಗ one portion, ಈಗ if there is differences between the siblings, I mean through one wife, ಅದಕ್ಕಷ್ಟೇ ಒಂದು ಸಪರೇಟ್ ಸೂಟ್ ಹಾಕೋಬೇಕಾಗಿತ್ತು. ಈಗ ಫಾದರ್ ಶೇರ್ ಡಿವಾಲ್ವ್ ಆಯ್ತಲ್ಲ, ಫಾದರ್ ಶೇರ್ ಡಿವಾಲ್ವ್ ಆಗಿದ್ದಕ್ಕೆ ಮಾತ್ರ both wives and their children will be entitled. ಅದು ಯಾಕೆ ಅವನು ಎಲ್ಲಾನು ಸೇರಿಸ್ಕೊಂಡು ಮಿಕ್ಸ್ ಮಾಡಿದ್ರ?
ಇಲ್ಲಿರೋದು ವಾಟ್ ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಈಸ್ ದೇರ್ ಆರ್ 3 portions which were created in the partition.
ಅದೇ
One is given to the first
First
wife,
wife.
second one is given to the second wife and her children. First wife and her children. Second group is ಇನ್ನೊಂದು ಮೂರನೇದು ಭಾಗ he kept. ಯಾರು ಜಯಶಂಕರ್ he kept it. So now ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಅದು ಏನೇನೋ ಮಾಡಿದ್ದಾರೆ. ಇದರಲ್ಲಿ ಅದ್ರ ಮೂರನ್ನು ಸೇರಿಸಿದಾರ ಇಲ್ವಾ?
ಈಗ ಫಸ್ಟ್ ವೈಫ್, ಈಗ if there is difference of opinion amongst first wife, ಮಾಡಿಲ್ಲ. ಈಗ ಒಂದು ಕ್ಲಿಯರ್ ಮಾಡಿ, ಇಲ್ಲಿ ಇಷ್ಟು ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಇದಾವಲ್ಲ, ಈಗ ಒಂದ್ ಪಾರ್ಟಿಷನ್ ಮಾಡಿದ್ರು 1963 ಅಲ್ಲ 61 ಅಲ್ಲಿ ಒಂದು ಪಾರ್ಟಿಷನ್ ಮಾಡಿದಾಗ he divided the property to each branches and retained some property for him. ಈಗ ಈ ಒಂದು ಬ್ರಾಂಚ್ ನಲ್ಲಿ daughter of one branch has filed the suit, so her claim will be properties allotted to her branch plus in her father's share what was retained. ಈಗ ಈ ಕೇಸಲ್ಲಿ ಇನ್ನೊಬ್ಬರಿಗೆ ಸೇರ್ಸೇ ಇಲ್ವಾ? ಎಷ್ಟನ್ನು ಮಿಸ್ ಅಲ್ವಾ?
property I think divided into 3 shares. Father, the first of children, second of children. And whereas other two properties, the separate properties, other than I do, division ಮಾಡಿಲ್ಲ. Those properties given to the first of children and second of children equally.
ಇಂಡಿವಿಜುವಲಿ ಕೊಟ್ಟರು. ಅಲ್ಲ ಡಿಮಾರ್ಕೇಶನ್, ಸೊ 1963 ಅಲ್ಲಿ ಡಿಮಾರ್ಕೇಶನ್ ಆಗೋಗಿತ್ತ?
ಇಬ್ರು ವೈಫ್ ಮಧ್ಯೆ ಮಾತ್ರ.
ಹೌದು, ಹಾಗೆ ಬರುತ್ತೆ. ಈಗ ಆ ವೈಫಿಗೆ ಏನ್ ಬಂದಿರುತ್ತೆ, ಆ ವೈಫ್ ಬ್ರಾಂಚ್ಗೆ ಅದ್ರಲ್ಲಿ ಅವ್ರ ಮಕ್ಕಳು ಪುನಃ ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೋಬೇಕು. ಇವ್ರಲ್ಲಿ ಬಂದಿದ್ದಕ್ಕೆ ಇವ್ರು ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೋಬೇಕು. ದೆನ್ ಆ ಫಾದರ್ ಶೇರ್ ಏನ್ ಉಳಿದಿತ್ತು ಅದು ಡಿವಾಲ್ವ್ಸ್ ಆನ್ ಆಲ್ ದ ಚಿಲ್ಡ್ರನ್ ಅಂಡ್ ದ ವಿಡೋಸ್. ಇದನ್ನ ಇಷ್ಟು ಸಿಂಪಲ್ ಮಾಡೋ ಬದಲು ಅವ್ರ ಹತ್ರ ಇರ್ಲಿಲ್ಲ.
63 is in respect of ಚಿಕ್ಕಪೇಟೆ, ಅಂದ್ರೆ ಒಂದು ಪ್ರಾಪರ್ಟಿನ ಇಬ್ರಿಗೂ ಕೊಟ್ಟಿರೋದು.
ಡಿಮಾರ್ಕೇಶನ್ ಮಾಡಿದ್ರು, ಮೊದಲು ಕೊಟ್ಟಿದ್ರು ಅದನ್ನ ಡಿಮಾರ್ಕೇಶನ್ ಮಾಡಿದ್ರು.
ಅದೇನ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಗೆ ಇದಕ್ಕೆ ಅದಕ್ಕೆಲ್ಲ ಏನೇನೋ ಉದ್ದಕ್ಕೇನೋ ಬರ್ಕೊಂಡಿದ್ರು.
ಅದೇ 63 ನಲ್ಲಿ ಡಿಮಾರ್ಕೇಶನ್ ಮಾಡಿದಾಗ ಎರಡು ಬ್ರಾಂಚ್ ನಡು ಕ್ಲಿಯರ್ ಡಿಮಾರ್ಕೇಶನ್ ಮಾಡಿದ್ರು ಅಲ್ವಾ? ಅದು ಅಲ್ಲಿ ಈಗೇನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೌ ದಟ್ ವಾಸ್ ಡೆಲ್ಟ್ ವಿತ್? Like that political difference, all are entitled to 1/18 share in B schedule property. 1/18 share of the father's property, B schedule property. and that they are entitled to partition and separate possession of their shares by means and bounds under section 54, etc. It is further declared that plaintiff and defense 11 and 12 are entitled to 1/8 share in the rental income of rescheduled property. And in the items number 1 of scheduled property. scheduled property was a investments, investments. ಅದರಲ್ಲಿ ಒಂದು ಐಟಮ್ ಮೇಲೆ ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ. It is further declared that plaintiff and defense 11 and 12 are entitled to 1/8 share in item number 2 of scheduled property. It is same ಅಲ್ವಾ ಅದೇ three ಇರೋದು ಬರೀ ಇನ್ಕಮ್ ರೆಂಟಲ್ ಇನ್ಕಮ್. ಸಿ 4 is 1/8 share in item number 2 property. It is declared that defendant number 11 is entitled to item number 5 of suit schedule E property. Item number 5 of E schedule property immobile property. This defendant number 1 is daughter andrella adu. Sorry, 11. She took up the contention that she was earning and for convenience sake she invested the amount in the name of the mother also. And ಅದು ಜಾಯಿಂಟ್ ನೇಮ್ ಅಲ್ಲಿ ಇದ್ದ ಸಿಂಗಲ್ ಮದರ್ ನೇಮ್ ಅಲ್ಲಿ ಮಾತ್ರ ಇದ್ದದ. Only in the name of mother. ಅವರಲ್ವಾ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿದ್ರು ರಾಮಕೃಷ್ಣ ಈಸ್ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ ಎಷ್ಟು 5 ನ ಕರೆಕ್ಟ್. ಓಕೆ, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಓದಿದ್ದು. He says that he was earning, he took it in the name of the mother. Correct, 5. Only which paragraph? 12 is para 11, 12. Follow 0.01 ಅಂತ ಶುರುವಾಗಿದೆ. So we had heard madam only on that. Hello. You want to read it?
Because the nature of the property is not required. Only allotment of share is concerned. But not allotted each share. That is
The plaintiff was the daughter of first wife Parvatamma. So whatever the properties, the suit properties ಅಲ್ಲಿ ಅವ್ರ ಶೇರ್ ಕೊಟ್ಟಿದ್ದ ಯಾವ್ದು ಒಂದ್ಸರಿ ಹೇಳಿ. ಇನ್ನ ಪಾರ್ಟಿಷನ್ ಇನ್ 1963 ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ನೀವು ABCD ಅಂತ ಶೆಡ್ಯೂಲ್ ಮಾಡಿದಿರಲ್ಲ, ಅದ್ರಲ್ಲಿ ಯಾವ್ದಾವ್ದು ಕೊಟ್ಟಿದ್ದು ಅವ್ರಿಗೆ ಫಸ್ಟ್ ವೈಫ್ಗೆ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ? ಶೆಡ್ಯೂಲ್ ಮತ್ತೆ ಅಲ್ಲ ಒಂದ್ಸರಿ ಹೇಳ್ಬಿಡಿ ನಮ್ಗೆ ಅದು ಜಸ್ಟ್. Which were the properties allotted to the branch of the first wife? ಇದರಲ್ಲಿ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ನಿಮಿಷ ಪ್ಲೇಟ್ ತಕೊಳ್ತೀವಿ ತಡಿ. ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಕ್ ಹೋದ್ರೆ ಇವತ್ತು ಫೈಲ್ ಮಾಡಿರೋದು
ಬಿಡಿ ಸುಬ್ರಹ್ಮಣ್ಯ ಅವರು
ಇಲ್ಲ, ಆಮೇಲೆ
ಹಾಕಿದ್ದಾರೆ.
ಬೇರೆ
ಹಾ ಸರ್ ಅದೇ ಮೇಡಮ್ ಅದೇ.
ಹಾಕಿದ್ರು.
page number 4 ಅಲ್ಲಿ.
Page number 4.
Page number 4. ಅದರಲ್ಲಿ Procedural property, Procedural A property. Procedural B property, Procedural property. It is the share of gain as the cost. That is Procedural B property is 1,176 square feet. And commercial building, the rental income is paid allotted to the children of Parvati Bai and children of Saraswati Bai. Both
The suit schedule C property in suit schedule C, the other wife's property is also included. ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಡಿಮಾರ್ಕೇಶನ್ ಆಗೋಗ್ಬಿಟ್ಟಿತ್ತಲ್ವಾ, ಅಷ್ಟು ಬಿಟ್ಟು ಇದನ್ನಷ್ಟೇ ತಗೋಬೇಕಾಗಿತ್ತು. Then D schedule property.
schedule property is 22 to 82 commercial shop, the running business allotted to the children of Parvati Bai and children of Saraswati Bai.
To be equally.
More conditions. ಇದು D schedule property.
ಅಲ್ಲ, this D schedule, whether as per that partition deed, it was fully, I mean, exclusively allotted to the share of Parvati Bai or
And Saraswati Bai also.
ಇಬ್ಬರಿಗೂ ಇದೆ. ಆಮೇಲೆ 63 ಅಲ್ಲಿ this was also bifurcated. 63 ಅಲ್ಲಿ bifurcate ಆಗಿತ್ತಾ? ಸುಮ್ಮನೆ more complicated. You represent plaintiff? ಅಲ್ಲ, plaintiff ಅನ್ನ you are transposed later. Depend number 12. ಅಲ್ಲ, contesting defendants ಯಾರು? ನೀವು ಒಬ್ರೆ contesting defendant. The children of Parvati Bai. Even her children. ಇದು suit file ಮಾಡುವಾಗ ನಾವು you should have sought share in the property allotted to Parvati Bai. That is one thing. ಆಮೇಲೆ father share ಏನಿತ್ತು ಅದರಲ್ಲಿ all of you were entitled, ಅದನ್ನ ಸೆಗ್ರಿಗೇಟ್ ಮಾಡ್ಕೋಬೇಕಿತ್ತಲ್ಲ. ಸೊ ಇಲ್ಲಿ ಸರಸ್ವತಿ ಬಾಯಿದು ಸೇರಿಸ್ಕೊಂಡಿದ್ದಾರೆ. ಇದು 2 ಸೂಟ್ ಅಂದ್ರೆ ಬಿ ಯಾವ್ದ್ಯಾವ್ದ್ರಲ್ಲಿ C and D schedule properties. ಸೊ ಇದೆರಡು ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ರ? ಅದು ಕ್ವಶನ್ ಆಫ್ ಲಾ ಮೇಲೆ ಆಯ್ತು. ಬಟ್ ಇದು ಯಾವ ಗ್ರೌಂಡ್ ಮೇಲೆ ಕೊಡ್ಲಿಲ್ಲ, CD ಅಲ್ಲಿ ಅವ್ರದ್ದು ಸೇರ್ಕೊಂಡಿದೆ ಅಂತಾನೆ. ಬಟ್ ನಾವೀಗ ಅದನ್ನ ಹೇಗೆ ಚೇಂಜ್ ಮಾಡೋದು? ಹೌ ಡು ವಿ ಬೈಫರ್ಕೇಟ್ ದಟ್? ಒಂದೀಗ D ಆಯ್ತು. ಈ ಶೆಡ್ಯೂಲು ಎಲ್ಲ ಮೂವಬಲ್. Movable divisions all were standing in the name of Parvati Bai. Ramakrishna. You represent him standing in the name of Parvati Bai and Ramakrishna. Either or survivor anta idu ಡಿಸೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. Correct. They were standing in the name of those two. ಪಾರ್ವತಿ ಬಾಯಿ ಓನ್ಲಿ ಇರ್ಲಿಲ್ಲ ಐದರ್ ಆರ್ ಸರ್ವೈವರ್ ಅಂತ ಮತ್ತೆ ಅದೇ ಜಾಯಿಂಟ್ ಇದ್ದಾಗ ಆಯ್ತಲ್ಲ ಐದರ್ ಆರ್ ಸರ್ವೈವರ್ ಅಂತ ಇದ್ರು ಡೆಪಾಸಿಟ್ ರಿಸಿಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರ ವೆದರ್ ಹ್ಯಾಡ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಡೆಪಾಸಿಟ್ ರಿಸಿಟ್ಸ್ ವಾಟ್ ಇಸ್ ದಟ್ ಡೆಪಾಸಿಟ್ ರಿಸಿಟ್ ಯಾರ ಹೆಸರಲ್ಲಿದೆ ಯಾವ್ದದು ಎಕ್ಸಿಬಿಟ್ ತೋರಿಸಿ ನಾವು ನೋಡ್ತೀವಿ ನೀವ್ ಹೇಳಿದ್ದಲ್ಲ which is that document judgment ತೋರಿಸ್ಬಿಟ್ರಿ what is that document
Page number 332.
332 ಇದು ಬ್ಯಾಂಕ್ ಪಾಸ್ಬುಕ್ these were all SB ಅಕೌಂಟ್ ನೇಮ್ ಪಾರ್ವತಿ ಬಾಯಿ ಅಂಡ್ ರಾಮಕೃಷ್ಣ ಅಂತ ಇದೆ ಅಲ್ಲ ಇಫ್ ದಿಸ್ ಇಸ್ ಕರೆಕ್ಟ್ ಟೈಪ್ ರೈಟಿಂಗ್ ಕರೆಕ್ಟ್ ಇದೆ ಅನ್ನೋದಾದ್ರೆ ನಾಮಿನಿ ಅಂತಿಲ್ಲ ಪಾರ್ವತಿ ಬಾಯಿ ಅಂಡ್ ರಾಮಕೃಷ್ಣ ಅಕೌಂಟ್ ಹೋಲ್ಡರ್ಸ್
Page number 335, Parvati Bai in JD Ram.
D6 Karur Vaishya Bank, Parvati Bai and JD Ramakrishna. This paper book ಯಾರು ನಮ್ಮ ಆಫೀಸರ್ ಮಾಡಿರೋದು ಒಂಚೂರು ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ ಮನೆ ಇದು D456
DC.
ಅದು ಒಳಗೆ ಹಾಕಿ ಅಲ್ಲ ಇದು ಮಾಡಿದ್ದಾರೆ ಪೇಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಗಮ್ ಟೇಪ್ ಹಾಕಿದ್ದಾರೆ ಇಲ್ಲೊಂದು ಯಾವ್ದೋ ಕಾಣಿಸುತ್ತೆ ಅದಕ್ಕೂ ಹಾಕ್ತೀವಿ ಎಲ್ಲದಕ್ಕೂ ಗಮ್ ಟೇಪ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ರೈಟ್ ಕೋಟ್ ರೆಕಾರ್ಡಲ್ಲಿ ಕರೆಕ್ಟ್ ಅವರು ಒಂದು ಯಾವ್ದಾರು ತೆಗಿಯೋಕ್ಕಲ್ಲ ಸೊ ಇದು ಪೇಪರ್ ಬುಕ್ ಆಫೀಸರ್ ಮಾಡಿದ್ದಾನೆ ನೀವ್ ಹಾಕಿದ್ದ ಪೇಪರ್ ಬುಕ್ ನೀವ್ ಹಾಕಿದ್ದ ಆಫೀಸರ್
ಫೈಲ್ ಮಾಡಿರೋದು
ನೀವೇ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಒರಿಜಿನಲ್ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಗಮ್ ಟೇಪ್ ಹಾಕಿ ಏನೋ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಬಿದ್ದು ಹೋಗ್ಬಾರ್ದು ಅಂತ ಹೇಳಿ ಇಫ್ ದಟ್ ಇಸ್ ಕರೆಕ್ಟ್ ವರ್ಷನ್ then we rely on that only. So if we go according to that was standing, both were account holders. Parvati Bai and Ramakrishna both were account holders. ನೀವ್ ಹೇಳ್ದಂಗೆ ನಾಮಿನಿ ಅಲ್ಲ. ಸೊ ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ತೆಗೆದು ನೋಡೋದೇ ಇಲ್ಲ ಒರಿಜಿನಲ್ ಏನಿದೆ ಅಂತ ಬರೀ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿ ಒಂದ್ ಯಾವ್ದಾರ ಸ್ಯಾಂಪಲ್ ತೆಗೆದು ನೋಡೋಣ D5 ನ ಯಾವ ಬ್ಯಾಂಕ್ ನಲ್ಲಿ ಜಾಸ್ತಿ ಇತ್ತು ಹೇಳಿ ಬ್ಯಾಲೆನ್ಸ್ ಅಲ್ಲಿದ್ರಲ್ಲಿ ತೆಗಿತೀವಿ ಆ ಪಾಸ್ಬುಕ್ ತೆಗಿತೀವಿ ನೀವು whom do you represent? Plaintiff. ಅಲ್ಲ ಅವ್ರಿಗೆ ಯಾವ್ದ್ರಲ್ಲಿ ಅಮೌಂಟ್ ಜಾಸ್ತಿ ಇದೆ ಅಂತ ಶೆಡ್ಯೂಲ್ ನೋಡಿ ಈ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲಿ ಜಾಸ್ತಿ ಇದೆ ಬ್ಯಾಲೆನ್ಸ್ ಅದನ್ನ ಓಪನ್ ಮಾಡೋದಿದ್ರೆ ಅದನ್ನೇ ಓಪನ್ ಮಾಡೋಣ ಯಾವ ಬ್ಯಾಂಕ್ ಹೇಳಿ ಕರೂರ್ ವೈಶ್ಯ ಬ್ಯಾಂಕಿನ 2 ಪಾಸ್ಬುಕ್ ಇದಾವೆ D4 and D5 ಅಂತ ಬಹುಶಃ ಕಂಟಿನ್ಯೂ 307 ಒಂದೇ ಅಕೌಂಟ್ ಇದ್ರೆ ನಾನು ಇಲ್ಲ 3299 ಅಂದ್ರೆ ಏನದಂತ ರಾಮಕೃಷ್ಣ ಪಾರ್ವತಿ ಅಂತನ ಮೂರಿದೆ ಪಾಸ್ಬುಕ್ ಕರೂರ್ ವೈಶ್ಯ ಬ್ಯಾಂಕ್ ಇಂದ ಅಕೌಂಟ್ ನಂಬರ್ ಬೇರೆ ಬೇರೆ ಆಯ್ತು ಯಾವ್ದು D4 D4 ಇದನ್ನೊಂಚೂರು ಓಪನ್ ಮಾಡಿ ಅದೇ ಮತ್ತೆ ಹಚ್ಚಿ ಇದಷ್ಟೇ ಇದನ್ನ ಕಟ್ ಮಾಡಿ ಇದಿಷ್ಟೇ ಇದರಲ್ಲಿ ಬರುತ್ತೆ ಅನ್ಸುತ್ತೆ ಮತ್ತೆ ಅಲ್ಲೊಂದು ಪಿನ್ ಹಾಕಿರ್ತಾರೆ Bank account. Passbook. ಇದು ಏನಾರ ಹುಡುಕಿದ್ದಕ್ಕಿಂತ ಕಷ್ಟ. ಏನು JD ಪಾರ್ವತಿ ಬಾಯಿ ಅಂಡ್ JD ರಾಮಕೃಷ್ಣ ಅಂತಾನೆ ಇದೆ ಅಕೌಂಟ್ ಹೋಲ್ಡರ್ಸ್ ನೇಮ್. ಜಾಯಿಂಟ್ ಅಕೌಂಟ್ ಅದೇ ಐದರ್ ಆಫ್ ಸರ್ವೈವರ್ ಅಂತ ಬರೋದು ಜಾಯಿಂಟ್ ಅಕೌಂಟ್ಸ್ ಇದ್ರೇನೆ. ಸೊ So this is about ಎಲ್ಲದರಲ್ಲೂ ಹಾಗೆ ಇದೆ ಅದು ಆಲ್ ಅಕೌಂಟ್ಸ್ ಅಲ್ಲ ಸರಿ. ಎಸ್ ಶೆಡ್ಯೂಲ್ ಇ ಶೆಡ್ಯೂಲ್ ಎಫ್ ಇಸ್ ವೆಕೆಂಟ್ ಪೋರ್ಷನ್. ಇದು ದಿಸ್ ಇಸ್ ಅನದರ್ ಕಾಂಟ್ರವರ್ಸಿ ವೆದರ್ ಇಟ್ ವಾಸ್ ಪಾರ್ಟ್ ಆಫ್ ಯಾರ್ ನೀವು ಅದರಲ್ಲಿ ವೆಕೆಂಟ್ ಪೋರ್ಷನ್ they have mentioned that it was part of ABC property. Correct. Now, how do we bifurcate this in the schedule? ಯಾವ್ದದು ಎರಡು ಸೇರಿಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದಾರಲ್ಲ ಶೆಡ್ಯೂಲ್ ಸಿ ಅಂಡ್ ಡಿ. 63. 61.
63 is only in respect of ಅದಕ್ಕೆ ಮಾತ್ರ ಅದು ಕರಾರು.
ಹಂಗೆ ಸುಮ್ನೆ ನಾರ್ದನ್ ಪೋರ್ಷನ್ ಸದರ್ನ್ ಕಾಂಪ್ಲಿಕೇಶನ್ ಆಗುತ್ತಲ್ಲ. ಅಲ್ಲ ಬೌಂಡ್ರೀಸ್ ಬೈ ಡೈಮೆನ್ಷನ್ಸ್ ಎಲ್ಲ ಏರ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ರೆ ಮೆಜರ್ಮೆಂಟ್ಸ್ ಬೌಂಡ್ರೀಸ್ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ.
ಇಡೀ ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಬೇಕು, ಕಾಮನ್
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವ್ರ ಪ್ರಕಾರ.
ಅದು ಕೊಟ್ಟು ಬೆಳಗ್ಗೆ ಕೊಟ್ಟು
ಡಿವೈಡ್ ಮಾಡಬೇಕು ಅಂತಂದ್ರೆ
ಶೇರ್ ಡಿಕ್ಲೇರ್
ಕ್ಲಿಯರ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಇಂಥ ಪ್ರಾಪರ್ಟಿ ಶೇರ್ ಇದೆ ಅಂತ ಮಾಡ್ಬೇಕು. ಈ ಡಿಮಾರ್ಕೇಶನ್ ಈ ಮೆಜರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ. ಶೇರ್ ಬರೋದಿಲ್ಲ ಮಾಡಕ್ಕೆ. ಈಗ ಫಸ್ಟ್ ಟೈಪ್ ಆಫ್
ಒಂದರಿಂದ 8 ಜನ ಬರುತ್ತೆ ಪ್ರಾಪರ್ಟಿ. There is the matter, and there even used to be done like this or done like this.
ಈಗ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಶೇರು ಎಲ್ಲೇ ಒಂದು ಸಪರೇಟ್ ಇದೆ. ಎ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಏನು ಪ್ರಾಬ್ಲಮ್ ಆಗೋದಿಲ್ಲ. ಈ ಸಿ ಅಂಡ್ ಡಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ. Whether you are agreeable with regard to which portion in the C and D schedule property comes to the share of Parvatamma and branch of Parvatamma and Saraswatamma. Page number ಎಷ್ಟು? Page number. 25. ಒಟ್ಟು ಕುಟುಂಬ ಆಸ್ತಿ ಮತ್ತು ಆದಾಯ ವ್ಯವಸ್ಥೆ ಕ್ರಮ ವಿಭಾಗ ಪತ್ರ ಅಂತ ಹೇಳಿ. ಅಲ್ಲ ಇದು ಯಾವ ಇಸ್ವಿ ಇದು? ಶೆಡ್ಯೂಲ್ ಎ.
ಉತ್ತರಕ್ಕೆ ಇಡೀ ಪರ್ವತಿಬಾಯಿ ಮತ್ತು ಅವರ ಮಕ್ಕಳಿಗೆ ಸೇರಿದ ಮೇಲ್ಗಡೆ ನಂಬರ್ನ ಭಾಗ ಈ ಮತ್ತು ದಕ್ಷಿಣಕ್ಕೆ ಈ ಎನ್ ಜಯಶಂಕರ ರಾವ್ ಅವರಿಗೆ ಸೇರಿದ ಭಾಗ 21 ಪೂರ್ವಕ್ಕೆ 11 ಗಂಟೆಗಳಲ್ಲಿ ಪಶ್ಚಿಮಕ್ಕೆ 2ನೇ ತಾಸು. ನೆಕ್ಸ್ಟ್ ಇಲ್ಲಿ ಬಿ ಶೆಡ್ಯೂಲ್ ಸೇಮ್ ಇದೆ. ಜಯಶಂಕರ ರಾವ್ ಅವರಿಗೆ ಅವರು ನೋಟಿಸ್ ಬರೆದಿದ್ದಾರೆ. ಈ ಶೆಡ್ಯೂಲ್ ಸಿ ಇನ್ ದಿಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇಸ್ ಎ ಶೆಡ್ಯೂಲ್ ಇನ್ ದಿಸ್.
ಈಗ ಆದ್ರೆ ಒನ್ ಮೋರ್ ಥಿಂಗ್ ವಿಚ್ ಕ್ಯಾನ್ ಬಿ ಡನ್ ಅಂದ್ರೆ ಈಗ ಎ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ವಾಸ್ ಪಾರ್ವತಿ ಬಾಯಿ ಶೇರ್. ಅದಕ್ಕೆ ಇನ್ ಎ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಇದು ಪ್ರಿಲಿಮಿನರಿ ಡಿಗ್ರಿ ಅಲ್ಲ. ಇನ್ ಎ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಅಂದ್ರೆ ಪಾರ್ವತಿ ಬಾಯಿ ಏರ್ಸ್ ಏನಿದಾರ ಈಚ್ ಆಫ್ ದಮ್ ಆರ್ ಎಂಟೈಟಲ್ ಟು dispatch share. And in B schedule property, then it has to be divided amongst all. C schedule property ಅಲ್ಲಿ ಪಾರ್ವತಿ ಬಾಯಿ ಏರ್ಸ್ ಏನಿದ್ದಾರೆ ಅವ್ರನ್ನೆಲ್ಲ ಐ ಮೀನ್ ಪ್ಲೇಂಟಿಫ್ಸ್ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಯಾರಿದ್ದಾರೆ ಅವ್ರು ದೇ ಆರ್ ಎಂಟೈಟಲ್ ಟು dispatch of share ಅಂತ ಡಿಕ್ಲೇರ್ ಮಾಡ್ಬೇಕಾ? ನಿಮ್ಮ ಸೂಟ್ ಅಲ್ಲಿ
ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಡಿ ಶೆಡ್ಯೂಲ್ ಸಿ ಶೆಡ್ಯೂಲ್ ಹಾಗೆ ಇಷ್ಟೇ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ನಾವೀಗ ಏನ್ ಮಾಡ್ಬೇಕು ಈಗ? ಸಿ ದೇ ಹ್ಯಾವ್ ಮೇಡ್ ಸಮ್ ಬೇಸಿಕ್ ಐ ಮೀನ್ ಎರರ್ ಅಲ್ಲಿ. ಈಗ ಸಿಂಪಲ್ ಆಗಿ ಪಾರ್ವತಿ ಬಾಯಿಗೆ ಬಂದಿದ್ದ ಶೇರ್ ನಲ್ಲಿ ನಮಗೆಲ್ಲ ಮಕ್ಕಳಿಗೆ ಇಷ್ಟು ಶೇರ್ ಬರ್ಬೇಕು, ಸರಸ್ವತಿ ಬಾಯಿಗೆ ಬಂದಿರೋದು ಅವ್ರ ಮಕ್ಕಳಿಗೆ ಅವ್ರದ್ದು ಇಷ್ಟು ಶೇರ್ ಬರ್ಬೇಕು ಅಂತ ಮಾಡಿ ಅದೇನು ಡಿಮಾರ್ಕೇಶನ್ ಆಯ್ತಲ್ಲ 63 ಅಲ್ಲಿ, ಅದ್ರಲ್ಲಿ ಈ ಪಾರ್ಟಿ ಇವ್ರದ್ದು ಈ ಪಾರ್ಟಿ ಇವ್ರದ್ದು ಮತ್ತೆ ಇದ್ರಲ್ಲಿ ಇಷ್ಟು ಬರ್ಬೇಕಂತ ಫಾದರ್ ಶೇರ್ ಅಲ್ಲಿ ಎಲ್ಲರಿಗೂ ಇಷ್ಟು ಬರ್ಬೇಕು ಅಂತ ಮಾಡ್ಕೋಬೇಕಿತ್ತು. ಈಗ ಅದನ್ನ ಹೌ ಟು ಸಾಲ್ವ್ ಇಟ್ ಹಿಯರ್?
ಇದರಲ್ಲಿ ಡಿ ಶೆಡ್ಯೂಲಿಗೆ ನೋಟಿಸ್ ಹೇಳಿದೆ. ನೆಕ್ಸ್ಟ್ ಡಿ ಶೆಡ್ಯೂಲ್
ನಾವೀಗ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಏನಿರುತ್ತೋ ಅದ್ರಲ್ಲೇ ಕೊಡ್ಬೇಕಾ?
ಹೆಂಗ್ ಮಾಡಿದಿರಿ ಅಂತಂದ್ರೆ ನಮ್ ಕಾಲದಲ್ಲಿ ಕುರ್ಚಿಗೆ ಇದನ್ನ ಹೇಳ್ತಿದ್ರು, ಏನು ಟೇಬಲ್ ಅಂತಿದ್ರು, ಟೇಬಲ್ಗೆ ಕುರ್ಚಿ ಅಂತಿದ್ರು. ಈಗ ನಾವು ಕುರ್ಚಿ ಟೇಬಲ್ ಗಳನ್ನ ಉಲ್ಟಾ ಹೇಳ್ತೀವಿ. ಈಗ ನೀವು ಇದನ್ನ ಮಾಡಿ ಅಂತ ಹಂಗ ಒಂದು 10 ಫರ್ನಿಚರ್ ಹೆಸರು ಹೇಳಿದಿರಿ.
If there is no dispute at all about these things, ಅದು ಮೂವಬಲ್ ಬಿಡಿ, ಮೂವಬಲ್ ಅಂತ ಅದನ್ನ we can decide even that ಯಾವುದೋ ಒಂದು ಪಾರ್ಟ್. Why can't you amend if you have no if all of you are I mean sailing together, why can't you amend the plain schedule or make a part of the written statement schedule? ಯಾರಿ ಪ್ಲೇಂಟಿಫ್ ನೀವಾ? ನೀವು ಪ್ಲೇನ್ ಶೆಡ್ಯೂಲ್ ಅಮೆಂಡ್ ಮಾಡಕ್ ಆಗಲ್ವಾ? ಅದಕ್ಕೆ ಈಗ ಈ ಪೊಸಿಷನ್ ಗೆ ಯಾರ್ದು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ವಲ್ಲ. ದಯಾಶಂಕರ್ took this much, Parvati's branch was given this much, Saraswati Bai's branch was given this much. Parvati Bai's you are claiming to Parvati Bai share ಅಂತ ಒಂದು ಶೆಡ್ಯೂಲ್ ಮಾಡ್ಕೊಂಡು ನಾವು all the children of Parvati Bai are entitled to this much share. And Saraswati Bai share ಅವ್ರದ್ದು ಏನ್ ಶೆಡ್ಯೂಲ್ ಇರುತ್ತೆ ಅದನ್ನ ಮಾಡ್ಕೊಂಡು ದಯಾಶಂಕರ್ ಅವ್ರಲ್ಲಿ ಎಲ್ಲರಿಗೂ ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಅದನ್ನ we will decide. And other the movable property now we have to decide it was whether the ಅಲ್ಲ ಅದೆರಡು ಕಾಮನ್ ಏರಿಯಾ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ.
What I have specifically stated is my reference statement. F schedule property is the property that can be given to satisfy the content.
What was her schedule? That is CN schedule Parvati Bai.
And Parvati Bai equals
But I have made a comparative chart and I have tried it along with this.
So ಅದ್ರ ಬಗ್ಗೆ ಒಂದು ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. Because when they came before the court, it was for them to show that what is the property, they are entitled to a share in that. ಅದು ಬಿಟ್ಟು ಇದು ಯಾವ್ದ್ರಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ವೋ ಇದನ್ನಾದ್ರೂ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೋಬೇಕು.
That would be my own of contention. So they did not leave make a pleading on exhibit P11, that is the 1963 document. Now, in fact, exhibit P11 was marked in their evidence only, they knew it. In spite of it, without specifically saying, already by means of the division had taken. The entire Saraswati Bai's branch mother were held up with this property for this long time of litigation.
We are telling that only. ನಾವು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದೀವಿ ಈಗ ಸರಸ್ವತಿ ಬಾಯಿ ಶೇರ್ ಇದು ಅಂತ ಅಂದ್ಬಿಟ್ರೆ they will not get anything in that. So suit that can be excluded from the suit. Those ಈ ರೀತಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಕ್ ಆಗುತ್ತಾ ಅಂತ ಕೇಳ್ತಾ ಇದೀವಿ. ಎಕ್ಸ್ಕ್ಲೂಡಿಂಗ್ ದ ಪ್ರಾಪರ್ಟಿ ಶೇರ್ ಆಫ್ ಸರಸ್ವತಿ ಬಾಯಿ, then including only the share of Parvati Bai and the father. ಅದನ್ನ ಮಾಡ್ಕೊಂಡು ಈಗ father share ಗೆ both of you will become necessary party. Whatever Dayashankar got, ಈಗ Saraswati Bai's children and Parvati Bai's children, they have to be there on record. ನೀವು ಅದನ್ನ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡ್ಬಿಡಕ್ಕಾಗಲ್ವಾ ಸರಸ್ವತಿ ಬಾಯಿ ಪ್ರಾಪರ್ಟಿನ? So whole thing will be solved. ಅವಾಗ otherwise how to do it? ಅವ್ರು ಹೇಳ್ದಂಗೆ ಕುರ್ಚಿ ಟೇಬಲ್ ಕತೆ ಆಗುತ್ತೆ ಅದು.
ಅವಾಗ ಕುರ್ಚಿಗೆ ಟೇಬಲ್ ಅಂತಿದ್ವಿ, ಈಗ ಚೇರ್ಗೆ ಇನ್ನೊಬ್ಬ ಸ್ಟೂಲ್ ಅಂತಾರೆ.
ಅಪ್ಪ ಪಾರ್ಟೀಸ್ ಏನ್ ಗೊತ್ತಿರುತ್ತೆ, ರಿಪೋರ್ಟಿಗೆ ಬಂದ್ಮೇಲೆ ಹಿಂದಿನ ಕೇಸ್ ನೋಡ್ತಿದ್ರೋ ಇಲ್ವೋ? ಅದಕ್ಕೆ why should they keep fighting in the court for many years?
Better you do something
ನೀವು
to simplify the things.
ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಆ ಸರಸ್ವತಿ ಬಾಯಿ ಶೇರ್ ಏನ್ ಬಂದಿತ್ತಲ್ಲ ಅದನ್ನ ಈ ಪ್ಲೇನ್ ಶೆಡ್ಯೂಲ್ ನಿಂದ
property that there are three things. One is Parvati Bai property, then Saraswati Bai, then Dayashankar Rao, then left out property, that is 5,000 per annum.
So only Gandhinagar property is in dispute now.
That has to be divided among
even
That is
Gandhinagar property.
inclusive of that.
ಅಲ್ಲಲ್ಲ ಇವನ್ ಗಾಂಧಿನಗರ್ ಪ್ರಾಪರ್ಟಿ ಎಫ್ ಬಿಟ್ಬಿಡಿ, ನಾಟ್ ಇನ್ಕ್ಲೂಡೆಡ್ ಪ್ರಾಪರ್ಟಿ ಬಿಡಿ. ಬಟ್ ಆ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ there was a demarcation for ದಯಾಶಂಕರ್ ಶೇರ್, ಸರಸ್ವತಿ ಬಾಯಿ ಶೇರ್ ಅಂಡ್ ಪಾರ್ವತಿ ಬಾಯಿ ಶೇರ್ ಅಲ್ವಾ? ಅದನ್ನೇ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ನೀವು ಹಾಕೋಬಹುದಲ್ಲ ಇದ್ರಲ್ಲಿ. If you can keep it in the schedule, we'll decide whether it is part of that property or not. But so far as 1961 date, whatever was allotted, one property dantu admit ಮಾಡ್ತೀರಿ. 63 ನಲ್ಲೂ ಕೂಡ there is demarcation. ಅದನ್ನ ಸರಸ್ವತಿ ಬಾಯಿಗೆ ಅದ್ರಲ್ಲಿ ಡಿಮಾರ್ಕೇಟ್ ಮಾಡಿ ಯಾವ್ದು ಕೊಟ್ಟಿದ್ರು ಅದನ್ನ ಬಿಟ್ಬಿಟ್ರೆ ಉಳಿದದನ್ನ ಮಾಡೋದಕ್ಕೆ ಇಟ್ ಬಿಕಮ್ಸ್ ಈಸಿ ಫಾರ್ ಅಸ್. ಅದು ಮಾಡಿ
ನೀವು ಅದು ಬೆಕ್ಕಿಗೆ ನಾಯಿ, ನಾಯಿಗೆ ಹುಲಿ, ಹುಲಿಗೆ ಬೆಕ್ಕು ಅಂತ ಹೇಳಿ ಹೇಳ್ತಾರೆ ಅಂತ ಹೇಳಿ ಇದ್ರೊಳಗೆ ನಿಮ್ಮ ಎ ಬಿ ಸಿ ಡಿಗೆ ಅದ್ರೊಳಗೆ ಬೇರೆ ಇದ್ರೊಳಗೆ ಬೇರೆ ಇದ್ರೊಳಗೆ ಬೇರೆ ಮಾಡ್ಕೊಂಡು ಕುತ್ಕೊಂಡ್ರೆ ಹಿಂಗೆ ಆಗುತ್ತೆ.
ಇನ್ನೂ ಒಂದು ಮಾಡ್ಬೋದು. ಈಗ ಇದಕ್ಕೊಂದು ಸಪರೇಟ್ ಸೂಟ್ ಹಾಕಿ ತನ್ನ ಸಿಬ್ಲಿಂಗ್ಸ್ ಮೇಲೆ ಫಾದರ್ ಒಂದು ಸಪರೇಟ್ ಎಲ್ಲರನ್ನೂ ಕೂಡಿಸ್ಕೊಂಡ್ ಮಾಡಿದ್ರು ಆಗಿತ್ತು. ಸಿಬ್ಲಿಂಗ್ಸ್ ಜೊತೆ ಕೇಳೋದು ಒಂದ್ ಬೇರೆ, ಆಮೇಲೆ ಸಿಬ್ಲಿಂಗ್ಸ್ ಆಫ್ ದ ಅದರ್ ವೈಫ್ ಜೊತೆ ಕೇಳೋದು ಒಂದ್ ಬೇರೆ. It seems there is non-joinder of causes of action also. And the death of Daya Shankar, all of were entitled, that is one cause of action. And the death of Parvati Bai, her all children were entitled, that was one cause of action. When Parvati Bai died, she died in 1992. Okay. When this Daya Shankar died in 1965. 65 ಅಲ್ಲಿಂದ ಅವಾಗಿಂದ ದಯಾಶಂಕರ್ ಅವ್ರಿಗೆ ಏನ್ ಬರ್ತಿತ್ತು ಅದು ಎಲ್ಲಾ ಮಕ್ಕಳಿಗೂ ಬರ್ಬೇಕಿತ್ತು. ಈ ಶೆಡ್ಯೂಲ್ ಅಷ್ಟೇ ಅಲ್ವಲ್ಲ, ದಯಾಶಂಕರ್ ಹ್ಯಾಡ್ ನಾಟ್ ಓನ್ಲಿ ರಿಟೇನ್ಡ್ ಮೂವಬಲ್ ಪ್ರಾಪರ್ಟಿ, ಬೇರೆ ಪ್ರಾಪರ್ಟಿನೂ ಇತ್ತಲ್ಲ. ಈ ಶೆಡ್ಯೂಲ್ ಇಸ್ ಇಮ್ಮೂವಬಲ್ ಪ್ರಾಪರ್ಟಿ ಬೇರೆ, ದಟ್ ವಿ ಹ್ಯಾವ್ ಟು ಡಿಸೈಡ್ ಅದು ಅದರಿಂದ ಆಗಿದ್ದು ಅಲ್ವಾ ಅಂತ ಹೇಳಿ. He died in apparently that was standing in two account holders name. ಅದು ಅವರು ಯಾರು ಪಾರ್ವತಿ ಬಾಯಿ ಈಗ ಇಲ್ಲಿ ಅವ್ರಿಗೆಲ್ಲ ಎಷ್ಟು ವಯಸ್ಸಾಗಿದೆ.
Ramkrishna Rao has taken all the money accumulated from the income generated from A schedule property, B schedule property, and he has purchased one more property.
ಅದು ಇದರಲ್ಲಿ ಇದೆಯಾ?
ಅದು ನಮ್ಮ ಡಿಪೆಂಡೆಂಟ್ ಲೆವೆಲ್ ನಮ್ಮ ಎವಿಡೆನ್ಸ್ ಇದೆ.
ಕರೆಕ್ಟ್, ಅದೇನ್ ಸೂಟ್ ಪ್ರಾಪರ್ಟಿ ಅಲ್ವಲ್ಲ.
ಮಾಡಿಲ್ಲ ಅವರು, ಆದರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಪರ್ಮಿಟೆಡ್ ಫಾರ್ ಎಂಕ್ವೈರಿ.
ಸಬ್ಜೆಕ್ಟ್ ನೀವು ಸೇರಿಸ್ತೀರಿ, ಎನ್ಕ್ವೈರಿ ಹೇಗಾದ್ರೆ ಎನ್ಕ್ವೈರೀಸ್ ಫಾರ್ ಮೀನ್ ಪ್ರಾಫಿಟ್ಸ್, ನಾಟ್ ಫಾರ್ ದಿಸ್. ಎನ್ಕ್ವೈರೀಸ್ ಫಾರ್ ಮೀನ್ ಪ್ರಾಫಿಟ್ಸ್, ನಾಟ್ ಫಾರ್ ಶೇರ್ ಇನ್ ದಟ್ ಪ್ರಾಪರ್ಟಿ. ಅಂಡ್ ವೆನ್ ದೇರ್ ವಾಸ್ ಎ ಡಿವಿಷನ್ 1961 1963 ಅಲ್ಲಿ ಡಿವಿಷನ್ ಆದ್ಮೇಲೆ ಜೂನಿಯರ್ ಮೆಂಬರ್ ಇಫ್ ಹಿ ಅಕ್ವೈರ್ ಸಮ್ ಪ್ರಾಪರ್ಟಿ, whether it can be called as a joint family property.
It cannot.
Once there is a division, it's division. Then whatever he acquires, it becomes his property.
Joint family.
Joint family.
Where is the joint family?
And partition in 1961.
All that joint. They have not taken separate share. Parvati Bai, or he was Parvati Bai and her children.
Whether he was the manager of the family, he was the senior elder son, no? Ramakrishna Rao.
Parvati Bai was given the power of management.
ಏನದಕ್ಕೇನು ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ?
Then it's a document later.
ಏನಂತ?
Parvati Bai has to manage.
But Parvati Bai has to manage ಅಂದ್ರೆ ರಾಮಕೃಷ್ಣ ಮ್ಯಾನೇಜ್ ಮಾಡಿದ್ರು ಅಂತ ಹೆಂಗಾಗತ್ತೆ?
Helping the mother, helping the mother.
ನಾವ್ ಹೇಳಿದ್ವಲ್ಲ,
ಇದು
let them rest in peace.
intentions. Once there is a partition, it is a partition. Here ends the matter.
ಶೇರ್ ಅನ್ನ ಯಾವಾಗ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿರೋದು? 93 ದಲ್ಲಿ. 65 ಅಂದ್ರೆ 93 ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು? 28 ವರ್ಷ ಮೊದಲು ಏನು ಕ್ಲೈಮ್ ಮಾಡಿಲ್ಲ. ಈಗ 28 ವರ್ಷ ಆದ್ಮೇಲೆ ಅದು ಎವಿಡೆನ್ಸ್ ಪ್ಲೇಂಟ್ ಅಲ್ಲೂ ಬರ್ಲಿಲ್ಲ. He has another property. It should also be included. It is joint family. Mr. Subramanya, ಈ ನಿಮ್ಮ our experience.
The legal position is very clear. 61 there was a partition for steps. ಅಂದ್ರೆ 3 ಬ್ರಾಂಚ್ ನಲ್ಲಿ ಮಾಡ್ಕೊಂಡಿದೀರಿ, ಅದು ದೇರ್ ಎಂಡ್ಸ್ ದ ಮ್ಯಾಟರ್. ಅಲ್ಲಿಂದ ಇಲ್ಲಿಂದ ಅಲ್ಲಿ ನೀವು ನಾಯಿ ಬೆಕ್ಕು ನಾಯಿ ಮಾಡಕ್ ಬರಲ್ಲ, ಹಂಗೇನೆ ಇಡ್ಬೋದು.
ಈಗ
ಒಂದು ಎರಡನೇದು ದಯಾಶಂಕರ್ ರಾವ್ ಅವ್ರಿಗೆ ಏನಿತ್ತಲ್ಲ ಅದ್ರಲ್ಲಿ ಎಲ್ಲರಿಗೂ ಬರುತ್ತೆ, ಬಿಕಾಸ್ ಆಫ್ ವಿನೀತಾ ಶರ್ಮಾ ವರ್ಸಸ್ ರಾಕೇಶ್. ನೋ ಡೌಟ್ ಆನ್ ದಟ್.
ನೀಟ್ ಅಪ್ಲೈಸ್ ಅಲ್ಲ, ಅವ್ರಿಗೆ ಆಗುತ್ತೆ. 8 ನಲ್ಲಿ ಎಲ್ಲರಿಗೂ ಬರುತ್ತೆ. ಅದೆಲ್ಲ ಕತೆ, ಅದೆಲ್ಲ ಪ್ಲೇಂಟ್ ಆದ್ಮೇಲೆ ಅದ್ರಲ್ಲಿ ಏನು ಸೇರಿಸ್ಲಿಲ್ಲ, ಮಾಡ್ಲಿಲ್ಲ. ಯು ಆರ್ ನಾಟ್ ದ ಪ್ಲೇಂಟಿಫ್, ಯು ಆರ್ ನಾಟ್ ದ ಪ್ಲೇಂಟಿಫ್, ಯು ಆರ್ ದ ಡಿಪೆಂಡೆಂಟ್. ನೀವು ಕ್ಲೈಮ್ ತಗೊಂಡು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅದನ್ನ ಪ್ರಾಪರ್ಟಿ ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿ ಅದ್ರಲ್ಲಿ ಶೇರ್ ಕೊಡಿ ಅಂತ ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ರ, ಅದ್ರಲ್ಲಿ ಪ್ರಾಪರ್ಟಿನ ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿ ದಿಸ್ ಇಸ್ ಆಲ್ಸೋ ಒನ್ ಆಫ್ ದ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ, ಇದ್ರಲ್ಲೂ ಶೇರ್ ಇದೆ ಅಂತ ಹೇಳಿ ಇದನ್ನು ಅದ್ರಲ್ಲಿ ಸೇರಿಸ್ಬೇಕು. ಈಗ ಮೇಡಮ್ ನೀವ್ ಅದು ಮಾಡ್ತೀರಾ? ಆ ಸರಸ್ವತಿ ಬಾಯಿ ಪ್ರಾಪರ್ಟಿನ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿಬಿಡಿ. ಬಟ್ ವೈ ಅಪೀಲ್ ಆಗಿ 2011
ನಾವು ಕೋಡಿಂಗ್ ಅಂಡ್ ಡಿಕೋಡಿಂಗ್
ಅದನ್ನು ಮಾಡಿದ್ಮೇಲೆ ಒಟ್ಟಿಗೆ ಕೊಡಿ. ಇದು ಮಾಡೋದಕ್ಕೆ ಕೊಟ್ಟಿದ್ವಾ ನಿಮ್ಗೆ? ಮತ್ತೆ ಏನು ಕಂಪೈಲೇಷನ್ ಮಾಡ್ಕೊಡಿ. ಆಯ್ತು ಕೊಡಿ, ಇದು ಒಳ್ಳೆ ಅಲ್ಲ ಅದ್ರದ್ದು ಆಯ್ತು. ಈ ಸಿಂಪಲ್ ಆಗಿ ಅದೇನು ಉಗುರಿನಲ್ಲಿ ಹೋಗೋದಕ್ಕೆ ಕೊಡ್ಲಿ ತಗೊಂಡ್ರು ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಹಾಗೆ. But your counterpart has contributed to it. ಅಲ್ಲ ಅದಾಯ್ತು. ನಿಮ್ಮ ಕೌಂಟರ್ ಪಾರ್ಟ್ ಪ್ಲೇಟ್ ಹಾಕುವಾಗ ವೈದ್ಯ ಕೂಡ ನಿಮ್ಮ ಕೌಂಟರ್ ಪಾರ್ಟ್ ಅಂತ ಹೇಳಿದ್ವಿ ನಾವು. ನಿಮ್ ಕೌಂಟರ್ ಪಾರ್ಟ್ ಪ್ಲೇಟ್ ಹಾಕುವಾಗ ಇದನ್ನೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ತಂದು ಕೊಟ್ಮೇಲೆ ನೋಡಿ ಹೇಳ್ಬೇಕಲ್ಲ.
ಎಷ್ಟು ಕಾಂಪ್ಲಿಕೇಟ್ ಮಾಡಬೇಕು ಮಾಡಿದ್ದೀವಿ.
ಈಗ we are not the mouthpieces of the parties. We are the officers. ಒಂದ್ ವೇಳೆ ಅವ್ರ ಇಂಪ್ರೆಷನ್ ಮೇಲ್ alone are entitled ಅನ್ನೋದು ಇದ್ರು ಕೂಡ you should not have included Saraswati Bai's property. ಅದು that legal issue was being decided in course of time. ಬಟ್ ಬೇರೆ ಅದನ್ನು ತಗೊಂಬಂದು ಸೇರ್ಸಿ, ಆಮೇಲೆ ತಂದೆದು ಇದ್ರಲ್ಲಿ ತಗೊಂಬಂದು ಸೇರ್ಸಿ other 2 children are not included ಅಂತೆ ಬೇರೆ. Or plaintiff, plaintiff, ನಿಮ್ ಕ್ಲೈಂಟ್. ಎಸ್, ಅವ್ರ ಅದನ್ನೆಲ್ಲ ನಾವು ತೀರ್ಮಾನ ಮಾಡ್ತೀವಿ. ಅದನ್ನ ಎಫ್ ಹಾಗೆ ಇಟ್ಕೊಂಡ್ರಿ ಇಟ್ಕೊಳ್ಳಿ. ಸರಸ್ವತಿ ಬಾಯಿ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿ. Now they are all living, the daughters are living in separate places. ಇದೆಲ್ಲ ನೀವು ಇಲ್ಲಿ ನಮ್ಮ ಮುಂದೆ ಹೇಳೋದಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ನೀವು ನಾವು ಈಗ ಬರ್ದಿದ್ವಲ್ಲ ಇಲ್ಲೆಲ್ಲ 23 ವರ್ಷನ ಎಷ್ಟೆಲ್ಲ ಬರ್ಕೊಡ್ವಲ್ಲ. 23 ವರ್ಷ 28 ವರ್ಷ ಕೇಸ್ ಹಾಕ್ಲಿಲ್ಲ. ಅಲ್ಲಮ್ಮ, ಅಣ್ಣ ತಮ್ಮ ಅಕ್ಕ ತಂಗಿ ಎಷ್ಟು ವರ್ಷ ಬದುಕಿರ್ತೀರಾ ಎಲ್ಲರೂ? ಇಷ್ಟೆಲ್ಲ ನೋಡಿದ್ರು ಇನ್ನು ಏನೋ ಒಂದ್ ಮಾಡಿ ಸೆಟ್ಲ್ ಮಾಡ್ಕೋಬೇಕು ಇದನ್ನಂತ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ನೀವು ಎಲ್ಲಿವರೆಗೂ.
All the parts, the children are part of the fire and all. And they have come to something. And then we ate to the fire. And still, they have not come.
We understand.
You in the 100 in the you ಎಷ್ಟು
ನೋಡಿ 81 ಇಂದ 81
ಅಲ್ಲಮ್ಮ ಇದು ಎಲ್ಲರೂ ಇಬ್ರಿಗೂ ಒಬ್ರು ನವದಿದಲ್ಲಿ ಹಿರಿಯರು ಯಾರು ಇರ್ತಾರೆ. ಇವನ್ ಇದ್ರಲ್ಲಿ ಹೆಂಗಂದ್ರೆ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ನಲ್ಲಿ ಯಾರು ಒಪ್ಪೋದಿಲ್ವೋ ಅವ್ರನ್ನ ಬಿಟ್ಟು ಉಳಿದವ್ರು ಸೆಟ್ಲ್ ಆದ್ರೂ ಮಾಡ್ಕೊಬೇಕು. ನಿಮ್ ಲಾಯರ್ಸ್ ಇದಾರಲ್ಲಮ್ಮ ಹೇಳ್ತಾ ಇದಾರೆ. ಅಲ್ಲ ರೀ, ನಿಮ್ ಅಕ್ಕಂದ್ರಿಗೆ ಮದ್ವೆ ಮಾಡಿದ್ರೆ ನಿಮಗ್ ಮದ್ವೆ ಮಾಡಿರೋದಿಲ್ವಾ ನಿಮ್ ತಂದೆ? ಅದು ಒಂದು ಈಗ ಹೇಳಿ ಮತ್ತೆ ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಪ್ರವೋಕ್ ಮಾಡ್ತಾರೆ ಅವ್ರನ್ನ. ಯಾಕೆ ಅಕ್ಕಂದ್ರಿಗೆ ಮದ್ವೆ ಖರ್ಚು ಕೊಟ್ರೆ ಅವ್ರಿಗೆ ಆಸ್ತಿ ಕೊಡೋ ಆಗಿಲ್ಲ, ನಿಮ್ ಮದ್ವೆ ಮಾಡಿದ್ರೆ ನಿಮ್ಗೆ ಹೆಚ್ಚು ಆಸ್ತಿ ಕೊಡ್ಬೇಕು ಅಂತಾನ? ಆಯ್ತು, ಇದನ್ ಬರ್ಕೊ. both heard both side further. During the hearing, it is found that though the suit was filed by the daughter of Parvati Bai, claiming share in the property allotted to the branch of Parvati Bai and her plaintiff's father Daya Shankar, the properties allotted to the share of Saraswati Bai, the second wife, were also included in the plaint. Learned counsel, ನಾವೇ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಳ್ತೀವಿ ಅಂತ ಹೇಳ್ತೀವಿ ಅಷ್ಟೇ. ಏನ್ ಹೇಳಾರ ಅಥವಾ ನೀವೇ ಮಾಡ್ತೀರಾ? Under the circumstances, it would be appropriate. Appropriate ಅಂತ ಹೇಳು. It would be appropriate under the circumstances to avoid unnecessary complication. It would be appropriate to amend the plaint to exclude the properties fallen to the branch of Saraswati Bai. You are the appellant, no? ಯಾವ್ದು 6.1. Learned counsel for the appellant in RFA number 41 of 2011, who represent the plaintiff, shall amend the plaint, amend anta nave shall file necessary application to amend the plaint based on accordingly anta ಮಾಡಿದ್ವಿ. ಲಿಸ್ಟ್ ಆನ್ ನೋಡಿ, ಇದನ್ನ ಆ ರೀತಿ ಮಾಡ್ಕೊಂಡ್ರೆ ಕೇಸು ಬೇಗ ತೀರ್ಮಾನ ಆಗುತ್ತೆ. ಇಲ್ಲಾಂದ್ರೆ ನೀವು ಹೀಗೆ ಕೋರ್ಟಲ್ಲಿ ಇನ್ನೊಂದಿಷ್ಟು ವರ್ಷ ಓಡಾಡ್ಕೊಂಡಿರ್ಬೇಕಾಗತ್ತೆ ಅಲ್ಲ. ಮತ್ತೆ ನಾವ್ ಹೇಳಿದ್ವಲ್ಲ ಅವ್ರು ಇದು ಮಾಡೋದ್ ಬೇಡ. ಈಗ ಪಾರ್ವತಿ ಅದನ್ನ ಬೇರೆ ತೀರ್ಮಾನ ಮಾಡೋಣ, ಅದು ಭಾಗನೋ ಅಲ್ವೋ ಅಂತ.
ಅದನ್ನ ಬಿಟ್ಟು
ಸರಿ, ಅದನ್ನ ಬಿಟ್ಟು ಅಲ್ಲ ಯಾವತ್ತು ಹಾಕೋಣ, ನೀವು ಯಾವತ್ತು ಎಷ್ಟು ದಿವಸ ಮಾಡ್ತೀರಿ? ಅಷ್ಟೇ, 14. ಮತ್ತೇನು
ಅದನ್ನ ಯಾವ್ದಾದ್ರು ಕಾಮನ್ ಇರ್ತಲ್ಲ ಅದನ್ನ ಬಿಟ್ಟು ಬಾಕಿ
ಶೆಡ್ಯೂಲ್ ಇದೆಯಲ್ಲ ಅದು ಇರ್ಲಿ. That will decide on merits. But
ಬಾಕಿ ಯಾವುದು which are not in dispute, that 61 or so, ಅದನ್ನ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡು. So that becomes easier for the remaining problem.
ಯಪ್ಪು ಈ ಏನು ಕೂಡ ಏನು ಸೀರಿಯಲ್ ನಂಬರ್ ಆನಂದರಾಮ್ ರೆಡಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ರೆಡಿ ಅಂತ ಬಂದಿದ್ರು. ಯಾರು? ಅವರ ವೆಂಕಟೇಶ್ ರೆಡ್ಡಿ ವಕಾಲತ್ತೆ ಹಾಕಿಲ್ಲ ಅಂತ. He is not appearing in the connected. ಅಲ್ಲಿ ವಕಾಲತ್ not filed ಅಂತಾನೆ ಇದೆ. Cross objection without filing the ವಕಾಲತ್, how does he file a cross objection? ಆಗ್ತಾ ಇದಾರಲ್ಲ ಅವ್ರು ಯಾರು? ವೆಂಕಟೇಶ್ ರೆಡ್ಡಿ ಅಂದ್ರೆ ಅವರು ಯಾ ನಾಟ್ ಫೈಲ್ ವಕಾಲತ್ ಮಾಡಿದ್ದಾರೆ ಅವರು. ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. ಯಾ ಮ್ಯೂಟೆಡ್ ಯುವರ್ ಮೈಕ್. ಅವರಲ್ವಾ? ಮತ್ತೆ ಎಲ್ಲ ಯಾರೋ ಇದಾರೆ. ಏನ್ ಮಾಡೋದು ಈಗ? ಇಲ್ಲಾಂದ್ರೆ ಅವ್ರನ್ನ ನೋಟಿಸ್ ತಗೋಬೇಕಾಗತ್ತೆ. ಅದೇ ಪಿ ಪಿ ಹೆಗ್ಡೆ ಅವ್ರ ಜೊತೆ ಮತ್ತೆ ಯಾರ ಅಪಿಯರ್ ಆಗ್ತಿದ್ರು ಅದ್ರಲ್ಲಿ? ಅಲ್ಲ, ಯಾರು ಇನ್ನೊಬ್ರು ಕಾಲಕ್ಕೆ ಸೈನ್ ಮಾಡಿದವ್ರು ಇಲ್ವೇ ಇಲ್ವಾ? ಹಂಗಂದ್ರೆ ಪಿ ಪಿ ಹೆಗ್ಡೆ ಅವ್ರನ್ನ ಕರೆಸಿ ಒಂದ್ಸರಿ, ಕರೆಸಿ ಯಾರು ಅವ್ರ ಕೊಲೀಗ್ಸ್ ಹತ್ರ ಹಾಕಿಸ್ತಾರೆ ಕೇಳೋಣ. ಅವ್ರ ಕೊಲೀಗೇನ ಅಂಡರ್ಟೇಕ್ ಮಾಡಿದ್ದ ಇವರು? But they should have made some arrangement, alva? Your suit is decreed or dismissed? No, you are the defendants, defend. But they are the beneficiaries of the decree. Adjourned. Date no representation for the respondent. No representation for the respondent or respondents. List respondents list on
21st.
And his name is being shown in the cause list also. ಯಾವಾಗ ಅವ್ರು ಇದ್ರು ಅಂದ್ರೆ ನಮ್ಗೆ ಒಂದ್ಸರಿ ರಿಮೈಂಡ್ ಮಾಡಿ ಹೇಳ್ತೀವಿ. ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಈ ಕೇಸ್ ಇರೋ ದಿವಸನೇ ಅವ್ರದ್ದು ಇನ್ನೊಂದ್ ಯಾವ್ದಾರ ಕೇಸ್ ಇರುತ್ತಲ್ಲ ಅದನ್ನ ಲಿಸ್ಟ್ ಮಾಡಿಸಿ.
Number 11 attempts, number 12, Narayan Rao, Gopal Gowda exchange.
Yes, agent.
Number 13, Hare Krishna M. S. Timothy.
Yes, agent.
14,
My lord, 14, I appear for the respondent. My lord, the appellant is no more. I'll be filing a memo, my lord, in the registry tomorrow. It may kindly be taken, my lord, during next week, my lord.
Okay, no representation for the sole appellant idara?
No, sole appellant, my lord.
No representation for the appellant. Learned counsel for the response submits that appellant is no more, and he submits the memo to that effect to the registry. List after 1 week.
No, next week, some date may begin. 2014 matter. I have deposited my lord, all the money, my lord, before the trial court. Emergency. Next week,
He has
some
succeeded. Suit for specific performance is
specific
decreed.
performance. Yes, my lord.
List on 15.
Please, great.
Yes, sir. Yes, junior Gopal Swami ಕಾಯ್ತಾ ಇದ್ದಾರೆ. Serial number 18, first please, second list.
Morning.
ಯಾರೋ adjournment ಆಯ್ತು. ಇನ್ನು ಇದು ಇದ್ರಲ್ಲೇ ತಗೊಂಡಿದ್ರಲ್ಲ. Somebody had taken adjournment, they had not.
10:30 adjournment.
ಅದೇ 10:30ಗೆ ತಗೊಂಡಿದ್ರಲ್ಲ. Adjourned, date ಏನು ಕೊಟ್ಟಂಗಿಲ್ಲ.
Adjournment just.
I don't remember his name.
Bhargav.
Sorry, identity ಇದಲ್ಲ. Does when answering Mitra, ಏನು ಲಂಡನ್ ಸ್ಕೂಲ್ ಆಫ್ ಎಕನಾಮಿಕ್ಸ್?